Hey guys, welcome back. Okay, you guys, I've got some good news for you. This is the deal. So yesterday we watched, oh God, did I just mess this up? Okay, no, thank you. Yesterday we got into day 6 because we just were good on time, and we literally, like, I hate to use literally because literally always sounds so bad. It literally sounds terrible. Um, ugh, Facebook, hold on. I don't know what's going on with Facebook. Facebook isn't transmitting well. All right, so let me fix that. We'll bring you back, Facebook. Okay. You guys, welcome back. Welcome back. Okay, so we are into day 6. We started day 6 yesterday. If you were watching not with us, that's cool. Day 6 yesterday we broke at lunchtime. So what I'm saying is that we have about 3 hours, not including a couple of breaks. This particular sequence of witnesses, we are going to see, let me bring this up for you guys. This is interesting. Devyn is going to be in her police interrogation era. Okay. She is in, can you please have a seat and let's talk? So this is her this is kind of what we've been waiting for, but I'm going to just say it again. And this is probably the third day. I feel like they should have arrested this case like day 4, but I know they have a lot of witnesses, but I feel like that's just what I'm just feeling is like this should have been rested already, but I guess not. Anyway, there's going to be a series of witnesses. Look, a bunch. I wonder if Andrea's coming. Who's this lady in the red? Is that Andrea? Maybe, maybe not. Is this Andrea right here? Maybe some new people coming, okay? So hold on, and then we're going to see her interrogation. And then it's going to go to, let's see if I can see on Court TV if they listed the people who are coming. Let's see. And then we're going to go ahead and let it play. Okay, day 6 was Douglas, Douglas Linnell, Elizabeth Lemons. Was that day 6? Yeah, okay, so Carl Lipasich finished up the day. Then Douglas. I feel like Miriam came back, the crime scene investigator. Clark County. Ooh, okay. They're going to have Elizabeth from Clark County Family Services. They're going to have Nicholas Eason from Clark County. So a little CPS testimony is coming. All right. So CPS is coming to testify. Baby, it's a lot going on here. Another star-studded law enforcement day. So anyway, guys, let's just, without further ado, let's just go ahead and get into it. Happy Friday, guys. Back to the gutter, okay? Okay, you guys.
Please be seated, Your Honor. The jury call present and accounted. We are back on the record in C 3772396.
We are back on the record, y'all.
Attorneys on behalf of the state, you both parties, signature presence of our jury.
Yes, Your Honor. Yes, Your Honor.
Ladies and gentlemen, jury, I do apologize for the delay, but as I told you in the preliminary instructions, if we have to delay, it's only because we're trying to make things smoother for you guys on the back end. So I apologize you have to wait now, but hopefully that alleviates you having to wait on the back end. But if you guys are in any way frustrated about your wait times, please hold that against me and not against either of the parties. But I do apologize on behalf of the court for the delay in bringing you guys back from lunch. Mr. Horvath, are you prepared for your cross-examination?
Yes, Your Honor.
Okay, and Zach, can I just remind you that you are still under oath?
Yes, Your Honor.
Okay. Whenever you're ready.
Good afternoon, Detective Campbell. I'm going to start with just a few things that were touched on your direct from the state. This slide was brought up, and it sounded like, and we reviewed it, it was a report that you generated at the direction of the District Attorney's Office, correct?
Yes.
We'd referenced it, the defense had referenced it in their opening statement. It says that it was modified on 8/7, is that correct?
Yes.
I don't think the state was trying to mislead you, but what was testified to, what was brought up about this is that it was accessed or looked at that day. Is that what that time says?
Not necessarily. Accessed by the device, yes.
Okay. So it could have been accessed that morning and that time, correct?
Yes.
And that's what that shows.
Yes.
It wasn't made that day. It was just
No.
okay. Now, there's a few things I want to go to, and I know that we've talked about how we've stipulated and gone through a lot of these things, but one of the things that was brought up yesterday in the crime scene with Detective Ozawa was collection of evidence, and you were given a list of electronics to go through and examine, correct?
Yes.
Did you ever examine an Xbox,
No.
a Nintendo Switch?
No.
I'm pulling up, and I have a thumb drive here that the exhibits under have been stipulated to, so I don't know if I should be referring to this as what number or letter would this be?
It's your next in line?
Yes, we have a thumb drive. Instead of having all the exhibits for the jury to hold on time, I just put them all in one so they can access it.
Next one will be
B4. Thank you. So on B4, I have a bunch of, let me go back here a little bit. I've got a bunch of files that we're just going to go to, and these are things that have been provided to the defense, and our own experts looked at this. It's stuff that was on the phones. So right here, there's this is a text message chain with Devyn, and it looks like potentially some of his friends. I'm trying to make this a little bit bigger because I know it's a little bit smaller up there.
Thank you.
And the name of this chat, it says Legend of Dick Combat. This is something that you haven't seen, right? I mean, you saw it previously today, but this is not something you were asked to examine.
Correct.
This was on his phone between his friends talking about their gaming. Is that what it seems to be?
Yes.
So Devyn is known to be a gamer from the messages that we saw on the phone between him and Devyn. But you were never asked by Detective Ozawa or anyone to analyze an Xbox about anything.
No.
When you're going through the text messages of Devyn, I know that they said that they wanted you to look at Jonathan Willett, Devyn Willett, and Devin Michaels, but was there anyone else that you were asked to focus on?
No.
And just kind of along the same lines of the Xbox, do you recognize these at all?
Just from what I saw previously today.
And if I told you they were from Devin's cell phone showing Devyn playing Xbox and that he was a big gamer, would you have any reason to disagree with me?
No.
And there's even more messages that we got from Miss Michael's phone from the Celebrite extraction, talking about the video gaming. Because obviously it seems like he was a big gamer from reviewing all these messages, correct?
Yes.
Now, in going through the text messages, were you asked to look at the conversations between Devyn and Jonathan?
Yes.
And I apologize. I'm just going through the files that are on this thumb drive that's on B4. And I'll say the name of the file on this one. I apologize. It's Devyn and Jonathan Cordial Conversations PDF. So I'm actually going to go down a little bit here. It's kind of a long file. I think there's 200 and some pages on this extraction that was created. Now, who would this, from what you're seeing, who would this be to? Can you tell which parties are which?
Just by the phone number, a lot of times the names or whatever they put in the phone. But the 9242 phone number to someone else, I'm not sure.
Okay, and if I told you that these are messages between Devyn and Jonathan, do you have any reason to disagree with me?
No.
Just on this message from 8/2/2023. I'm doing good, trying to hustle up $50 someday or somehow today. I have Saturday for sure, but need gas. It's 2 trips to Las Vegas, to St. Rose. I also have turf next week. And then also I'm getting up early to get the girls used to getting up for school. You see that?
Yes.
And what was the date of that one?
August 2nd, 23 at 8:18 a.m.
On another one on August 2nd, I'm gonna have good things happen for me today. It's just early. And it looks like she responds, great things. Correct?
Yes.
And that's around the time, yeah, you said 10:03 in the morning.
Yep. Same day at 10:03. Yes.
I'm going to jump around a little bit because this will go back to the jury and they'll be able to see these conversations. So on 10/2, later on that day, that evening, it looks like a list on ribs, crab legs. It looks like maybe like a dinner list or food that they're getting.
Yes.
And then they ask what kind of drinks, and they're talking about getting Coca-Colas, what it looks like, some kind of sodas.
Sorry, sir, you just have to answer out loud.
Yes.
No kind of crazy fighting text from just your observation of these text messages, right?
Not in these that I've seen. No.
And this is the this is Devyn Michael or a Devyn medical activity file on the thumb drive. So if I zoom in on this, do you know which phone this came from?
I don't see it in here. It says it's an SD card backup. I believe that was from Devyn's phone.
Okay. And on this kind of, I zoomed in a little bit. I forget that those ones are a little, looks like a picture of Miss Michaels in the hospital.
Yes.
Looks like some medical records of her going to the hospital.
Yes.
Let me zoom out here a little bit. There's just a few more. And that's what that looks like. Those came from her phone, correct?
Yes.
Now I'm going between Devyn and Devyn. And who does this look like? I'm sorry, yeah, Devyn and Devyn. These messages were previously addressed by the state, but we put them in here for the jury to have easier access to them. But do you know what number that came from, that top one? Liar, cheater, liar, cheater?
It doesn't look like it shows here.
Let me go down a little bit and pull. So we get the extraction one. There you go. Does it say there?
Yes.
And that's Devyn's phone.
phone. Yes.
I'm sorry, counsel. Can we just clarify who sent it?
That was Devyn to Devyn. Now I'm clicking on Jonathan and Devyn text. This appears to be the extraction from Devyn, or the exchange between Jonathan and Devyn, correct?
Yes.
And it goes on for a while because this, I mean, it starts back on this extraction starts back on October of 2021, correct?
Yes.
And then it goes all the way down to looks like July 2nd of 2023.
Yeah.
And the last file on this is the messages between Jonathan and Yoko. Is that what those numbers look like up there in this exchange? I'm sorry, I know I'm kind of moving it fast.
Between Jonathan and who?
Yoko.
Yeah. I'm sorry. Yes.
And this goes all the way up to July of 29 of 2023.
Yes.
Is that correct?
Yes.
That last message. All right. Now, I'm not going to bore the jury with all the exhibits. Like I said, they'll have an opportunity to look back at them and we may touch on them later on. But what I'd like to do is, in your investigation, you weren't at the crime scene, were you?
I was.
Okay, and then was it you that takes inventory of what to grab, or does someone tell you?
That time someone told me.
Okay, that time meaning when you were out there or when they came to your office and said, hey, go through all of these?
Meaning since that time, we've gone to scenes to collect devices ourselves.
Okay.
And have input on what gets collected.
So when you show up to the scene, do you have an idea of what's going on, or do they just say some devices need to be looked at or collected and you're going to take them back and look at them?
So in this particular instance, I was called just to go and do a router interrogation. So I had no input or had no idea what other devices were there.
Were you given any details of the incident before arriving?
Yes.
On the router, that was a Cox panoramic router, correct? Sound about right?
Yes.
During that interrogation, you took photos of the device and you collected the router logs that were stored.
Yes.
And you took photos of that?
I don't recall if I took photos of the logs or if I just collected the logs themselves. But I took photos of the router.
You didn't, okay. And the evidence law or the logs, were those given to Detective Ozawa, or do you make the determination on what's important and give it to Detective Ozawa?
I don't recall if they were given to Detective Ozawa. Normally I would, yes, but I don't recall in this case if they were.
And if I told you, let me see here. In your report, in the 18-page report authored by Detective Ozawa, let's see here. I'll give you a page number here in a second. Attendance. Court's indulgence. I don't know if it's that number. I know you were kind of starts down there. I think it's just this word. So it says that you collected the data logs for Detective Ozawa, and that's what you did, correct?
Yes.
And did you discuss that with him, or the findings of those?
I don't recall for sure. I probably did.
I don't want you to guess, but you don't remember having any significant conversation with him.
I don't.
Fair to say that the router didn't have much on it for you to go back and tell Detective Ozawa.
That's correct.
Now, when we get into all the devices, there's 11 devices plus the router, so there was 12.
Yes.
I want to clear up a few things. You talked about the UFDR is the complete file or, download of a phone.
Yes.
Now, the UFDR, is that something that when you extract the phone, you get that and that's the whole thing? Or is that something you are focused in on?
No, the UFDR is like a full report of all the data from the phone.
Is a UFDR different from a UD or UFD?
I'm not sure.
The UFDR it's a reader, right? Like you put in it all and it spits out what you are kind of looking for, right? So if it's a certain phone, certain things, it's marked for you, correct?
What do you mean by marked?
When you put it in, when you track the phone and then you put it into the Celebrite, and then do you click on what you want, or is it just a whole thing and then you decide what to do?
There are different settings in the Celebrite software, but where you can, after it's processed everything in Physical Analyzer, you can create a UFDR report. You can change that by time frame if you want, or include just specific things.
And then was your UFDR, was it one that you had changed the settings on, or was it a full one?
It was a full one.
Okay. Now, when you go through your findings on these phones, you give it to Detective Ozawa to review.
Yes.
Is there any other follow-up of the phone? Or let me go back. You go through the phones, you tell Detective Ozawa, and that's it, right?
Normally, yes.
If in a complete investigation, wouldn't a detective like Detective Ozawa want to go further deep in it, or does he just trust what you have to say?
No, so typically we'll create that report of the entire of data from the phone.
Mhm.
We'll give that to the investigator, and the investigator will go through and look for the evidence that they need.
Do you know if Detective Ozawa went through this?
I don't know.
Course indulgence. In your report to Detective Ozawa, it states what you did, but I'm kind of hitting on this is that it's his job to follow up, and if there's anything more that he wants, he's got to. It's up to him, correct?
Yes.
Any more artifacts, meaning the things that potentially could be left out of a report, or if there's anything that he, goes through?
Yes.
And did he ever do that with any of the devices?
I don't know.
Do you remember going through the HP laptop?
Yes.
Anything of any evidentiary value on there?
No.
And so Detective Ozawa, when he went through his investigation, as far as you know, he just used your report to come to his conclusions or direct his investigation, correct?
Yes.
He never came back and asked for any kind of follow-up or anything more that he needed from you.
I don't remember. I know that we, to prepare for trial, I started assisting in going through the devices, and so, but I don't recall if back initially, if there was any, collaboration between him and I.
Court's indulgence. No further questions, Your Honor.
No, thank you, Judge.
They give you a have any questions on this video, okay? You would all like to ask, feel free to pick with your name and your doing. Sir, does the system collect deleted messages?
It can, yes.
Would examination of the home router show activity for the Nintendo Switch or the Xbox?
Most of the activity that on this router and specifically and on most routers is it just shows connected devices. The other logs are like system logs and that don't really give us much information.
You have no questions? Character information. Okay, seeing no further, sir, more excuse this time. Thank you. Further questions for this witness? Any further statement?
Nope. At Porcupine.
I never went to that residence.
No further questions.
Any further statement?
Nope, thank you.
Do ladies and gentlemen, do you have any further questions for this witness? Okay, seeing no further, sir, more excuse this time. Thank you very much for your testimony here today.
Thank you.
Can I take?
Yes.
Your Honor, just real, may I admit this?
Yes, Mr. Junior, you can go ahead and go outside.
Just leave the floor.
Yes, that's it. Okay, we're just gonna take like a quick minute, but we're not take another recess. I know you guys are gonna be up and down.
Your Honor, the state calls Nick Eason.
Step on up, raise your right hand, please, next for you. You solemnly swear or affirm the testimony you're about to give this action, shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Sir, if you please state your full name and spell it for the record.
Sure. My full name is Nicholas Anthony Eason. First name Nicholas. Anthony Anthony. Last name Eason Eason.
Who do you work for, sir?
I work for Clark County Family Services.
What is your position there?
I'm a family services supervisor.
Turning your attention to October 16th of 2022, did you come into contact with a family, that being Devyn Michaels and Jonathan Willette's family?
Yes.
And you became the primary on that case, correct?
Yes.
You made contact with Devyn Michaels during that case, correct?
Yes.
You met with the two daughters of those two individuals, correct?
Yes.
You met with Jonathan Willette multiple times, correct?
Yes.
And he was a pleasant person, correct?
Yes.
He was very polite.
Yes.
He seemed very appreciative of your work.
Yes.
Seemed very organic, your conversations with him.
Yes.
Not hateful toward Devyn in any way.
No.
And there were just relationship things between them that just didn't work, correct?
To my understanding, yes.
Now, as far as meeting with Devyn Michaels, what were briefly your observations of her when you met with her?
So when I met with Devyn, she presented as what I would describe as bizarre. Her affect and presentation to questions were inappropriate given the nature of the questions.
She shared with you that she had been married to Jonathan in 2012, correct?
Yes.
That they were married for 6 years.
Yes.
And that they had broken up 4 days after having Tamaya, one of their daughters.
Yes.
And that the two of them had an agreement to have another child, even though they weren't together, correct?
Yes.
And her and Jonathan, she explained they were not a real married couple, correct?
Yes.
For the record, you are using air quotes.
That is correct, Your Honor. Lived in different rooms.
Yes.
And they were ultimately separated in 2018, that being Jonathan and Devyn, correct?
Yes.
And this is everything she told you.
Yes.
And I think you briefly mentioned this, but she presented with an affect that was not consistent with the situation, correct?
Yes.
And there was a contentious custody agreement between Devyn Michaels and Jonathan Willette, correct?
Yes.
On October 25th of 2022, Devyn expressed that she was at the office to quote, and this is her own words, do whatever she needed to get her girls back home, end quote.
Yes.
Correct?
Yes.
And at that point, she showed desperation. Is that right?
Yes, I would agree.
The girls were then in Dad's physical custody, and the girls were released to him specifically on October 27th of 2022, correct?
Yes.
And you work with an individual, or at that time, an individual by the name of Yolanda Lizardo.
Mm-hmm. Yes.
And you are aware that she met, Ms. Lizardo met with the family on October 27th as well as October 28th of 2022.
Yes.
And your involvement with the case concluded on December 18th of 2022, correct?
Yes.
Pass the witness, Your Honor.
Well, yes, just I have a couple of very narrow questions for you.
Yes.
There had been a question concerning a contentious custody issue, correct?
Yes, sir.
That was specifically in October of 2022, correct?
I believe so. Yes.
So you were not involved following that concerning a reunification of the parties, were you?
I was not.
Thank you. No further questions.
Any following statement?
No, Your Honor.
Ladies and gentlemen of the jury, have any questions for this witness? Okay, seeing no response, sir, you are excused. Thank you very much for your testimony.
Thank you, Your Honor.
State, you may call your witness.
State's next witness is Yolanda Lizardo.
Yolanda? You can step on up to me and stand in the first one to swear you.
Hi.
You solemnly swear or affirm the testimony you're about to give in this action shall be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Yes. Now, if you please state your full name and then spell it for the record.
Yolanda Lizardo, Yolanda, last name Lizardo.
Ma'am, were you employed with the Department of Family Services back in 2022?
Yes,
At some point, did you become involved in a custody matter involving Tamaya and Janaea?
yes,
And those were two minor girls.
yes,
And the natural mother was Devyn Michaels.
yes,
The natural father was Jonathan Willett, correct?
yes,
On October 27th of 2022, physical custody of the girls was given to the natural father, Jonathan Willett, correct?
yes,
And there is something called a parent placement verification letter that was given out. Is that right?
yes,
At this time, I believe between stipulation of the parties, the state is now moving to admit states 14.
States 14 would be minute.
Permission to publish.
Yes.
Showing you, once I zoom out. States 14 there is that parent placement verification letter we just spoke about.
yes,
And the two minor children's names are there, Tamaya Baker and Janaea Willett, correct?
yes,
With, I assume, their birthdays, correct?
yes,
And then down below is your signature there.
yes,
And it states that they have been reunified with their natural father, Jonathan Willett, on October 27th, 2022.
yes,
Correct.
yes,
And that he resided at 2698 Paladura Drive in Henderson, Nevada, 89074.
correct.
And that's your signature at the bottom.
Yes, it is.
And you dated this October 27th of 2022, correct?
Yes,
Now, this was a contentious agreement between the mother and the father, correct?
yes,
The mother, Devyn, was not happy about it. Is that correct?
yes,
The father, Jonathan, was happy about getting the girls, correct?
yes,
Devyn was not involved in the custody agreement, correct?
yes,
And you yourself met with dad, Jonathan Willett, multiple times.
yes,
You were actually the individual that gave the two minor girls to the father, Jonathan, correct?
yes,
And you conducted follow-up at the father's home with the girls.
yes,
The girls appeared happy with dad during those follow-ups.
yes,
They were well taken care of.
yes,
All their needs were met.
yes,
Once they were placed with their father, Jonathan, you had no further involvement. Is that correct?
yes,
Pass the witness.
Cross.
Your involvement was just primarily limited to October of 2022, correct?
yes.
Nothing following that?
No.
No further questions?
Can you follow up, Tim?
No, Your Honor.
Do the ladies and gentlemen of the jury have any questions for this witness? Okay, seeing no response,
Hi.
maybe you're excused. Thank you very
Thank
much. for
you.
your testimony today. State your name, your next witness.
State's next witness is Elizabeth Lemons Woods.
You can step on up and remain standing, the clerk's going to swear you. You solemnly swear or affirm the testimony you're about to give in this action shall be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, I do.
Yes. Please state your full name and spell it for me.
Elizabeth Lemons Woods. Elizabeth is ELIZABETH. Lemons LEMONS and Woods WOODS.
Good afternoon, ma'am.
Good afternoon.
How are you employed?
With the Department of Family Services?
And you were employed in that capacity in 2023 as well, correct?
Yes.
Turning your attention then to August of 2023, did you become involved in a custody matter involving the two minor girls, Tamaya and Janaea, correct?
Yes.
And the natural mother was Devyn Michaels, correct?
Yes.
The natural father was Jonathan Willett, correct?
Yes.
You received information that the primary custody holder of the girls, the two daughters, was the father who was deceased, correct?
Yes.
And the mother had been arrested, correct?
Yes.
You were tasked with finding out where the two girls were and where they would be placed, correct?
Yes.
Now, turning your attention to August 16th, 2023, you went to the mother's home, Devyn Michaels, at Porcupine Rim address and removed the girls, correct?
Yes.
Then the next day on August 17th, 2023, you actually met with the mother, Devyn, who was at the Henderson Detention Center, correct?
Yes.
And the purpose of that conversation with Devyn was to notify Devyn that the girls had been removed, correct?
Yes.
You weren't expecting to really have a conversation beyond that, correct?
No, I wasn't.
But you had a conversation about the homicide, correct?
Yes.
Devyn told you during the conversation that she had to do it, correct?
Yes.
And she explained that she was married to Devyn when he came back from California in 2021, correct?
Yes.
She explained that their relationship didn't work out and they were just really good friends, correct?
Yes.
Devyn then said that Jonathan had wanted to move back in, right?
Yes.
He wanted something more, but she did not, correct?
Yes.
Devyn explained that she had agreed with Jonathan to move his belongings, correct?
Yes.
She explained her relationship with Jonathan was transactional, correct?
Yes.
And then elaborated that she would have sex with him and he would pay bills, correct?
Yes.
Devyn went on to explain to you that she was rubbing Jonathan's back and then cut herself off in the conversation, correct?
That's correct.
So the conversation stopped.
Yes.
But then, okay. I want to touch on just briefly, what were her emotions like throughout the discussion that you had with her? Was she having physical emotion? Did it seem forced? Anything of that nature?
From what I can recall, not much emotion at all.
She didn't cry at all?
I think she initially tried to, but I don't remember her actually crying.
But she initially tried to.
Yes.
Pass the witness.
You didn't know Devyn Michaels, did you?
No.
Never met with her before, correct?
No.
You meet her and she's been arrested, correct?
Yes.
People react to traumatic circumstances in different ways, don't they?
That's fair to say, yes.
What, we could approach this briefly.
What is she shaking her head at? Devyn looks like she has been through it, baby. Okay. Her body language is giving. She's big mad. She's mad because her weave looks better than hers.
Yes.
Now turning your attention, girls were correct.
Yes.
You were tasked with finding out where the two girls were and where they would be placed, correct?
Yes.
Now turning your attention to August 16th, 2023, you went to the mother's home, Devyn Michaels, at Porcupine Rim address and remove the girls, correct?
Yes.
Then the next day, on August 17th, 2023, you actually met with the mother, Devyn, who was at the Henderson Detention Center, correct?
Yes.
And the purpose of that conversation with Devyn was to notify Devyn that the girls had been removed, correct?
Yes.
You weren't expecting to really have a conversation beyond that, correct?
No, I wasn't.
But you had a conversation about the homicide, correct?
Yes.
Devyn told you during the conversation that she had to do it, correct?
Yes.
And she explained that she was married to Devyn when he came back from California in 2021, correct?
Yes.
She explained that their relationship didn't work out and they were just really good friends, correct?
Yes.
Devyn then said that Jonathan had wanted to move back in, right?
Yes.
He wanted something more, but she did not, correct?
Yes.
Devyn explained that she had agreed with Jonathan to move his belongings, correct?
Yes.
She explained her relationship with Jonathan was transactional, correct?
Yes.
And then elaborated that she would have sex with him and he would pay bills, correct?
Yes.
Devyn went on to explain to you that she was rubbing Jonathan's back and then cut herself off in the conversation, correct?
That's correct.
So the conversation stopped.
Yes.
But then, okay. I want to touch on just briefly, what were her emotions like throughout the discussion that you had with her? Was she having physical emotion? Did it seem forced? Anything of that nature?
From what I can recall, not much emotion at all.
She didn't cry at all?
I think she initially tried to, but I don't remember her actually crying.
Not that she tried to cry.
Yes.
Hmm.
Pass the witness.
You didn't know Devyn Michaels, did you?
No.
Never met with her before, correct?
No.
You meet her and she's been arrested, correct?
Yes.
People react to traumatic circumstances in different ways, don't they?
That's fair to say. Yes.
What, we could approach this briefly.
I didn't say that to you. Why would you? Why is she looking at her like that? Devyn, you're giving crazy eyes, girl. And then you're writing with your little, look at her little pencil.
Great question, ma'am. This conversation that you had, it was not recorded, was it?
That I'm not sure of.
Okay, you weren't recording it. You weren't collecting evidence, anything of that nature, correct?
I was not recording it, but I was getting information for my investigation.
Okay, and that involved the custody of the children, correct? The
Correct.
placement of the children.
Correct.
Thank you. I have no further questions.
Any problems, Dave?
No, not at this time.
Ladies and gentlemen, do you have any questions for this witness? Okay, seeing no response, ma'am, you're excused. Thank you very much for your testimony here today. State and call your next witness.
Douglas Lina.
You know who this lawyer reminds me of? The defense attorney. Anybody, any of my Breaking Bad folks, Better Call Saul, the guy, the blonde guy who owned the law firm where the wife worked. I forget her name and I forget his name. The guy who ended up dead at the end of this of Better Call Saul. The guy who was Better Call Saul's brother's partner, the partner of his brother, the blonde guy. He was kind of a douchebag. Any of my Better Call Saul people know what I'm talking about. But yeah, he kind of reminds me of him. Anyway, let's get into it because this is going to be Devyn's testimony. This is going to be Devyn's interrogation.
Swear affirm the testimony about giving this action shall be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Yes. Sir, please state your full name and spell it for the record.
Douglas, Douglas, Lionel, Lynaugh.
Thank you. Sir, what do you do for a living?
Excuse me. I'm a detective with the city of Henderson.
And which unit are you currently assigned to?
Robbery homicide.
How long have you been with robbery homicide?
About 6 years.
And how long have you been with the city of Henderson in total?
About 18 and a half years.
What did you do prior to joining robbery homicide?
Prior to robbery homicide, I was in the property unit. Prior to that was a criminal intelligence unit. Prior to that, problem solving unit. And then prior to that, patrol.
So kind of a wide range of experience in law enforcement, sir.
Yeah.
And as a robbery homicide detective, have you been the lead investigator on several cases and also support investigator on several cases?
Yes.
Your team also is responsible for investigating officer-involved shootings within your department.
Yes, that's accurate.
So you have kind of a wide range of duties as a detective.
Correct.
In this particular case, were you enlisted in the support role on August 7th, 2020?
I was.
Did you respond to the initial scene?
I did.
Did you do a little video canvassing at that scene?
Yes, I did. And then just some workup on the individuals involved.
Okay. And fair to say that Detective Ozawa kind of led the investigation, or he was the one divvying up duties?
Correct.
Did you become involved in an interview with a person by the name of Devyn Michaels on August 15th of 2023?
Yes, that's true.
And where did that occur, sir?
At the Henderson Police Station, the main station.
And on that date, had the defendant already been arrested prior to you making contact with her?
Yes.
Who did you make contact with her? Who were you with?
Another detective?
Yes.
Detective Rick Christopher.
And was that conducted in an interview room at the station?
It was actually done in a conference room in
Yes, Hamlin, the Hamlin guy. Yes.
the investigative bureau.
Was that both audio and video recorded?
It was.
Was the video recording the kind of the primary, and then the audio was a backup?
Correct.
And in fact, during the video portion, like over an hour in or around an hour in, the video loses storage space, correct?
Correct.
But you did have an audio backup running.
Yes.
Okay, so we might transition as we play,
Okay.
once we get to the end of the video. And Judge, I would move for the admission of wait, sorry, Mark. Sorry, it's on the envelope. I moved the admission of 621 and 621A.
Any objection to 621 and 621A?
Outside of what's on the address, no, Your Honor.
Okay, those will be admitted.
May I publish 621?
Yes.
Pause that. Detective, it looks like it's a little over an hour, about an hour and 15 minutes. Can you see the bottom right?
Yes. Sorry.
Okay. And so we're going to play this in its entirety, and then there is a small portion at the end where it's just audio, correct?
Correct.
We will transition at that time. This particular interview room, did it have a recorder set up in it already, or did you record this?
The video?
Yes.
No, it was just a video camera that we placed into the room.
Got it. Understood. May I judge?
Yes.
Just gonna sit ahead a little bit. Pause it here, 2 minutes and 9 seconds. What is this little thing right here?
That's an audio recorder.
That's your backup there?
Correct.
Yeah, so we're gonna take your handcuffs off and then we're gonna put those on. Okay, so it's a little longer. Okay? So just, maybe just step forward a little bit. Let's see, I know you want to in here, you want water or something. Yeah. Yeah, he's got one more with him. Good. Yeah, I see. Thanks. Hey, this is for a little bit. Alright. Ready? Was it good? Search for a minute. Just give a minute till first comes back and we'll talk, okay? Need water up there? Put them all in. Do you know what's going on, or do you understand what's going on? But you understand the severity of what's actually occurring.
Because I said I didn't murder Sean. I didn't say that.
It was just. It is August 15, 2023. It is 6:50. We met once before, obviously you don't remember, but you can't go out and so Christopher. Earlier today, you were advised what your rights are. I'm just going to advise you again, just so you fully understand that. All right. You do have the right to remain silent. If you give up that right, you continue to say and will be used against you in court of law. You have the right to speak to an attorney before answering any questions and have the attorney present while you answer any questions. If you cannot afford an attorney will be provided at no cost to you. If you decide to answer any questions now, you may stop at any time and ask to speak with the attorney before questioning continues. If you decide to stop answering questions once you have begun, all questioning will stop. You understand that? Okay. So, there's been, you've given a handful of different statements, a handful of different stories along the way, and that's just what we're trying to clear out. So, okay? You understand that? So do you want to start from on the 6th? You were hanging out with John and doing some shopping? Yes?
Yes.
Okay. Describe that day to me, you know, the cliff note version.
Simple day.
Okay.
Shopping, got girls some supplies. Shoes. That's it. It was a very easy, pleasant day for the most part.
Okay. And then at night, John was moving in with you.
John was moving the girls' stuff to my house. It wasn't until he had actually moved everything over until I realized he was moving some of his things over.
Okay.
I'm gonna pause there, 7 minutes, 18 seconds. And Your Honor, if I may inquire with the jury, if everyone can hear all the voices?
Can you guys hear the voice?
Okay. Detective, you had just asked about John and the moving situation, and is it true that the subject said that she had just learned that he was actually moving in, essentially?
Correct.
And you can see 3 people in the room. You are on the right.
Yes,
On the left is Detective Richard Christopher.
correct.
In the center is whom?
Devyn Michaels.
And do you see that person in court today?
I do.
Can you please point to that person, describe an article of clothing she's wearing today?
Black and white shirt.
Would the record reflect identification, Judge?
The record shows that.
Thank you. I will resume.
I've been telling me he was gonna move, but that happened months ago back and forth. I didn't actually move in there. I've been putting stock into it. So when he moved some of his things over, that's when I realized he's actually moving his things. Yes, I remember talking to John about it. Yes, I remember talking to other people about it. But until that moment, it really wasn't something that was gonna take place.
Okay.
Because at one point, a few times, he said he wasn't going to move. And it had happened more than one time, so I just took it as it was.
Okay. So you said earlier that you're shopping. You invited him over to drop off the last load of the night?
Yes.
Okay.
He assisted in his truck.
Okay. And you rode with him?
We both were involved.
Okay.
He wanted to take his truck because the trailer has his information on it, and said it's free advertising.
Oh, was the trailer loaded as well, or just the truck?
And at that time, the trailer was loaded later on that evening by John and John alone.
Okay. And did that make its way over to your house?
Yes. And that's when I found out what he had actually loaded up. It was like the girls' things up on bed, dressers and clothes. And it turned out to be a lot more than that.
Okay. How did you feel?
Jimmy Devyn's all right. There's more tools and Jimmy D's than anything. So it really wasn't too much to feel bad about. It was just a whole bunch of extra crap I had to.
Were you shocked or surprised that he was actually moving?
Yeah.
Okay. Was it somewhat confrontational or anything like that? Because now you're moving stuff that you didn't expect.
No, because like I said, it's tools, DVDs, and she got his guns over.
Okay.
That was really nice.
Okay. So after you knows what happens,
We went back to his house.
the both of you? Okay. About what time was that?
That night.
About 9? Okay, and then now you're going back to his house? Are the girls with you or are they at home? Okay, and what happens then?
We went to the gas station, had a couple of drinks. stuff, I think. Went back, she cooked, ate, took a shower. I let her have some more of the girls' small items
In what?
that I have in the car.
Your, that Nissan SUV? Okay.
I was at 8, I smoked, drank some more. So the vehicle. And it was after I left. Because I didn't leave for a while there, I didn't remember all of that. I don't really that much better, I'm going to the pharmacy,
After you left. Okay,
going home, showering, going to bed.
okay. So, you wanted some sort of sexual encounter with you?
That wasn't gonna happen to him. He was not dead.
Okay.
That's when the girl came down, I spoke with her. And like I said, afterwards I left.
Okay. Have you recently had a sexual intimate relationship with him?
Recently,
Well, in the past like month, obviously he's moving back in, you were speaking, have
he's
you?
asking for sexual favors, yes, but no, we have not had intercourse, no.
Okay. Well, because part of the reason we've been told otherwise by other people that he was telling other people that we do that. That's why we're trying to clarify some of this stuff.
No, we have not had intercourse.
Okay, and we've got other things like cunnilingus, any type of foreplay or anything like that.
The most he's had was a hand job.
You two moving in together, was there a expectation that you were gonna be in a relationship together? Or,
Certainly expected it, but he's quite aware that I'm not able to do anything. I was not trying to have sex with him.
okay, so he's asking for sex, you say no,
As usual.
okay, and then from there, what happens?
I gave him a back massage on his back.
I mean, it's obviously you're quite a bit smaller than he is, how do you pop his back?
He was laying on the ground and pushed it in, forward line, raised up, and supposed to hop.
Okay, so you're straddling his lower back area, something like that, or standing up, something?
Yes.
Okay, and you're just pushing his back, he was out, okay. And where was that, in the bedroom or the,
Floor of his, yes,
I'm sorry,
on the floor of his room.
before his room? Okay, and then from there, what happens?
He went to go smoke again. When he came back in, and was laying on his bed, and he had me rubbing his back. That's when I was rubbing his back. And that's when the yoga was coming down the stairs.
So you're rubbing, are you using anything, like,
How was he positioned on the bed when you're rubbing back?
Laying down and
But how, like, is he up next to the headboard, is he laying long ways, is he laying opposite of the headboard?
he's laying more towards the bottom of the bed.
Okay, so let's do this. Have you on the bed and show us, I need to see a figure, how he's laying on the bed from.
So that
where's the head of that?
Yeah. Okay, so I'm just gonna, for you, I'm just gonna say, that's the bed and this is the headboard, okay? So obviously, for headboard purposes, these would be pillows, this is where somebody would lay their head. So you drew a line across. Now, I want to put words in your mouth, so I want you to correct me if I say something that's wrong. He's lying across the bed, is that right? Okay, which side would be his head? this side, so closest to the edge of the bed, or lower left, laying on it, the left side.
There's like a wall and like a makeshift closet on the side, right?
So I'm just gonna circle for it. Is that right? So he was laying this way. Where exactly were you while you were getting into that room? So you were on the bed, between the headboard and him? So I'm gonna go on the X for you. Does that sound about fair? Were you on top of him, kind of sitting on his butt, or?
Pausing at 16:01. Can I approach? Showing you states 12, sir. Do you recognize that?
I do.
What does that appear to be?
The hand-drawn photo that was just depicted right there.
I move for admission of that.
Any objection to that?
No objection.
That would be an opinion.
So Detective, we just witnessed this, but I just want to clarify, as Detective Christopher was assisting, obviously Ms. Michaels was in handcuffs up front. He was kind of helping her
Correct.
and asking for her instruction on where everything went, right?
Yes.
And this up here being the headboard where the pillows are,
Correct.
what does the X represent?
Where she was sitting?
And then this at the bottom represents where John was, correct?
Correct. With the circle being his head.
With the circle being his head. Now, there is a folder sitting on the table as you're interviewing her, correct?
Yes.
That folder was closed.
Yes.
That contained a couple of the photos of John dead, missing his head in the bed.
Correct.
Those were not shown to her prior to this drawing, correct?
No, they were not.
They're shown later. We'll see that. And that
Yes.
will be the first time she will have seen those.
Correct.
Resuming.
Back running, or were you on the side? On the side, okay.
Any lotions or oils or anything like that? Okay, I mean, just for this instance, did you introduce lotions or oils or anything like that later on? Okay, so just, when we talk about this incident here, not the past or anything else like that, okay? So this is going on, now what happens?
He was rubbing on me and, like I said, locals coming down the stairs.
So in the house, there's stairs to go to the second floor, and then there's like the, we'll say kitchen bang. Okay, so that stairs into the, we'll call it makeshift John's bedroom, not those couple little stairs there, but the stairs upstairs down. Okay. And how do you know this? Do you hear when somebody walks up and down the stairs? Okay.
How do you know it's her, not the stepdaughter?
I did, he's just usually, when I've been at the yard, so we should call this.
Okay, and just to clarify, was he there?
Listens.
Was.
Have you ever lived in this house?
No, but
Okay. So John and Andrea have been together for 5-6 years or so. Have you been at this house during that time, before or after? Okay, so it's, how long has John lived at this house? I know his parents have been there a long time.
off and on for years.
Okay,
And I don't even live there. We separated and moved out.
okay, all right. So you're giving the massage, he's face down. You said he's rubbing on you?
Yes.
Okay, how's he doing that, like,
Yes.
Was it-
Trying to reach backwards.
Did he say anything to you?
No, just he said it looks good and he's happy.
Are you replying to any of that? Are you saying anything to him?
No, I'm just trying to get his back.
Okay.
I don't talk so much.
Does he, what does he wear at that time?
He had his boxer shorts on at that time.
What color were his boxer shorts?
He was black or darker color.
Darker color. Okay, so nothing else, it's just boxers. Okay. What's on the bed? Comforters or anything like that, you know?
Like just blankets.
Blankets, do you know what the blankets look like?
Just blankets.
White blankets? Okay. Is his head resting on the bed or is it off the bed? It's on the bed, okay. So it's, obviously, if he's talking and stuff like that, his face is in the bed, is that what you feel one way or another? Okay. He's rubbing on you, or is this making you upset or uncomfortable or something?
Visually to bother me,
Okay. What bothers you about it?
that he's still pursuing sex, you know, like, maybe just isn't gonna turn away or anything like that, so. trying to do something.
Well, that's you're still getting him that, correct?
Because I know he has some girls, and I don't can keep him happy to a point. And he can keep him away from me, but she has been before,
You love your girl, don't you?
very much so.
With all your heart.
Because I'm not her, so.
I didn't say that. I'm just asking that you love them with all your heart, that's not me to hurt.
Sorry.
Is that why you asked me back in to have, is it currently, or we'll say at this time, he had full custody?
No, we both had temporary joint custody. He filed to get sole custody and he never showed up, so his motion was denied.
I thought CPS revoked or took your parental rights away for that.
They did,
Okay, that's what I'm referring to.
and that case was closed, and we had temporary joint custody. And he was supposed to file custody and he never showed up.
When was that?
That was in April,
Okay,
so his motion was denied. He
okay,
was elected. Both had temporary joint custody. He had physical custody of the girls.
okay, so you got legal custody, legal joint. He had physical custody, what was his issue like?
Based on CPS, I was supposed to see the girls for supervised visits for therapy sessions only. And he never enrolled them, I enrolled them, and that was it. And he said, he didn't want to go to the courts anymore, we were going to be one happy family. And we were actually working towards it. We were not perfect, but we were getting along.
You kind of started a little bit while you were telling that story, what kind of brought that emotion out?
Because when it was all said and done, when he needed something, I was helping him. No matter how much he did something, I was helping him. And everything said, thank you for helping me, thank you for helping me. And it's like, I was literally trying my best to put it back together in my family.
Go back to your family or did your girls back?
Because my girls wanted everybody to belong. It was like,
Your girls,
this,
not what you wanted. Understandable. So you said the CPS case was closed out,
yes, sir, back in February,
back in February?
yes.
Okay, I'm just having a hard time with what it is. So you didn't want to be with John, but you wanted the family capacity to get your girls back.
I didn't want to be in a physical sexual relationship with John. Me hanging out with John was fine, we got along well enough for that. Like, we went on picnics together, we did all of the shopping together, we watched movies together, we got along just fine for that.
Okay. But you mentioned that he could keep your kids from you. How would he do that?
Because he had the physical custody of them. That's all. I had legal showing that he had the physical custody. So like on Father's Day, he got mad at everyone and said, "At this, go pack up the girl stuff, bring it back."
So it's like he had the upper hand,
So he's said yes,
right?
that's his.
He basically called the shots.
Sometimes yes,
How did you feel when it came to your daughters?
they let me go that, okay, don't piss him off.
So, made you feel like you had no power.
I just didn't argue with him.
Because you want to make it worse.
It wasn't a worse situation, I just didn't argue with him.
Well, you just didn't want him to keep your kids from you. Okay,
He wasn't keeping them from me, but he always kept trying to threaten that, like,
okay. So that was always an option you had.
he would threaten me, yeah, but it seemed like he wanted me to keep the girls because it made it easier for him to work. 'Cause I had him so he could work.
Okay, so you discussed with, we'll call him Deb, because of your current husband, he was moving out, or what was the,
When we first talked about it, he made it clear he did not want to be in the same bucket with the job.
okay,
Because nothing came to be, it wasn't really a conversation we had more than once. Like I said, John didn't actually take any actions towards it. So, yeah, John was kind of a bit prepared and said he would move out. But John hadn't not moved in, so it wasn't our conversation. I am not trying to make myself out to be anything other than what I am. Yes, I hate John.
let's talk about that. He's laying here, got a massage, he's rubbing on you. You said at some point you feel uncomfortable?
Yeah, he was starting to get on my nerves because he kept grabbing on me. I already said no, stop touching me.
Okay, then what happens?
I hit him, he stopped touching me.
What you did?
Some staff thing that was on the fireplace.
Okay, so the fire station is temporary.
Yes.
So he's laying on the bed, you get off the bed, walk over to the fireplace. What do you grab?
This staff,
Oh, I'm sorry.
I don't know what it's called.
Describe it.
It looks like a town.
A cannibal woman?
I don't know, it was square, it was, I can't remember. Shape, I don't know how to describe it.
Okay, so,
Hold on, so is it, and how long is it? Are we talking short,
Shorter than that.
shorter than that?
A little bit, of this one, at the inside of this.
a little bit easier.
Yeah, the
Okay,
inside.
how's it? Okay, so about,
Yes.
and same thickness throughout the length, is that correct?
Started just have a square, like a top and square, and bottom.
Okay, so a candle or something around the candle system, that,
Something that's wooden,
okay, and what color was it?
wooden color.
Like black, or was it like a dark brown, or black? That had black coating on it,
I would say real black color.
okay, and just out of the middle of the massage, you get up and you walk over to the fireplace, does he say anything? So there's the bed, did you say, hey, I'll be right back, don't move? You just got up and walked over,
I got up and I walked down.
Okay, and what happened after that?
Okay,
Where were you saying you were in?
I was seeing that.
In the same position? You got back in the same position, just for clarification purposes, back where you were originally given the back massage, between the headboard, correct? Which direction was the head facing? So facing away from you. Okay, where exactly did you hit? Okay, so if he's facing away from you, I don't know words you know, so if I say anything that's incorrect, please stop me, correct? Okay? So he's facing away from you, you say you hit him in the head. So if I'm facing away from you, did you hit him on the ear, or at the top, or on the front, or on the back?
I guess around the back of these, I guess.
Okay. Well, you can't guess, you were there. Right?
I'm just not positive for anyone actually struck it, so.
Okay, so the, okay, so that's fair enough, so it's, there's no nice number, correct? Is that correct?
Yes.
Okay. Is there light on by indication, so is there any ambient light whatsoever coming into the room, or is it just pitch dark?
It's hard.
It's dark, okay. So how do you know what you grab when you walk over to the fireplace?
I'm just going by whatever.
Okay, what was that? So you've been somewhere around a year or something like that, you moved, correct, that's safe to say? How many times did you hit him?
One.
Okay, how hard did you hit him?
I'm sure I didn't answer that.
Okay, so
As hard as you could, like,
did you use all of your hands?
Okay.
One hand, two hands, right hand, left hand,
Right.
your right hand, okay? Did you say anything before you hit him?
Stop.
Stop, why did you say stop?
Just kept touching me.
Okay,
what is these things?
Didn't say anything, he didn't stop moving. But he was still breathing.
okay, so you hit him, he's still breathing, but he completely stops moving,
His hands stopped moving, yes.
okay? Did he say anything else after that?
That's when I heard local and whatever.
Okay. And what did he say? Or excuse me, what did she say, or what did you say?
We were just talking about it, and she was asking me about, can you help Sean give me some money for the insurance? And he hasn't paid this, and
Okay, did she want to go talk to him? So how did you get her to go back upstairs?
I didn't give her all that, she walked upstairs.
Okay, so why did she come downstairs?
She went up to the kitchen, I didn't tell her to come downstairs, she came downstairs.
So why did you go and talk to him?
Because I heard her in the kitchen.
So you see her walk in and just have a conversation with her?
I didn't know
Okay, what happened after she went back upstairs?
that I finished. I got my stuff in the car and I left.
You put what's up in the car?
My bag.
Okay, where'd you have the bag?
The keys, my phone, and stuff.
You talking about the purse, or you know the purse?
It's like a backpack, yes. The purse.
Okay, the line. Okay. I've seen your house, things are decorated and stuff. I think if you walked over and grabbed a candlestick or something that resembles a candlestick, you would understand what that is. Right? So what did you actually grab?
I don't know what it was, that's, I said, that's what it seems like, I don't know what you call it, because it wasn't in my house.
Okay, so where did you do it?
It is on the bed on the floor. I don't know, I gotta have that.
Okay,
You didn't
well,
have
that
that.
matters, let's try again. Okay, this shit's about to get real, okay? I'm gonna explain something to you, there's about 40 years of law enforcement experience in this room right now, and that doesn't include you, does that make sense? Okay, don't play the, what's going on, okay? Okay, well, I'm just gonna be direct with you. All right, we're talking about your father's kid, or the father's, your children, is no longer here. And you were the last person that was with him. You were the last person that used force on him. Does that make sense? So the shit's getting real. I'm not trying to be disrespectful to you, but the games are over. And you should look at that picture, because that's the last position you saw him in. And that's the position we saw him in when we was at that house. Does that make sense? So cut the shit, and let's get down to the nitty-gritty and start answering some questions for us. Don't tell us the same bullshit that you felt Detective was out. You have the rest of your life ahead of you right now. You have a big decision to make right now. A huge decision that can ultimately affect your two little girls. The whole time that we've been sitting here having this conversation with you, you've had this defeated look. This can go one or two ways. When you write this report, we're going to say Devyn was non-remorseful, not even emotional.
Sir,
You don't have to call me sir, all right? We're beyond that, all right?
I don't know your name.
It's Rick Christopher, okay? My apologies, I assume that he introduced myself even though I wasn't in the room, all right? So as we move forward, my question to you before we even get into details is if there's no light in that room, you described something to me that you picked up. So there's only that was one thing, when you took it with you, or you hid it, you saw it in light. So somehow there came light, and you saw an object. Because we know it was not on the bed, and we know it was not on the floor. So that's the stuff that I'm talking about. Does that make sense? So where is it?
I didn't tell you nothing about that.
Okay, so where is it?
Where did you put it?
Where did you put it?
That you keep looking at this bed, like you're reliving this situation right here. This happens right here. You hear Yobo coming down the stairs. You don't want her coming in here. Because you just hit it in the head with this candlestick that you so said, right? That's not what I'm saying. This right here. You don't want her coming down, but you just hit him and knock him out. Because he's there.
Yes.
So you rush up to her kitchen. Yes?
Yeah, I would tell the doctor, yes.
Okay. And you say, oh, he's drunk, he's gonna sleep it off, or whatever, not to come down there. And then she goes upstairs. That's at 1 o'clock, right? You go back down there, you're there for an hour and 4 minutes. There's video and everything else from the neighborhood, everything around the room. We know exactly what time you left. We had tracks from your car going from the Boulder address to John's address, all the way back to your house and everything else. So we know exactly what time you left, what time you got home. So you're there for an hour and 4 minutes. You didn't just get out of there. They talk about the cleaning supplies, the ammonia and stuff like that, that you said that you saw them, or, oh, yeah, I just saw them.
Anything cleans less than shop.
Okay, who is that?
I don't know anything about cleans less than shop. She didn't ask me. I didn't really know that. And I just said that before.
Okay, so you saw the cleaning supplies.
Yes, there were some on the floor, by the bathroom, in the laundry area, yes.
Okay, so John's right here. You hit him. He lays there. You go out. Now we have an hour where you just don't remember what happened. What did you go back there and do?
She's cleaning up the dishes and things.
Cleaning up the dishes in his room.
That's what I was doing when I gave everything to go home, yes.
No, after you open.
No, I was just cleaning.
What were you cleaning?
The dishes and everything.
Stop. What side is it?
Just cleaning.
What were you cleaning?
I was literally just cleaning up the area. When I left, and I hit him, he was breathing. I didn't.
How do you know it's weird?
You're telling the person was breathing.
Okay,
Chest goes up and down.
okay, you said it was dark.
You can still know when someone's breathing.
In the dark.
It's not pitch dark, but yeah, it's not.
So you can't see a area on his head because it's so dark, but you can see his chest moving? You can't see what you grab off the shelf because it's so dark, and then you walk over, but then you can see him breathing?
Yeah, you can see some person breathing. Your eyes can't adjust.
Also, then your eyes should have adjusted before all of this, too.
I just don't know the exact spot.
Okay.
Asked me, and I said, I'm not.
So right hand or left hand you use?
Right, sir. Yes.
Right. Okay, well, I'm trying to verify, so I don't say that's wrong.
I already said I feel horrible about it, but I didn't write.
Why did you give it to the place? Pain on you?
She kept leaving me alone.
Okay, you got up and walked away, why did you get up and walk out? You could have left you on that way, right? Why do you say that? Okay,
You got up, walked over there, and walked back, and you never said anything, you know, where you attempted to get out of bed, right?
It wasn't that bad.
What was it like? What was it like? So, you mean to tell us, you hit him in the head, right here, where you're showing this, and he doesn't move from there.
Right, but I didn't take long, because I wanted to make sure he was breathing.
Okay, so you hang around for an hour and 4
Not an
minutes.
hour, I did not know I was there at all.
Okay, it doesn't matter if you know it or not, you were there. You were there for an hour and 4 minutes, hanging around with somebody you just hit in the head to make sure that they're doing okay. Do you recall any of those or anything?
No,
Do you go over physically question or check out or anything?
yes, I did touch him.
did he say anything to you?
No.
Why?
Because he was unconscious,
Did you ever send her medically?
to a breathing person.
Who was unconscious? From law enforcement to that. Don't look at my little stupid question, it's a valid question.
Did you roll him from his back to his roundabout? How did you check on her?
I just felt him, I felt he was breathing.
Okay.
But then I saw him, he was breathing, so I was like, okay, he's all right.
Okay, so you're hanging out in this room for an hour, or no, you are. Unless you're running around, go back and inside and outside, but that's what you're doing. Okay, so describe to me what you're doing during this time, and don't say clean.
I don't know, I just kept moving around. I just kept moving.
Just kept moving around.
Is it because you were a man?
So I guess
Understand? That was on you. Okay, why are you a man?
I was afraid that I actually just hurt him, maybe didn't want to get him like that.
Okay, let me ask you this, were you in a panic because you knew the person and he was in severe life-threatening
No, sir.
injuries?
No, sir. No.
Geez, please.
I wouldn't mind asking, because I've been doing this too long to understand what was going on.
So,
It's fine.
He didn't know him.
Okay, it's
He
fine.
that, and then he would be the nicest person in the world, and then try to do everything he could to help.
Okay, so you have some resentment towards him. I
Yes, but it wasn't for me, it was for my others.
there's gonna be some dislike towards that person. I understand that, that's reality, I get that. But for you not to go into detail on exactly what happened, other than the fact that you hit him, is not going to help you out. I'm telling you that.
I cannot remember.
You have amnesia. Do you take medication for memory loss?
Yes, I do.
Okay, what type of medication do you take?
I don't know the names of it, but I do take medication.
Who's your doctor that prescribes that?
History thing.
What history is?
I medical history, because I do take medication for seizures, headaches, memory loss, sights, all sorts of stuff.
Okay, so is there a possibility that you could have not been in your right frame of mind while you were there that night? Because of all the medications you were on? Okay, so when people are on medications that come home to their thinking, sometimes they do things that they don't believe that they're doing. Does that make sense?
Yes.
Okay. So now reading you, sounds like that could be a possibility, that night in question.
I just don't remember. They're telling me things that happened, like I don't remember doing that. You're saying I was there that long.
We know you were there. I was trying to explain to you that video surveillance of you eating.
But I remember talking to Yoko, getting my stuff, leaving, going to the pharmacy, and going home.
But Devyn, what you don't understand is this, you know you're under arrest, okay? There is gonna be a police report and it's gonna have the interviews that we have with you.
Do you think anybody believes that he was laying here, you hit him in the head, you don't know what you do for an hour and 4 minutes, you leave, he's found in the exact same spot, dead, then you're like, oh, I don't know.
No, but the hitting him didn't feel real, like I don't.
I understand, so you're not in the right frame of mind, maybe because your medications, that will make it feel like it's not real.
No, but I think like all of this feels like a nightmare, like a dream. Like I remember being with him and him us talking and everything like that, but the actual, it does not feel real. I don't feel I was there that long. I remember being there, Yoko, pharmacy, home. I thought I was home at like 2 something. You guys are saying it was,
2:42.
yeah, I promise you.
Okay, so what do you do that night? After you get home?
I got home, I got a shower, I went to bed.
No, you didn't. How long did you sleep for?
About 2 hours.
Because you get home at 2:42, you're texting John's phone saying, oh, I can't find this, or where's this? And then like, remember, we took her phone, we took his phone, so we did all these downloads. I read text messages between you, Dev, everyone else, things like that.
About 2 hours.
Okay, it was, if you got home and showered and then went to bed, then you about 1 hour. Then you would have been able to sleep and wake up and start looking. Is that? So it doesn't look like you slept at all that night.
I said about 2 hours, so I'm not super off, but you guys are telling me I'm there for a long time, and I know for a fact that's not what is.
Yes, that is exactly. You can say, I don't think I was there that long, and I don't remember.
I don't remember, and in my recollection, it was not like that. I remember talking to Yoko, giving her the keys, picking up my stuff, and walking out the door. I picked up one more thing and left. I do not remember any of this. They told me, they asked me, where's his head? And until then, I didn't know anything about that. They're like, well, didn't Debbie ever tell you? No, Debbie didn't tell me anything about that. Well, did he leave that night? No, I don't remember Debbie or leaving, but I don't remember anything. I just remember going home and everything. I don't remember the driving to the damn pharmacy. I just remember being at the pharmacy.
Okay, they told you he was decapitated.
They
He
told
had
me
his head cut off.
They told me that
And they said you did not even blink.
Because it doesn't sound believable. Who does that?
I don't know, you tell us. That's it, it's, this whole thing, remember, everything you're saying does not make sense. I was here, I did this. Do you think anybody's gonna believe I hit him in the head and I left? I took his, how did, when did you get it, when did he give you that wallet? Did you claim it was given to you earlier?
He said nothing to do with Social Security cards.
And when was that?
Around the time he was 18.
So that night,
Yes.
Okay, he has one key to the truck.
I didn't know that.
Okay, so why would he give you the one key to his truck when he's supposed to be over there in 2 hours? And his wallet. Yeah, because he's supposed to come over with you in order to take the kids to the.
In the morning.
So how was he supposed to get your house then? And
I don't think I was supposed to take them. I know I was supposed to take the social security card, but the other stuff, I don't think I was supposed to take.
why were they in your underwear or wrapped up in other bags?
Because when he gave them to me, I didn't realize what I was taking, and I just put them away and said, keep them safe.
That's not normal.
You just said, when he gave it to me, you're like, I don't think I was supposed to take these.
No, I said in hindsight. I literally said in hindsight, I don't think I was supposed to take those. The social security card he gave me, the other cards he gave me, you can see that on the surveillance camera, he hands me the card. But those ones, I don't think I was supposed to take them out of the house. I think I was just supposed to put them up, and then in the morning, he's supposed to go and get them. That's what I said. In hindsight, I don't think I was supposed to.
Well, why did you wrap them in bags if it wasn't tied in your dresser drawer?
I wrapped them up. I don't think I was supposed to bring those with me.
You're not answering my question. Why were they wrapped up in plastic bags and put in your underwear
I
drawer?
wrapped them up right then and there in front of them.
Why didn't you just put them on your dresser?
One tied, another tied, another tied. It wasn't like one of them tied. It was repeatedly wrapped over and over. This was a thoughtful process. Put it in there, tie it up, put it in another bag, tie it up.
Right, like I
Eight
said, I
times.
didn't realize what I had at the time, and he's saying keep them safe, so I'm wrapping everything up and I'm hiding it.
For what reason?
I don't know, he didn't say anything, he gave me this, he says keep it safe, it was the social security card.
The social security card was like backpack.
Right, I didn't even get a chance to put that away.
So you take that, put that in this not safe spot. The only thing that he asked you to keep safe, you keep in your backpack. But the stuff that you were not supposed to take, you wrapped up 8 times, 8 separate times in a bag, in bags, and then did that.
No, do you not understand?
No, I don't.
I got home, it was late. I showered, I went to bed. That was it. Then in the morning, I would have sorted through everything, I would have talked to John, and everything would have been figured out.
None of that makes sense. If you
None of
said,
it makes any sense to me at all.
okay, if you expect anybody else, the jury, a judge, or the general public, to believe anything what you're saying,
Because I don't understand any of it. You guys are asking me questions about really good.
What does that look like to you? You don't know?
This is John?
That's the position John was in when you guys saw him?
Yeah, but he had his boxers on.
Okay, now he's off some off.
I don't know, he had his boxers on, his boxers were black boxer briefs. He had boxer briefs on.
That's what I'm talking about, this shit's getting real. Keep looking at that. Take another look at this. This is reality we're talking about. Think long and hard about your decisions on how you go forward with explaining the bullshit that you're giving us right now. Nobody's gonna believe you.
I understand.
And tell us where the object is that you used to do this. Tell us where that.
Do this.
Who did?
I don't know.
Who did?
I don't know.
That's not good enough. You did that.
No, I didn't.
Yes, you did.
No, I didn't.
Then prove it.
How do I prove that?
Because you were the last person to see him alive. And you were the last person to visit him. You did that. That's reality. Look at that picture. He's gone.
this is the exact spot where you left it. What do you think, people are gonna see this, and what do you think they're gonna think of you? This has got to be eating you up. Holding this in is just got to be fucking eating you alive. You have to be going nuts.
For the sake of your daughters, tell us where the weapon is at so we can recover it, and there can be some closure for your two daughters when they grow up for the rest of their lives. You owe it to them. That is their father. You owe it to them. Stop. Don't even say it. Stop. It's not good enough. Tell me something that I can go research to know that you didn't do this. Give me some evidence that I can go follow up with so I can help you in front of a jury of 6 or 12. Look at the photo. Your children will never see them again. Ever. And that's a choice that you decided. You decided for them.
That's the exact spot where you said exact, right? You left it there, you hit it in the head, he's unconscious, not moving.
There wasn't this much blood. When I left, he wasn't bleeding like that.
No, this is because it empties out after you cut his head off.
I didn't cut his head off.
Look at it.
No, I didn't.
Okay. Explain how this happened.
I don't know. I can't cut a person's head off.
But you hit him with the stick. Is there a chance that that could have been a knife of some sort? Why? How do you know it's dark? Doesn't make sense, does it? There is no doubt in my mind that you did that. You owe it to your girls to have a closure. We want to know where the object is that you used to do this. Where is the object? Tell us where the object is at right now so we can start working closure for your daughters.
This is that. I do have to know. If you came here with me, I didn't. I don't know.
Do you expect anybody to believe that? Listen, just listen to that. Listen to exactly that, what you just said. I don't remember. I wasn't there that long. We can prove 100% you were there that long. You remember everything else. You remember going to the CVS, getting your daughter's prescription, getting home. Oh, I showered. I started looking for school supplies. I started doing all this. I remember everything except the hour and 4 minutes after I cracked him in the head. His cell phone is at his house. You leave, drive back to your house. His cell phone now gets back to your house and has blood on it. It was not left at your house. Conveniently.
No.
Yes, conveniently.
No.
There's no possible chance that you would forget hitting somebody, cutting their head off. Going to dispose of this.
Fathom doing that. Hitting a person is one thing,
Yeah, it is.
but to do this is something completely different.
Believe me, I know. That's why you're sitting here. You sat here this whole time and made these faces and stuff like that, not shed a single tear.
I've been crying all damn day.
Really?
Yes, I have.
Okay, because they said, when they showed you and told you that he was decapitated, you didn't even blink.
They didn't show me he was decapitated, they told me. And I don't know how to feel about this is disgusting. It is utterly disgusting, and you're telling me I did it. No, I didn't do this.
You did this. We're beyond that.
No.
Well, you can be in denial all you want. That's not gonna help you. You can deny it all you want. But we've been doing this too long to explain to you, we're giving you an opportunity to save face for you and the rest of your family. We're giving you that opportunity. But for you to sit here and deny that you did that, we're beyond that. We are so beyond that, there is no doubt in our mind that we can prove this in a court of law with a jury. You did this. However, you have an opportunity to save faith and have closure for your daughters to tell us where the weapon is. And don't sit here and say, I don't know. Where's the last place that you put it? Don't say, I don't know. Because just like Detective Flannel said, is you were very descriptive up to and very descriptive afterwards. However, there's that hour, that window that you were with him, which you said you were in a panic. No shit, you were in a panic. I would be in a panic too. You remember what you did, so tell us what you did. I know it's weighing on you. I can see it all over your face. You're gonna feel better once you get it off your chest. Nobody is here to pass judgment on you. Not a single person.
You heard the stop staring at that picture since we put it up.
Okay? And I know whoever you're praying to is telling you to do the right thing and tell us what we're asking. Tell us the answer to it. You're gonna feel better, I'm telling you right now. You're going to feel better. And you can start to have closure, and you can start moving on. Because that is the right thing to do. And you know it's the right thing to do. I know you know that. I know you're a good person.
There has to be a reason why it's happened. And if you could explain that, it'd be a lot better off for you.
Then look at me. I know you're a good person. And listen, look at me. I know we can't change this. I know we can't, nobody can. But you can do the right thing and close it the right way. You truly can. I know you can. You are a good person. Do the right thing.
Is this how you want your girls to remember you? Or do you want to have a reason, an explanation on why it happened? So why? Why did it have to happen like this? What led up to this? What caused you to do this? Is something that's playing in this room, or is this room past, or what? Why did this happen?
It's okay to cry. It's okay to show emotion. It's gonna be okay. It truly is. It's gonna be okay. Do the right thing. You're a good person, do the right thing. We're gonna get through this together. We're not against you by no means. We're gonna get through this together, but you have to help us. You have to help us allow you to help you. You're a good person, Devyn. I'm telling you, I know you are. You're not a monster. You're not a bad person. But you need to start doing the right thing right now. This is where you change things and make things right.
This had to have a reason. You don't want your girls to remember you as this.
Let's take the reason out of it, okay, for right now, okay? Where is the object? Just tell us where the object is, that's all we're asking. Right now, let's take small steps. Heather, please. I'm begging you. I'm trying to help you. I'm sincerely trying to help you. Don't go down that road. It's not fair to you or your kids. No, I understand, but you're not allowing us to go through this together. You put up this wall, and you're in denial. This is reality, as I said before. This is not going away. But you have an opportunity right now to make things right for yourself, to start moving in a right direction. You start to have an opportunity for closure for his parents, for your children. Understand what? Lord, this is simply amazing. In my 22-year career, this is amazing. You sit here and say that. Listen.
Maybe it's because I didn't get rid of it.
Are your fingerprints or DNA going to be on either one of those bottles?
I do not know.
Why not?
Let me guess, you don't remember.
That one, I don't think I knew.
Where did you move these from?
It was in the hallway, right?
This is the hallway right here.
Right, but it's like laying in the hallway and the thing.
That's what these are. They're laying in the hallway. Right there.
Like set it up. And it was completely full.
So these are tipped over, laying right where they're at. You walk over and set it up, and then leave, and not set that one.
Yeah, but that was like hours and earlier in the day.
What was hours earlier in the day?
Like, maybe 6, 7 in the evening, earlier in the day.
So these have been sitting there all day long.
No.
Yes, these are there the next one. You're just claiming that these are in the hallway in the way. They're in the same spot where you just said.
Right, but it was not like that. Well, I'm not sure where it is exactly.
Okay. So, you got this same bottle over at your house? No, you don't?
No.
What is this? So you don't even know what it is, you're saying no? Soft stroke? Soft stroke?
It looks like it says yes.
Yeah. So you said no? You don't have that at your house? Sit on top of your washing machine.
That is?
Yeah. Listen,
Wait, back up.
that's the one to you because it is, I don't know, it's no, listen, you can sit here and say, you think you're smarter than me.
No, I don't think I'm smarter than anybody, but I didn't do this.
Okay.
It's only because I have the same cleaning.
No, the cell phone that you take, you have to take the cell phone from his house back to your house after he's dead, is his foot on it. His wallet, his keys, things that you're not supposed to have wrapped up in a bag 8 times shoved in your underwear drawer. Number one, you're the last person to see him, you're the last person to physically assault him, hit him in the head. He's in the exact same spot. You remember everything from him handing you debit cards and EBT cards and which specific gas station and this and that, and go to CVS and get your daughter's this, and the school, and he's supposed to be here at 5 a.m. or whatever time to go do all this stuff with the taking to school and this and that. Did your girl go to school that day?
I tried to again.
Why not?
John wasn't there.
Because your kids aren't registered for school? Because your kids aren't registered for school?
I didn't have to register.
Why does he have to register?
We both have to register them.
No. No, both parents don't have to register. They generally don't go to school to drop the kids off at school on the very first day of school to register them.
Yes, John was supposed to.
Okay, so all of this stuff, and then you just, the only thing that you don't remember is the time that you were denying that you're at the house, where 100%, you were there for an hour and 4 minutes. Running around the room, that you can't explain.
I don't remember when I was there. I do not remember anything else.
Okay, that's all you. Good luck with that, because that is not gonna fly. But I think we're done.
Absolutely. And your girls are definitely very taken because you can't even have the audacity to give them closure. Shame on you. That's terrible.
Get out here, little jealousy of this!
Oh, so there's
I didn't do it!
there's some anger now, huh?
I told you from the beginning I didn't
Is
do
that
it!
how you feel against him?
No! That is not how I feel against him!
I think you're just upset that you got office and.
That is what.
No,
No.
personally, I think that, you weren't expecting him to move into your house so soon, so you had to go over to the house. And killed him at his mom's house, so you wouldn't be the suspect.
No.
No,
Honest to talk about moving to my house for months.
yeah, you were surprised he was actually about.
No, because it wasn't falling through. He just moved tools and DVDs and stuff. You guys weren't
You
there.
said you moved all of his stuff.
Tools and DVDs. I didn't say he moved all this stuff. I said he moved a whole bunch of crap.
You wanna get somebody to transport him, I know?
Let me see what else is right here.
Okay. Do you understand that it's does not sound even feasible? No, just answer my question. You explained everything except an hour and 4 minutes, then after you hit it in the head, that you don't remember.
Yes, because I had nothing to do with him.
That's not answering the question.
Yes, I said yes.
So if that's not feasible to you, how would it be to a jury or the general
I
public?
didn't say it wasn't feasible to me. I didn't.
Oh, it's feasible, you remember everything except the hour and 4 minutes after you hit something in the head. That's what you're saying?
I didn't show.
You think,
I didn't show off his head. So I can say it over and over again. And I would appreciate you to say it. I didn't say that from the beginning.
well, is you have to have something for the hour and 4 minutes where he was murdered, that you were in the house. That's it, but that's the only time you don't remember.
I didn't know I was there that long.
It doesn't matter if you don't.
But that's what I'm saying. I don't remember being there that long. I didn't know I left.
Okay, so is it possible you did it, you don't remember?
Yes, sir. It is very possible.
Okay, how? Have you had moments in the past where you
Yes.
done stuff where
Yes.
it's happened?
Yes, there's things in my past where I cannot remember. And yes, I have talked to my doctor about it. Yes, they're trying to figure out what's going on with me. Yes.
Okay, you don't have to tell me if you don't want to, but what is wrong with you that you say that?
I
you're trying to
don't
be
know.
diagnosed?
They're testing me now. I went yesterday. For whatever reason, my brain tingled and then I blacked out. And I literally have it on documentation from the doctor, and they're trying to figure out what's going on with me.
Okay, do you take Xanax or benzos or anything like that?
I have a whole bunch of pills,
Okay,
and I don't know what they are because they're about 20 different syllables, and I don't know that I didn't do this. I know I,
ever been diagnosed with mental illness or
no.
no?
They were just testing me for everything. I just did an MRI, an EEG. They were doing a whole bunch of other tests. But yes, I mean, the last thing that has happened to me, I remember, my brain starts tingling and then I would wake up. I don't remember doing any of this. I know I don't remember being there that damn long. I remember getting my daughter's medication, I remember being home, I don't remember even hitting him like that. I know he was pissing me off, so I hit him, but it wasn't anything where he was dead, he was breathing, he definitely had his head on him. You guys are trying to say I did all this stuff, I did not.
You don't remember, is what you're saying. You don't remember doing any of this. Okay, so that's it. There's a possibility that you don't remember because you're blacked out.
I'm not a stable person. You guys are telling me that I did all these things. I'm like,
The next day, when you woke up, or I don't think that you went to bed based on the activity and things like that. Because when we print out the phone, then everything comes out, it's like minute by minute, and everything else. The activity, it appears that you're pretty active the entire night. The next day, what did you do? Did you go to school first, or you went to the oncology? So you drove to the school?
Yes.
Did you go to the oncology appointment first, or the school first? Okay, and you got to the school?
Yes.
Who did you talk to at school?
School staff, the rest school. And they said I can register, I had to turn in some paperwork.
Okay.
So I went to my friend, asked the detective to call me. And I got in there, talked to him. She tried to get a good word, tried to get in.
So we're working on all of this stuff, obviously it's whatever, but video surveillance from the school, video surveillance from the oncology place, all of this stuff, we have tons and tons. You told us like, hey, we stopped here at this gas station. So we spend the time, we go out there.
Detective, is that when your video storage ran out?
It was.
All right, State, where you move on, you just say, I'm gonna take a brief recess.
Yes, ma'am.
And then the rest of this will take us through the rest of the day. During this recess, you must not discuss or communicate with anyone, including fellow jurors, in any way regarding this case or this case, either by voice, phone, email, text, internet, or other means of communication or social media. You must not read much listed news or media accounts or commentary about the case. You must not do any research, such as consulting dictionary, using the internet, or using reference materials. You must not make any investigation, investigate the case, recreate any aspect of the case, or in any other way investigate or learn about the case on your own. You must not form or express anything in regard to this case, so it's fine submitted to you. Ladies and gentlemen, 3:45, we'll be in recess at 1 o'clock. All rise for the jury.
All of this stuff, we have.
Please be seated, Your Honor. The jury's all present and accounted for. We are back on the record in C-37723, Mount County State Member of Devyn Michael, and the record that is Michael, the president of the lawyers that we just closed on behalf of the state. We notify people of the presence of our jury.
Yes, Your Honor.
Yes, Your Honor.
State, you may resume your question.
And Detective, you indicated you had the backup recorder going.
Correct.
I'm gonna just play the audio, hopefully around the same time where we just left off.
Yeah, you was long haul around pay the truck bill or something like that, or I think it was end of July.
No, I called and they have to arrange it from time
Obviously, he's got some money issues and not really contributing a lot, it seems like. I think what he really contributed was with the EBT card.
I apologize, Detective. I'm gonna have to back up a couple minutes there.
School staff at the school. And he said, can you register, I have to turn in some paperwork. So I'm going to my appointment, that's when the detective called me. We were down there, talking to him. And she checked me before, checked it in.
So we're working on all of this stuff, obviously it's whatever, but video surveillance from the school, video surveillance from the oncology place, all of this stuff, we have tons and tons. She told us like, hey, we stopped here at this gas station. So we spend the time, we go out there, we take video surveillance from that place. We get video surveillance from any place that you said that you were at or could have had, or any place that your phone or vehicle or anything like that, but you have. We have video surveillance from the entire neighborhood. Streets along the way, in and out, and everything else like that. Nothing says anybody else did it. And the difference is where we're at here is a lot of it looks like it's planned. There's cleaning supplies, there's this, it's the last, one of the last things supposed to be at home, the cameras are taken down. It looks very plain in the thought. Or is it something that happens and hey, I got angry, he was touching me this and that, whatever, I hit him, went too far and ended up with this. That's the difference. And you just say, well, I don't remember. So you and Dad, what?
That was very soft there. You're asking about the cameras, and she says he took the cameras down, meaning John?
Yeah, he took the cameras down, he did all that.
Conversations that he had about any of this stuff.
John chose his with his family and gone. Basically, I've been along with the girls.
You seem to be a very emotionally dependent person based on the conversations between you two. Would you characterize yourself like that, or is that, you don't feel like that? Because everything's very, it seems like there's an issue with the intimacy or something, and then I hate you about you're cheating on me, you're this, that, you won't have sex with me, and then like a day later, hey, grab me 2 beers and pay from the store. Okay, see you at home, when you come home, I hate you, liar, cheater. It's a very up and down.
Yeah.
I think on the 3rd you told me you wanted a divorce.
Yeah.
Or it's just fed up, or? That's it. I don't know what your financial situation is, but I'm assuming he pays some money.
that's why it wasn't really a big thing for John, okay?
But John doesn't really have money to pay, right?
He said he was gonna try to help.
I'm trying to, but obviously, like, you just had to help him out with some money with his mom, right?
So,
You and his mom didn't give him some money? Well, you told somebody, you and his mom helped him out pay the truck bill or something like that for, I think it was, August, end of July.
no, I called and, you know, they were anxious about it, but I didn't pay it. I'll go pay it.
Obviously, he's got some money issues and not really contributing a lot, it seems like. Seems like he really contributed was with the EBT card,
Yes.
but he can't really pay bills on the EBT card.
But she's willing to accept me.
I'm saying he moves in with you, not debt fees. Was he paying $1,100 a month?
Yes, the time there was, I was going to rent out my home. Something small. I really wasn't so much of a financial burden on myself. Because I realized it doesn't matter who it was. It just needed to be a little easier, whether it was John or heavier.
Was the heavier thing to like try to get back at John, or how did that come about?
It started out as games and just thought about my own thing, but
Did he have any sort of relationship with his dad towards the end? Did he ever go over to the house or anything like that? Well, just give me a psychiatrist or anything you're under current care? Or who was your doctor that is dealing with the lockouts?
I don't remember her name. Just kind of the doctor. Radiologist.
What do you know?
Is that person that I don't know her name.
She's that first med.
I just started talking to her, so
What was that?
2 months ago.
2 months ago?
Yes.
Oh, yeah, she had an appointment and stuff, or?
She's one that set up the neurology appointments and everything.
So was she like family care?
Yes.
What was his EEG?
His way to,
Raising?
Detective, well, I tried to stop it right at an hour, 20 minutes. Fair to say that there's about 3-4 minutes left, and it's just mainly medical stuff and nothing, no more real questioning related to what we've been discussing.
That's accurate.
Judge, I will pass the witness at this time.
Okay. Cross.
Yes, thank you. Detective, it was you and Detective, was it Christopher,
Correct.
that conducted this interview?
Yes.
Fair to say it was a fairly confrontational interview.
Fair to say yes.
I mean, you've got your partner in this interview saying you're not going to tell us the same bullshit that you told Ozella, correct?
Correct.
You've been trained in interview techniques, correct?
Yes.
You would agree with me that the primary starting point in the police academies is the read technique.
I don't know about the police academy, but I've heard of it.
You've heard of it. Is
Correct.
there another named technique that you were taught through the course of your training as a detective and a police officer?
Open-ended questions. I believe the read technique's more of a structured course technique where you rely on rapport more in the beginning.
You would agree with me that when you sat down and you began your interview, you were convinced that she had committed the crime.
Correct.
Your partner was convinced that she had committed the crime.
Correct.
You would agree with me through this process and up until this time that we heard this interview, which started, was it at 6:54 p.m.?
Yes.
You and everyone else involved basically reached the conclusion that she was the guilty party, correct?
Yes.
So you'd agree with me that you went in there not necessarily with a motive to find out information, but to get her to confess to the crime, correct?
We were trying to confront her on the evidence that we had that she was not admitting to.
I mean, there's relationships about her daughters, threats concerning her daughters, correct? You want to see your daughters, think questions along those lines, correct?
No.
We listened to them. It was brought up, her daughters, correct?
Her daughters, but we never threatened that she wanted to see her daughters.
That she needs to cooperate, that she needs to give up information, correct? And it's clear in the video, the daughters, the theme of the daughters was employed to try and get her to confess to a crime, correct?
To admit to the evidence that we were confronting her on.
Beginning of the interview, she's sitting there, she's already been cuffed, correct?
Correct. She was under arrest.
You had said at the very beginning of you, I know it's been a long day, correct?
Yes.
You had made reference to her with a defeated look, correct?
I believe that was Detective Christopher, but yes, that was brought up.
You were both in there, correct?
Yes.
There was reference made to her having been Mirandized earlier that day, correct?
Correct.
There was also reference made to where she had been told earlier that day that Jonathan had been decapitated, correct?
Correct.
She was being confronted with evidence that things that you knew in an attempt to get her to capitulate and to admit to having done something wrong. Fair to say?
Correct.
In fact, there's one point, it was early on in the interview, there's a talk about you and your partner's collective experience all the years. Do you recall that?
Yes, I do.
How many years was told to her?
I believe it was 40.
40. And then that's followed with this shit's gonna get real, correct?
Sounds right.
There was reference made to State's Exhibit 12, this photograph, correct?
Yes.
And it was at about 16, maybe 1601 on the interview, correct? That
photo?
Yes.
I won't dispute that.
State, will you agree? It's about 16 minutes. It states here, hand-drawn picture by Devyn Michaels, correct?
At the top of it?
Yes. If I may approach her, actually, may I publish this? Thank you. This has been admitted. Push this button. Okay. I'm gonna but that's states right here, hand-drawn picture by Devyn Michaels, correct?
Correct.
But we can see in the interview, she just draws one straight line, correct?
Yes.
The rest of these, the elements to this, the head, the bed, the pillows, the headboard, that's supplied after she's drawn a straight line, correct?
Yes.
So it wasn't a hand-drawn picture by Devyn Michaels. It was simply a line drawn by Devyn Michaels, correct?
Detective Christopher assisted her because she was obviously struggling in the handcuffs.
Well, you say he assisted her. He drew this whole thing, didn't he?
Yeah, based on what she said, yes.
And the video will speak for itself. She draws a line and then he fills in the rest of this, correct?
Correct.
Which is, he's obviously doing that in an attempt to make it match the photograph that's ultimately showed to her, correct?
No.
You'd agree with me that, well, and you're a police officer, but people get nervous when they speak to cops, correct?
Yes.
People get nervous when they get pulled over for a mere traffic ticket, correct?
Absolutely.
I mean, you'll agree with me that through your experience as a detective, sometimes people break down, correct?
Yes.
They may say things that they didn't necessarily do. Is that fair to say? And
Yes.
you know where I'm going with this, but isn't
Yep.
that right?
Yep.
She had been interviewed multiple times prior to your interview, correct?
Correct.
We've heard them. There's been multiple interviews, correct?
Yes.
There's been multiple denials presented to her in reference to having committed a crime, correct?
Yes.
But nonetheless, you and other members of law enforcement keep returning and speaking to her, correct?
Yes.
And that's done with the intent of eliciting some sort of a damaging admission. Fair to say?
It would. Yes.
A great deal of emphasis was placed upon the timing in that house, correct?
The hour, is that what you're referring to?
Yeah.
Yes.
You keep talking about an hour and 4 minutes.
Correct.
Over and over and over again, correct?
Yes.
We've heard testimony from a person that's Yoko, pretty into time, that she came down to clean about 1 a.m. All right?
Yes.
And she testified that she spoke to Devyn for about 15 minutes. All right?
Okay. I didn't know the length of time, but I knew that they met in the kitchen at 1 o'clock.
And we do have video evidence, and some issues been made about the completeness of it, but the video evidence, we have her leaving the house at 2:04. All right?
Yes.
So we're not really talking about an hour and 4 minutes. We're talking about 49 minutes, correct?
Okay.
Much less time, correct?
Not considerably, but yes, less.
She had told you that she was cleaning things up when Yoko was there, correct?
Dishes that she handed to Yoko.
And if I told you that we have testimony from Yoko, that there was dishes, alcohol bottles, things of that nature, you'd have no reason to disagree, correct?
Correct.
If we heard testimony from Yoko that that room, and it wasn't a door, it was a sheet, but was open and the light was on in there, would you have any reason to disagree with that?
With Yoko?
Yeah.
No, I would not.
It's clear, and we've heard a great deal of evidence over the last week and few days that a move was going on, correct?
Yes.
Fair to say that when one moves one's belongings from one home to another, it can be a bit chaotic.
Yes.
Things can get misplaced or perhaps taken from one house to another inadvertently.
Yes.
There has been testimony concerning Jonathan's wallet and that he had actually lost that wallet the previous day. You're aware of that?
No, I'm not.
That there's texts which are now into evidence, right, Mike? Yes. Where it's shown that Jonathan had lost his wallet the day before and he was communicating with Devyn.
I'm unaware, but I don't dispute that.
But a great deal of evidence was made concerning that wallet and Jonathan's belonging, and is some idea that somehow that was evidence of guilt or that she was trying to hide something, correct?
Yes.
Come to find out, Jonathan had a habit of losing things and drinking, and she had taken his things. She'd received them from Jonathan. Okay?
All right.
There's been evidence concerning the phone that was taken, Jonathan's phone. Okay?
Yes.
There was never a statement by her, I took his phone on purpose, correct?
No, I don't believe she ever said anything like that.
Fair to say that, she arrived home at 2:42?
That sounds right.
And I'm just talking about from the 6th to 7th right now, so I won't have to keep saying
Yes,
the date.
I
But
understood.
you agree with me, it's reasonable to believe that maybe someone may take someone's phone by accident. Fair to say?
Possibly.
Someone may take another's keys, either by accident or on purpose, if that person's been drinking. Reasonable?
It's happened before, I assume.
And if I were to tell you that there are a number of texts from Yoko, who was living with Jonathan up until the time of his move, and there was a lot of concerns that Yoko had about his drinking and driving, would you have any reason to disagree with me?
I have no knowledge of that, but I would not disagree.
You'd agree with me, it's gotta be a pretty stressful situation to be arrested for the murder of somebody.
Yes.
And she had been arrested and handcuffed prior to your interviewing her, correct?
Yes.
She had cooperated and given multiple statements to law enforcement, correct?
Yes.
You're aware of statements, and we've heard them concerning Jonathan, although she said he wasn't cut. She had said that he had said something about injuring his hand in reference to a white table. You're aware of that?
I don't believe I am.
White table was found at her place. They had moved it. Aware of that?
I don't believe I am.
Okay. You'd agree with me, people can injure themselves moving.
Yes.
Common sense.
Yes.
Every time law enforcement engaged her, it was with the purpose of trying to get something incriminating against her. And I keep stressing that because that's clearly what you were trying to do, correct?
What I was trying to do?
Yeah.
Correct.
And others with whom you were working.
Correct.
You'd asked her about what Jonathan was wearing when she left, correct?
Yes.
And she said he was wearing boxer shorts, boxers, correct?
She did.
She stayed consistent with that, correct?
Yes.
But you had a photo and it's been evidence that the boxer shorts were gone, correct?
Yes. That's what she honed in on the picture.
She noticed, yeah. He had boxer shorts on when I left, correct?
Yes.
There was a discussion concerning cleaning materials at Yoko's house. And we'll just refer to that, the Paladura house as Yoko's house, correct?
Yes.
You were aware, you've seen photos, or perhaps you were there. There was a lot of cleaning supplies in that house, wasn't there?
I was not there. I was not, never went into that house. I was on scene, but never went in. Cleaning supplies that I was aware of were the ones in the hallway there with the evidence photos.
Are you aware of a photo that's now in evidence at Yoko's bathroom where it's lined with cleaning supplies?
I don't believe I am.
Okay. There was cleaning supplies in the hallway, correct?
What I just referenced, yes.
Yeah, yeah. And in the bathroom, I mean, there's a lot of cleaning supplies in that house, correct?
I would not disagree. I wasn't in there though.
Fair to say that she has been interviewed over and over again, and her statements, protestations of not having done anything to Jonathan weren't getting her anywhere. Fair to say?
What do you ask?
That through her various interviews and her, I said protestations, her saying over and over again she didn't do this, wasn't getting her anywhere, correct?
Correct.
She gets arrested, her daughters are brought up, she's threatened with nobody's going to believe with what she's going to say, and then she tells you about hitting him in the head, correct?
Correct.
And that's it, correct? In your interview, I mean, she talks about hitting him in the head with something
yes.
near the bed.
She hits him, and there's points where she says that she doesn't remember.
Yeah.
It's possible, but she just doesn't remember.
Okay, and we'll get to that. But you'd agree with me that hitting somebody in the head, assuming that happened, is different than killing them and decapitating them.
Yes, absolutely.
She actually points out that hitting him in the head with something is a completely different matter or something to
Yes.
those, correct?
Yes.
An object that Jonathan may or may have been hit in the head with was not recovered, correct?
Yes, that's accurate.
There were no power tools, specifically a mechanical powered saw that was recovered, correct?
Not that I'm aware of, but I'm wrong. But
Or any instruments that may have been used to sever the head.
not that I'm aware of. But I wasn't informed of that.
You'll agree with me that there's a lot of pressure, societal pressure to solve a crime, especially a heinous crime, fair to say?
Absolutely.
I mean, this was obviously number one on the list of priorities on the cases that you were working on. Find the murderer in this case, fair to say?
Correct.
Get closure for this case, correct?
Yes.
You'll agree with me when there's this kind of pressure, shortcuts may be taken.
I wouldn't say that.
It's easier to focus on one defendant, one object. Hey, we do know that she was there versus someone else. Fair to say, it's the shortest distance between 2 points.
Are you asking why she became a suspect?
Hey, she was the easiest person. She was there that night. Fair to say?
That among other things, but yes.
Yeah. She had said repeatedly that they were together that night. We know she was, correct?
Yes.
In fact, they had been together late the night before. You're aware of that?
Yes.
She was consistent and remained consistent through the course of your interview that John was alive when she left.
He was breathing, which you would say yes.
She never told you in that interview that she took his head, did she?
She did not tell us that.
Is this the first case that you've been involved with concerning the decapitation?
Yes. I can't think of another one.
Yeah, it's a fair rare occasion. I mean, it doesn't
Yes.
happen, at least here in this country, correct?
Correct.
Let me ask you this, and this is an aside, but I believe you may be the last detective we have an opportunity to speak concerning. I mean, was luminol used, in this? Was anything checked? I mean, there's been talk about times, things like that.
I can't testify to that. I don't know. I wasn't aware.
Okay. So based upon your interview with her, she hits him in the head, and now we know it's about 49 minutes she leaves, correct?
She's in the house for at least till 2:04.
Okay. That'd be a lot of time to actually decapitate somebody, clean it all up, and get rid of all the evidence, correct?
Be considerable amount of time.
It's a pretty tight timeline to get rid of. I mean, obviously, we've heard testimony that, if you decapitate a person, it creates a mess. We've seen photographs that there was a fair amount of blood, correct?
Yes.
She told you that she didn't take anything out of that house, correct? And it was in reference to a weapon or a head correct?
Yes, I would say that's what she's referencing because she was moving some of her daughter's belongings.
Yeah. She had told you that she was moving things around, correct? I mean, we know that she was moving, and that's consistent with what she told you. Is that right?
Yes, and she brought some of her daughter's belongings to her vehicle.
Yeah, so they're in the process of a move, correct?
Yeah.
She tells you that she leaves and then goes to a drugstore, correct?
CVS, yes.
And we've seen the video of that. Obviously, you've reviewed that.
Correct.
She's wearing white shirt, correct? Rolls in and gets a prescription for her daughter, correct?
I don't recall the color of the shirt, but I would say, yeah.
Yeah, and that's right after this decapitation is alleged to have occurred and that she's been supposedly cleaning this up, correct?
Correct.
And then she goes home. 2:42, I believe you said the time was.
She arrives home, yes.
That's consistent with what she had told you, correct?
Yes.
And your understanding. There was talk concerning her going to the school the next morning, and you're aware of, she did go to school the next morning and try and enroll her daughters. You aware of that?
I believe that's yes.
We do know that she went to a gas station, Funnies, correct?
The next day?
Yeah.
I'm not aware of that.
There is minimization that you and your partner, and I'm just going to kind of refer to you as one because we saw both of you sitting there. It was the two of you basically with her on the other side, correct?
Correct.
You're both large men. I mean, I'm pointing out the obvious, but I mean, you're in shape. You're a big guy, correct?
I would say average, but okay.
I'm going to disagree with you, but so is your partner. He's a pretty beefy guy too, isn't he?
Okay.
I mean, we can see it. It can be intimidating, correct?
We did consider that. Like I said, this wasn't an interview room. It was a conference room. It's a larger room. Typically, when we do interviews, we sit next to and across from. We had her seated at the head of the table, and we sat back a little bit.
She's handcuffed.
Correct.
That kind of changes the dynamic a little bit, the power dynamic, doesn't it?
Well, she's under arrest, yes.
Yeah. And she was placed under arrest prior to your interviewing her.
Yes.
She's told at the very beginning of this interview that she's going to fess up. She's going to help you. It's going to help her to give you information, correct? And that precedes her talking about hitting him in the head, correct?
I don't think exactly that, but I would say that works, yeah.
And then the jury has this video. I mean, the video speaks for itself.
Yes.
It's after this that then this idea about her hitting him in the head with something comes about, correct?
I don't recall the exact timeline, but it's obvious we've seen it.
Yeah. And through the course of this interview, nothing more than that, correct? Correct? I mean,
nothing more than what?
Than that. She hit him in the head with something he left and he was breathing, correct?
She at the end, she said that she waited around to make sure he was breathing. But yes.
Yeah. Yeah. He was alive.
Yes.
You are aware of the phenomena of false confessions, correct?
I've heard of it.
They happen, don't they?
Yes.
You're aware of case studies by social scientists where people actually admit, and usually it's murder, to something having committed a crime they didn't in fact commit, correct?
Yes.
We have the Central Park Five, and we have other, in fact, the Innocence Project. A third of those guys admitted, if he knows.
This is testimony. He's not an expert, and I would refute any alleged science behind that.
There's a lot of it.
Mr. Justice, he's not here to testify as an expert. You can talk to him about what
Yes.
he did, but we're not getting into things that are not an issue.
Let me ask you this. Have you received training concerning false confessions and the dynamic where they occur?
I don't believe so.
But you'll agree with me that they do occur.
Yes.
One more question on this subject. They tend to occur more concerning murder cases than others.
I wouldn't know that.
Okay. It's only after that you and your partner are basically swearing at her, telling her the shit's going to get real, saying, about the kids and John, that then she kind of has this where she doesn't quite remember, correct? It's fair to say. And that's a fair summary of what occurred during this interview.
No, I believe initially she was saying that she just left. She just left. And then we confronted her on the evidence that she was there. And then she says, I don't remember.
Okay, but she's there, says she left, she's confronted, she's under arrest, she's handcuffed. And then we kind of get this story about maybe she hit him in the head with something. Fair to say?
Sorry, what was that timeline again?
Yeah. The video starts, she's handcuffed, she's
Yes.
under arrest. Okay.
Correct.
Where we hear that she's been Mirandized previously that day. Okay.
Yes.
Her first story is that, she says that she just left. And then when that doesn't help you to get her to admit to something, it gets confrontational. Fair?
That's when we tell her that, hey, we have evidence that you were there. You didn't just leave.
Okay. And then after this confrontation, and the evidence will speak for itself, then this idea that well, maybe she did something, correct? Maybe she hit him in the head, correct?
Correct.
And then there's more that goes on, and we see it. Your partner's getting, passionate, correct?
Yes.
But she never says, and it's after that, then she's like, well, maybe I have a memory issue, correct?
She tells us that she's taking medication for memory
Yeah.
loss.
And if I told you that she does take medication for that, would you have any reason to disagree with me? She has a medical history.
I don't.
So it's in response to this confrontation that she's saying, well, I don't know. There's parts of that night maybe I don't remember, correct?
Yes.
And that's in response to the confrontational position that you and your partner, the two of you, are taking against her, correct?
I think that's more us presenting the evidence that she's there.
So it
And
wasn't
she doesn't have a
confrontational, your voices weren't raised, you're yelling.
I don't think it was that confrontational.
To you, maybe. Okay, you've got a 230-pound woman that's handcuffed with you, correct?
Yes.
And then it's after that, then we see that there's, well, maybe I don't remember something, correct?
Correct.
But then later, she actually gets passionate with you and says, I did not do this, correct?
Yes.
And she consistently denies having killed Jonathan, correct?
Correct.
She consistently, and she even looks at the photo through this and she's like, I didn't do that, correct?
At one point, yes.
There's discussions to do what's going to happen after she's not going to be able to go home and things like that. And that was the last part of this interview, correct?
No, I don't.
And I'm not trying to confuse. I'm not trying.
Yeah.
We heard, and we heard that the tape or the video, the capacity was full, so we lost the video towards the last part of this, correct?
Yes.
And the rest of this interview is captured on the little handheld recording device, correct?
Correct.
She's done, correct? She's being taken away. It's done, correct?
Yeah. Well, prior to even when the audio or the video was going, Detective Christopher steps out to get a patrol officer to transport her, and then I just sit there until the patrol officer shows up. But we have a conversation. Yes.
Okay. I can have the court's indulgence there. It's fair to say, for all intents and purposes, then this case is done and we're here now for trial, correct?
For my part.
Yeah.
I did not the end of it, but that was the end of it.
That was your part.
Correct.
Thank you. I have no further questions.
Just real quickly, Detective, the point of talking to a person multiple times, it's different in different types of cases. Would you agree with me?
Absolutely.
And here we have a very glaring piece of evidence that's missing, correct?
Yes.
And John had children, 3 of them, right?
Yes, he did.
He had 2 little girls
And the son.
and parents, and who probably want to put on a funeral for him.
Yes.
Was one of your main objectives in this interview attempting to find out what she did with the head?
It was obviously we always try to give the family some closure or whatever, but obviously finding a severed head would obviously help the family, I believe, with, some closure.
I'll pass.
No, thank you.
Do the ladies and gentlemen of the jury have any questions for this witness? Okay, seeing no response, sir, to our excuse, thank you very much for your testimony here today.
Thank you.
State, can you go ahead with us?
At this time, the state would rest its case.
Okay. All right, ladies and gentlemen, at this point, the state has arrested their case. We are going to take our night recess at this point. During this recess, you must not discuss or communicate with anyone, including fellow jurors, or anybody regarding this case or its merits, either by voice, phone, email, text, internet, or other means of communication or social media. You must not read, watch, or listen to any news or media accounts or commentary about this case. You must not do any research, such as consulting dictionaries, using the internet, or using.
Okay, you guys, the prosecution rested yesterday. We're going to find out. We're going to find out. Is Devyn going to testify? Oh my God. Is she going to testify? Does she need to testify? Is it going to make matters worse? Is it going to help the situation or hurt the situation? If it's going to hurt, she may as well stand down. If it's not going to help, we already know the answer. If it's going to help, which I don't think it is, you know, I see her lawyer's doing his job and everything, but I don't know if it can help. Sis seems to be in trouble. I don't know. Anyway, guys, we're done with day 6. We're going into day 7. It's 2:00. I don't even know if court started yet for today. Yeah, I don't. Let me see. Has court started today? Okay, so I guess she's putting on some. Let's see, what time is it? Where are we for time? We're at 3 hours. I wonder how many witnesses they say that they're gonna have. Let's see. Okay, do you guys want to get into some day 7? Let's see. We're going to get into a little bit of day 7, see how it goes. Let's see. We are in the present day. They started court. Did they start 2 hours ago? How'd they start 2 hours ago when they were supposed to be starting? Well, I don't believe that. Maybe they did. I thought court was starting. Maybe they started earlier today. Okay, well.
Yes, Your Honor.
All right. The state rested their case yesterday. Since you have any witnesses you intend to call?
Yes, Your Honor. We're going to call Sean O'Brien.
I do. Sure. Sean O'Brien, SeanObrien.
Good morning, Miss. I'm sorry. Good morning, Mr. O'Brien. How are you doing?
Pretty good.
How are you employed?
So I'm employed with Roll-Off Digital Forensics.
Okay, and what's your position there?
I am a digital forensic examiner.
Okay, can you give us a description of that job? What are your duties? What do you look at? What do you do?
Sure. As a forensic examiner, I look at any type of digital devices, digital artifacts, just pretty much anything that you can connect to the internet or even standalone, not connect to the internet, but it's digital in nature.
And about how long have you worked in this field?
Over 20 years.
Okay, you want to tell us about that, previous job assignments? Give us a little bit about yourself.
Sure. So I started off, I got a little intro to it whenever I was active duty in the Army. Got out of the Army, got recalled after 9/11. From there, moved on to the Air Force Office of Special Investigations Laboratory in Lithicum, Maryland. That's where I began my forensic journey, starting at the ground up from the basic taking a device and capturing it, as you saw earlier. From there, I got lots of training. I'm a Department of Defense certified forensic examiner. I also hold certifications with Cellbrite and Magnet and various other certifications related to the field. I worked there for about 9.5 years. I started off, like I said, it's technically called the imaging and extraction section. From there, I moved on to becoming a full-fledged examiner. And in that role, I was part of a child exploitation division that combated child exploitation and just all the different digital devices associated with that. From there, I went to the counterintelligence, counterespionage section and worked there as the deputy section chief. So I had a team of people under me that I mentored and taught how to do more advanced digital forensics. From that point, I went on like a little teaching circuit around the world to teach more stuff on like sexual exploitation type material. And then after that, I spent a little bit more time there at, it was called DCFL at the time. And then I switched over to Navy NCIS. I was offered a position to go start up a digital forensic lab or restart a digital forensic lab in Naples, Italy. I was the sole digital forensic expert for Europe and Africa and backup for the Middle East. I covered all those countries. As part of that duty, I also worked in hand and on location with essentially like the special forces of the military police for Italy and worked in a lot of like terrorism cases and stuff like that with them. I also worked with NATO, establishing the baseline digital forensics standard operating procedures so that everybody in NATO would have a baseline, because you have a lot of different economics, like there's very wealthy countries in Europe and there's not so wealthy countries in Europe. So trying to teach them how to do forensics with the bare minimum, because a lot of the tools are extremely expensive, and just teaching them how to balance the cost versus that. I spent 8.5 years doing that. I had to return to America, and I started working for the Veterans Affairs in the Office of Inspectors General. I ran the e-discovery division. It's essentially, it's not forensics, but it is in a related field. And I managed a team of people that would pull emails and do examinations and help agents and other requesting officers or parties to do audits and things like that. From there, I left and came over to Roll-Off Digital Forensics, and here I am today.
All right, so now you work for your forensic company. What are some of the programs or software that you use in your role at your current job?
So my primary tools are some of the ones that you've seen here. Cellbrite and Magnet are probably the top two that I use.
All right, and then what about any certifications on those programs? Any training on those programs specifically?
I'm certified with both Magnet and Cellbrite to be an examiner and like to extract the devices, to get the device and get the information off of it and then process it and review it.
And so when you're not just talking about cell phone like pictures and things like that. You can also look at locations and all of those types of things as well that go into anything with the digital forensics, correct?
Correct. Cell phones are essentially databases, so it's looking at all the different databases, some that can be seen, some that can't be seen in particular readers. So you have to use different tools to get to it and look at the data inside of those databases.
So I'd like to turn your attention to this case. Myself and Mr. Jaskovich called you to hop on to this case and help us to go through, I believe there's what, 6 terabytes of discovery on this case to go through?
There is a
Something like
plethora.
that. There's a lot. And we asked you to look at a few things. What were those?
So cell phones, the cell tower records, looked at the Barilla extraction of the infotainment center. So everything that has to do with the cell phones, the cell towers, and the vehicle.
Okay, so right now I'm gonna turn your attention to the cell phone examinations. You were tasked to look at certain things dealing with cell phones, correct?
Correct. I was primarily focused on 3 different cell phones. The cell phone of Devyn, Jonathan, and Devray.
And did you have an opinion on the accuracy of the information that was given to you?
I mean, accuracy, it's the data that's on there. Are you asking more like, was there anything that stood out, or?
Well, was it the accuracy of the extractions? Is there anything that was missing or that you would have liked to see more?
So as previously stated, the cell phones are made up of databases, and I stated that the software doesn't always pull all the information. So the information that I was provided was a UFED reader report, which is after you do an extraction, you take that data, you put it into another piece of software, and then you can create a reader report, which is what I reviewed in this. That is only the data that is able to be interpreted by the software. So I found it problematic because over my review and looking at everything, it's only, of all of the apps that are on the phone, the average between the 3 devices was only 3% of the data was displayed and presented with the databases backing it up.
So would it be your opinion that this was incomplete as what was provided to you as a whole?
Yes.
And what's the basis for your opinion on it being incomplete?
Years of experience and knowing that one tool doesn't do it all, and that whenever you look at that and you see something as low as 3%, like, okay, well, what else is there? What am I missing? Personally, if I pull up Cellbrite, I'm looking through it, I don't work off of reader reports. It's a bad practice because, again, you don't have all the information. I typically use Cellbrite as an initial tool. It's very good. It's accurate. It's accepted all over the world. The data that it displays is great. The way that it displays it is great. But sometimes you're like, well, I want to know more about that. And if you're in a reader report, you can't go back to, say, a database that holds messages and be able to find out more information about those files and to look into the databases and see the different information. So not having that is problematic. And then I typically use other tools. So if there's a database I can't get into, I could run it against, throw it into Magnet Axiom and be able to pull that up and look at it in a different tool to try to verify information as well as see if there's any additional information that can be gleaned. If there's databases there that I can't get into, then I can pull it like DB browser or some other deconstructing tool that deconstructs the database so you can look at it in different manners.
And I believe it was yesterday, Detective Campbell came in for the state and testified about UFD, and I'd asked him some questions about UFDR. And could you kind of explain to the jury the difference between the terminology before we go any further?
Sure. So whenever you get a cell phone, if it's all right, I'd actually like to start prior to that, if that's possible.
Course.
Okay, so whenever I've been to many crime scenes and was the person that collected the digital evidence and worked it all the way to trial, as you see today. The standard procedure is to get on site. What's this case? So first of all, you have to figure out what's your scope. What are you looking at? What do you have authority to look at? What type of evidence can you get? So first thing I do is I look after all the photos are taken, because that's the first thing that happens. The crime scene investigators come in, they take the pictures, and then we go in, we start doing a search. If I see anything that's digital in nature, I stop. If I don't have a camera on me or there's another person that's assigned to take pictures, that person would come up, or I would come up, take a picture in the state that it's in the location that it's at. And then from there, once that's been categorized and like logged down, then you would take that, secure it from being connected to any networks. So turning off data, putting it in airplane mode as a bare minimum. From there, you would then, if you're not processing it on scene, you would put it in a bag, seal it, evidence tape, do all that, take it back to the lab, take it out, and then begin your extraction. So that, we're going to use a phone for this example. The phone that was collected, I would connect that to what's, it's called UFED, and there is a UFED for PC, which is software that's on a laptop, and you can connect the phone up to it, and it starts extracting the data from the phone and puts it on there. There's also like mobile UFED devices that you can be in the field and on the crime scene and plug it in. So there's multiple ways to get that data through Cellbrite. And what that does is it builds a UFD. And that UFD is more like a index and some supporting information that tells you, hey, in this big package of data, which a lot of times it's in a zip file, and it's the package that the UFD is going to refer to that actually has the databases and the information. So you load that into Physical Analyzer. So Cellbrite has a product called Physical Analyzer, and Insights is their newer version. And you can put the data in there, and that gives you access to the databases. And you can actually do some database, like go through the database and break it down inside of that software as well. You can use, it's called App Genie. So it'll go in and it'll look at the app and be like, well, what can we do with this app? Like, what more information can we gather? Because again, it's a vendor software, so they're only doing what the people in my field are saying. Hey, we need this to be adjusted. We're not getting enough information for this. Can you turn your attention to there and try to get more information? So once that's all gathered, you go in, you're starting to do your examination, starting to find out your bits and pieces, finding out what databases you need to explore more, what information is important. And then the requester, which is usually an agent, a police officer, or auditor, whatever the case may be, they'll want to see everything right away. Unfortunately, digital forensics is not a right away type field. It does take quite a bit of time. 6 terabytes is a lot of time it takes to get through that. So they'll want something right away. You create a reader report, send it out to the requester. That way they have just a first look of like, oh yeah, that's my suspect. Oh yeah, this is a message they talked about. And you can start to get little bits and pieces. It keeps them happy while you're doing the more in-depth stuff. It also allows them to say, hey, I saw a message on this day, but I can't find anything else that's around there. So they reach back to me and say, hey, this date, I need to know more. So then I can hone it in and be able to say, on this date, at this time, looking at these different databases, I was able to determine this or to provide more information. And then from there, you write up a report, you put everything together, and then it goes back, the report goes back into evidence if it's an evidentiary report. Again, you're working off a copy of the data, so the phone's already been put away. You don't mess with that anymore. If the extraction, like you drop a hard drive or whatever and it stops working and you have to re-extract, you still have that. And one of the other things to touch on that, there's a verification. So I know earlier in the trial, there was talk about a hash value being a fingerprint. Same thing, whenever it does the extraction, Cellbrite does a hash of the data, and you're able to just click on verify hash value to make sure that you're looking at the same data that you were previously.
So in reviewing this and basing your opinion, what are we looking at here?
So right here, we're looking at this is the UFED reader report, and it has different data located there. So you'll see the file system, which is essentially the background of the phone, and it shows the different areas that databases are in. The one database that we'll look at in a little bit, or information that was supplied from that database, you can see I have typed out there the path that has the com.android.providers.telephony and the databases. If you look in the directory on the left-hand side, it does go in alphabetical order. So,
and Mr. Brown, if you
Sure.
want to use your mouse,
Oh, yeah,
don't
yeah.
click on it though, because of the
No
digital
clicking.
content, but
All right, no clicking.
yeah, you
So
can go ahead.
right here you see com.android Chrome, com.android vending, com like wallpaper backup. So that only 3 com.androids were found, not the com.android providers. Like that whole directory structure isn't there to include the database.
So is this a complete picture of this phone?
It is not.
Okay. So did you also review the Armada infotainment system?
So I reviewed the portions of the Barilla extraction that were provided to me, which were the data locations where the vehicle traveled.
And so I'm thinking that we heard testimony about how Detective Campbell was told, or I'm sorry, it was Detective Good was able to go through and kind of ping along how I'm sorry, Detective Spangler, all these guys with these technology and phones, I apologize. Detective Spangler was able to go and follow the infotainment system, where the car went, when it started, when it stopped. You saw that, correct?
Correct.
And I believe it was brought up that Miss Michaels was at a car wash around a certain time. I believe it was between 8:14 and 8:24, and the state phrased it as a car wash, correct?
Yes.
And we asked you to look at the points at this supposed car wash, and that's what we're looking at here.
That is correct.
Okay, and we see that the kind of the top half of it, it's the gas station, it's a convenience store, it's not just a car wash. But what did you do here?
So the first thing I did was I looked here. This is the car wash. You can tell by the structure and the wet marks. And then if you do street view, you can go in and see that as well. So I noticed there's no pings along this backside or anywhere along the car wash area. I also looked at the date and times and the start stop time of the vehicle, which also was indicative of not really enough time to get a car wash, not in the right location for a car wash. But it did show that there was activity under this canopy, which is where the gas pumps are, and is also where all the pins happen. The locations are all in the gas station area. Coming in from this side, going around into the area here, and then come out and leave that direction.
And just as a side, you shut off your car when you get gas, right?
Typically.
Usually when you're at the car wash, you leave it on, you're sitting there listening to music.
Or having to drive forward. Yeah.
Correct.
Or neutral, let it go on its own.
So turning your attention to another item, did you review video data at 6505 Taylor Creek?
I did.
And what is your opinion of what was recovered from that address?
So again, I believe it to be incomplete just based upon the type of evidence that it is and the devices that it comes from. There are, as you can see on the screen, 2 of them are labeled ring video, and the other one just has what appears to be a date timestamp and a .mov. The others are .mp4s. So the 2 videos on the right, the washed out one and then the one that's more in color, appear to be videos that were extracted off of either the Ring app, or like you can go online to the website and pull it down, download it. You can share via email. There's lots of things that you can do with Ring videos. And the one on the left appears to be a few still shots that were then combined into this video that's there. So the snapshots being put together, I'm not sure how familiar you guys are with the Ring camera, but you can set it up so that it does snapshots. So you can I don't recall the minimum amount of time, but I believe it to be like minutes, maybe even seconds. And then from there, you can go into you can turn it off completely. So the fact that there are what appears to be snapshots would indicate that snapshots were being taken. And if only 1 or 2 snapshots were taken of that area, and I believe this is the one where you can see the house up on the
or the vehicles on the top right. Yeah.
It's this one.
So in this area here is the area of interest. So if you're having a lot of snapshots in that area, you're going to be able to see things coming and going. So you would be able to refer to those snapshots. However, in this exhibit, I did not see multiple. Well, there were multiple, but not a plethora, not a whole bunch of snapshots to look through. It was just, hey, we collected these 2 or 3 snapshots because we see the vehicle there, and then done. But there's so much more that could have been collected on that and more information.
And you weren't provided any document from law enforcement that they were looking for snapshots of this camera.
I was not. I didn't receive any reports or anything on this.
Are you aware that any other videos that had been provided to you, anything else that you saw that was recorded except for what we saw here?
So there were, I looked at a bunch of different videos that were collected.
And let me, from
Sure.
this address.
From this address? No.
And that's because there could have been, but from what you saw, there wasn't anything done about the snapshots or anything. There was just that one.
Correct.
Now, I'm going to turn your attention to one of the phones we asked you to look at, and off of the information that was provided from the state. It was Devyn's phone. Did you review that?
I did.
And I want to get to was it a complete capture of Devyn's phone?
No, same as it's previously shown.
There wasn't information about every single app, every single activity that was going on.
There was not.
But even though we had an incomplete picture, you were still able to access some background information, some stuff from the databases that can tell you kind of what was going on.
Correct. I was able to access the reader and what Cellbrite was able to pull out and look at those provided items.
So what are we looking at here?
So here we're looking at on 8/6/2023 at 10:36 at night, there is communications, an instant message that was outgoing from, we're looking at Devyn's phone. So the outgoing would be the from, and then to the phone number related to the device of Devyn. So from Devyn to Devyn, their devices. It says, see you when you get back. I'm going to sleep, girls. So it's part of a text message. And then there's an incoming call at 10:58, which appears to be from Devyn's device to Devyn's device. And it appears that the call was taken and was 44-second long phone call. The last item is at 2:12 in the morning on Devyn's phone. There was part of the Android messaging here. There was a icon. So whenever you save a contact, you can add a picture to it. And just so whenever you look at it, it pops up, has the picture. So this is a picture like that.
And this is a little bit more information on that.
Correct.
Icon.
Same one, it just different slide. Same
timestamp.
Same timestamp,
date.
same messaging, same area.
And this is just a close-up of the photo of the contact.
It is.
So it shows that there may have been some activity going on at that phone around that time.
Correct.
Now, in your experience and investigation and the roles of your work, gaming systems and other devices, not just cell phones or computers, but anything with hard drives, anything that's able to be communicated over, that would be important, correct?
Correct.
You would be collecting those things as you go through and see what's at the scene.
Correct. Depending on what the crime is, depends on what you collect. In a murder case, you're going to collect pretty much everything you can. You can do some field assessments and be able to look and say, well, you know, this device is dead. It's one of the examples was a really old like Nokia bar phone from in the early days. And if you're dealing with a crime right now, there's no power to it. It's stuffed in a box in the back corner and like in a storage unit or something like that. You might not necessarily take it. I mean, you could, but it's more, all right, well, we know that's there if we ever have a need for it. But in general, if you're doing what's considered a major crime, which murder falls under, you're going to want to take as much digital evidence as you can until you start getting more information.
because in the beginning of an investigation, you don't really know what's going on. You're trying to collect anything that may have evidentiary value to later be examined, or if something comes about the investigation, you have that preserved.
Correct. And even in this case, so there was an additional cell phone, I believe it was Devyn's cell phone that was, okay, this is too old, the activity is too old, it's not really relevant to the specific focus point of this investigation. So again, collected as it should have been, reviewed, not relevant, set it to the side. So
here's a picture. It's one of the exhibits that has been admitted for the jury to look at. Just looking at this picture, do you see anything here that of evidentiary value that would bring you to preserve some of this?
So I see two items in here that could potentially hold additional information. There is a Xbox on the,
and I prepared it a little bit here just for you.
so it appears to be an Xbox here and then a Nintendo Switch here. And the significance of that is that both of those devices, you can chat with people, you can communicate. There's multiple ways that you can do that. One of them you'll see in a little bit, like Discord is a really big gamers app. A lot of people that use Xboxes also use Discord as a communication method if the game that they're playing or whatever doesn't have it embedded, or if they just want to save speed or data just to make things more efficient.
But even in like a Nintendo Switch where you can switch out data cards to store things and add more games, or even Xboxes with hard drives to plug in for additional space, it can be just normal hard drive. Those are things that you'd want to look at and see if they were there.
Absolutely. And they connect to the internet and you can browse the internet as well. So potential for communications that way on top of chat applications.
So going to other things that could have been looked at here, what are we looking at on this exhibit or this slide?
So this is showing that the Discord app was purchased through the Play Store on Devyn's phone, and it looks like 4/27/2023 is whenever it was installed. So yeah, it just shows that an additional chat application was on his phone that is also found on gaming systems.
And Discord, I know you kind of briefly touched on it. I'll let you explain that because you're more well versed in that. Can we just go through again for the jury what that is?
One more time, please.
Discord, what Discord is?
So Discord, a chat application, you can have it on your phone. You can have, there's multiple places that you can hold that, and it allows you to communicate back and forth via voice or text.
And what are we looking at here?
So this is another artifact related. Nintendo Switch was also found there. So there's an application that's listed as Cellbrite flagged it as entertainment and chat application. So it's another indicator. Hey, it's a possibility that the Nintendo Switch has chat on it. The application also allows for chat.
And that would be something of significance if you're trying to determine people talking about potentially a murder or anything, that you would go and look through all these things and all these apps to see which ones could communicate to other people, at least be looked at and investigated or preserved for a later time.
If you had access to those databases, yes.
And what are we looking at here?
We are looking at one of the applications that is related to Discord. And it's at 8/7/2023, 2:31 a.m. So it was an artifact, a Discord. So you can see Discord up here. So it's at that date and time on Devyn's phone, the Discord chat, or well, the Discord program was accessed.
And that was at 2:31 a.m. on August 7th.
That's correct. So it says modified. Anytime the system does anything to the file, then it would modify it because it's making changes.
And briefly, you didn't look at any router logs, did you?
I did not.
You weren't provided with any router logs?
I was not.
Nothing from the Porcupine residents about a router?
No.
That would have been helpful if you would have had that at that address, correct?
Correct. So as previously testified, the router holds information of connected devices. That's really important, especially whenever you're looking at an investigation like this, because if you know what devices have been connected, then you know what devices you don't have, or you can verify the devices that you do have. So you could look at it and be like, well, 6 phones show up on here, but I only have 5. Where's the 6th?
And some of these artifacts that we've seen, this could all be indicative of activity on either the phone or gaming systems. There's something going on, but we just don't know because we don't have the full picture.
That is correct.
And now we're looking at slide 18 on our presentation for the jury. What are we looking at here? Oops.
Okay, so you'll see in the next slide, it's the same slide as previously shown with the missing database. This lays it out a little bit more. So the native message here, which is found in this MMS-SMS database, which we've already shown is not located on the reader report. It has a message in it here that says headed there now. We don't have a to, a from, a date. We have no other information other than it was deleted, which let me clarify that also. So here you see like messages in white, and then you see it in red. The red indicates recovered deleted items. So if it's red or it has this little red X right here, it means that that item is deleted, but the software was able to pull that out of the database.
But does it show a time or date or to and from?
It does not. And again, I couldn't go back to the database to see if there was any more information in there or related stuff around that time, like around that message, or looking at deletion orders, or there's no way to tell more information in the presented state.
But we know it's deleted.
We do know it's deleted.
And this is the slide that we talked about earlier.
Correct.
And it's about the missing databases and the different types of files, the UFDs, UFDXs.
So UFDX, I think that's a new term. New term for here. So if you have a UFD, it's the initial one, like I had stated about having a device, and you're looking at it's the UFD with the supporting data. If you take multiple devices, so in this case, if I was to take all 3 of the devices that I looked at, I throw them all into Physical Analyzer, I could create a UFDX, which is essentially multiple extractions put into one. So I can open that up, and by doing that, it loads all of the devices, and then I can run searches. Can you go back a slide?
Of course.
Sure. So up here, I can type in a search, and then if I click on this little down here, it will display each device that's loaded in and how many hits there are, and then you can select which device. You can select all, and then you can work your way through it and see where all that search term shows up across all of the devices.
And just because we've heard all these terms and they've been thrown out between yourself and Detective Campbell, what is the most complete extraction that you would like to have had on this?
I would have liked to have the UFD with the supporting files so that I would have access to all of the data and not just the maximum 3%.
And again, you weren't provided with that.
I was not.
Now, when we asked you to review, yesterday we heard from Detective Campbell about it was Detective Good at the cell site location. It was a couple days ago. They said that they only looked until 9 a.m. at that time.
That is correct.
And we asked you to look a little bit further, give or take on both sides. And did anything stand out to you?
There was a location. I was like, oh, this looks interesting. Maybe want to take a look at it. Again, I don't have much more information other than the location at the time that was shown. And so I brought it to the attention
and just because I know it's hard for me to zoom in on this, how we have it set up, but if you could just put the mouse on the 2 little points that we have on this, the jury sees what we're trying to point out here.
Sure. So here is Jonathan's home. And then here is one in the southern part of the valley, more in a remote area. And that is on 8/7/2023 at 10:25 a.m.
And that's inclusive of what you brought to our attention, correct?
Correct. So it's here, and then you have a lot of these washes, and then over in this area you have lots of open area.
So it's pinging near all these open areas.
That's correct.
And that's the date of that is the 8/7.
8/7.
In your review of this, and I know I've hit this a bunch, but this is not complete.
It is not.
There's more out there that could have been done.
Absolutely.
And some of the things that we've brought up, these are things that we would have liked to know more about, we just couldn't get into.
Correct.
That could have helped us.
Correct.
Court's indulgence. Ask the witness.
Good morning, Mr. O'Brien.
Good morning.
We just met outside in the hallway.
We did.
Thank you for your military service, sir.
Thank you.
I have a few questions for you, not too much. I just received these items that were shown this morning. You would agree with that?
Yes.
So I'm just going to kind of go through a couple of the slides and try to make sense of, to clarify what we're actually seeing.
Okay.
So I'm going to start with the residential neighborhood, the slides you just put up. Mike, can I? Oh, do that. Power comes back up.
And you can click on it too if you need to just use it on here.
Yeah.
And then you can click on the slides below and it goes up.
Perfect. Thank you. So I'm showing the slide that you'd agree that's a residential neighborhood, correct?
Yes.
And you looked at a whole lot of stuff in this case. Would that include text messages on Devyn's phone?
It would.
We got a bunch of text messages after 9 a.m. On August 7th of 2023 from Devyn's phone.
Correct.
And you'd agree with me, there's text where he's talking with his boss and talking about a job and going to that job.
Yes.
Okay. And you'd agree this is a residential neighborhood, a newer one, kind of out at the tip of the valley.
I would.
And the location data is that you're looking at that caused you to testify that he was in this residential neighborhood was from the CDRs, not from the device.
That is correct.
So CDRs, as a reminder, those give a general approximation. They're not like the breadcrumbs from the Burla or the Google.
It's not the GPS, guys.
Got it. So you're not saying in any way to this jury that his location put him in any of these desert areas, correct?
That is correct.
You indicated earlier that you reviewed not only the DFLs, which were the actual phone extractions, but you also reviewed the CDRs and the Burla, correct?
That is correct.
Did you also review the Google?
I did.
The geofence stuff?
Yes, I
Okay.
did.
You would agree that there's nothing in any of those sources of information that shows Devyn's phone going toward or at the Paladura address between 10 p.m. on the 6th and 8 a.m. on the 7th.
That is correct.
Okay. You would agree that all of those things show the defendant's device, car, and everything at the Paladura address until 2:04 a.m.
That is correct.
So the Google data is separate, and that was a geofence,
Yes.
right? And you're familiar with the steps and Google's privacy. And
I am
all
the
that.
obfuscated numbers and doing the 2-3 steps.
Right. So just to narrow it down and like simplify it, a geofence is actually placed on around the home, the Paladura home, and says, the first step says, show us what devices are at that home, but they give general numbers.
Correct.
And if I oversimplify, you can tell me.
It's good. That works.
And so in this particular case, it only showed the defendant's device at that home.
Well, it showed multiple, but once you select which one you want that's of evidentiary value, and yes, that was one of them.
And that would be Yoko's, Yoshida's, and Jonathan's were actually there too.
Yes.
Yeah. And nobody else's.
Not that I recall now.
Yeah. So it's 4 devices at the Paladura home, not including Devier's.
Correct.
And Devier did have a Google device.
Yes. An Android that.
Yeah,
Yes.
Android is a Google
Yes,
device.
yes.
Okay. So we're in agreement. Nothing at all that you went through suggests Devier was at the Paladura address between those time frames.
That is correct.
The Google data did show John's phone traveling from the Paladura address at around 2:04 a.m. in the same exact path as the defendant's car and phone.
Yes.
Real briefly on the car wash. That information was gleaned from the Burla.
Correct.
Burla is the one with the breadcrumbs.
Correct. It does the GPS locations, which is the most accurate.
Got it. And that shows the Nissan going to what appears to be the gas pumps, not through the car wash.
That is correct.
We're in agreement. Okay. And that would have been about, correct me if I'm wrong, I think 8:30 in the morning.
Yeah, I don't recall.
Well,
it's back a few slides.
Okay. It's after the body's discovered.
Yes.
We agree there. You would agree that people can hand wash their cars, correct?
Correct.
And there were several hours before homicide detectives made their way to the Porcupine Rim address.
Yes.
So doesn't look like she went through the Funnies car wash.
Yes. Correct.
Fair. Okay. Briefly on the ring videos. Were you here? Because I've seen you a couple times. Were you here when the detectives talked about those videos?
I'm not sure if I was in the courtroom or if
Okay.
I was watching from another location.
I'm not going to try to recite what they said about the videos, but simplifying it, they basically said, we got what the homeowner gave us.
Correct.
Okay. You're not suggesting to this jury in any way the cops lied about what they got.
No.
Okay. We're in agreement there.
Correct.
They got what they got from the homeowner. And there's 3 clips, one of which looks like it's like motion picture, basically. It's like stills one after another.
Correct.
Which all video actually is.
Technically, yes.
Right. And you would agree with me that homeowners or people who have ring cameras, they can change the sensitivity settings on their device.
Yes.
If they don't want to keep getting annoyed with every time a car drives by, they can lessen the sensitivity just to kind of encapsulate their driveway.
You can set up boundaries. You can set up, there's lots of different settings.
Yeah, there's a ton of different settings. Correct. You would agree that in the videos from that same camera at night and in the morning, it appears Devier's vehicle is in the same exact spot.
To the best of my recollection, that is correct.
And on top of that, there is video from the entrance, the only entrance and exit a vehicle could go at the Porcupine Rim address.
To my knowledge, that is correct.
And that is continuous record. That's not a motion camera.
I'm not aware of the settings.
Okay. There may have been testimony about that. Sure. Fair enough. So I want to get to slide 10 and, well,
You want me to help you? You just go to the bottom a little bit.
Okay.
And slide it over.
Thank you. Slide 10. So the 3 rows represent an instant message. Row number 1, an instant message from Devier's device to the defendant. See you when you get back. I'm going to sleep, girls. Correct?
Correct.
The second one is an incoming call at 10:58 p.m. from defendant's phone.
Correct.
And that one says 44 seconds.
That is correct.
The third one is an image that you brought up today on August 7th at 2:12 a.m.
That is correct.
And I believe the language you used was, I wrote it down somewhere. Did you say accessed? What, just tell us, what does this mean? Like this?
So that particular picture, the PNG, was the device accessed that I don't have more supporting information about anything else that was happening at that time. Again, because I don't have that database, but something was done with that particular file at that particular time.
Got it. So we understand though, when you use that terminology, are you saying the device accessed it or a person accessed it?
Unable to determine.
Okay. If a
I can say that like the device shows that there was some sort of activity on that.
Yeah, and just so we're clear, a device can do things in the background, can access, can cache, can do all these different things. Correct?
Yes.
If it's the opposite, if it's a person accessing it, you would then agree with me that at 2:12 a.m. a person is with that phone using it.
You stated that a person was to show that a person would have to be there.
Yeah, absolutely. I mean,
Yes.
it seems obvious, but like there's two alternative theories. It's either the device access it somewhere in the background or a person is actually handling their phone at 2:12 a.m.
That is correct.
Okay. Go to the gaming system. So you pointed out a couple of a Nintendo Switch and an Xbox, correct?
That is correct.
And there were, to your knowledge, no gaming systems found in the other home, the John's home.
I am unaware.
Okay. I guess the pictures of John's home will speak for themselves when it comes to that. You're not taking a position on that. Do you know if the defendant had a Discord?
I do not know.
Did we get a full extract on defendant's phone?
We didn't get a full extract on any of the phones.
Okay. What is it that allows you to get a full versus a not full?
So the initial extraction that I talked about, the UFD, is the extraction. What we've been presented with was the UFDR, which is after that extraction is done, then you can either select all or you can like handpick what you want and then create that reader report. Okay. But to clarify, when you're selecting all, it's all the data that piece of software at that time is able to interpret and put into a report.
Got it. And so are you suggesting to the jury that the detectives picked and chose what they took, or are you suggesting that?
I'm not really suggesting anything other than the full set of data was not provided and I was unable to do a full examination based upon the lack of data.
Okay. And in prior cases, you have a bunch of experience. I have some experience with phones, not nearly as much as you, but there are many, many times in which you cannot get a full extract out of a phone.
Yes.
Right. That's not abnormal.
Correct.
And you're again not suggesting the detectives like only pick certain things out of the devices.
I have no knowledge what actions they took, but
okay. So with the text here on slide 18.
Okay.
You said this is an artifact with no other information at all.
No other information presented in this manner on the reader report.
Right. So you would agree that there are text messages, call history, all that from Devyn's phone, because we've seen a bunch of them.
Correct.
Right. There's also that same type of information from the defendant's phone.
Yes, all the phones. Correct.
Okay. The text history for Devyn's phone goes back years, right?
It's quite far, yes.
And he has a bunch of contacts saved in his phone like we all do.
Correct.
Right? I don't even know the number, but like dozens, hundreds, I don't know. Can you see it on that?
If you go back a slide, maybe. I'm not sure if it was captured on that or not. So before the bar shows up in the middle?
Yeah. Animation. Oh, gotcha. I don't know how to pull it off though. There you go. There we go. Thank you.
No, I didn't capture the contacts on there.
Yeah, but it is captured somewhere in.
It is part of the reader, yes.
Yeah.
The reader file has that.
And so you agree with this headed there now message. That could be to any number of people years back, 5 years ago, 4 years, whatever it is.
That is correct.
Okay. But you got to bring it up because, I mean, it's something. But you would agree with me, I'm showing you admitted exhibit 666, that, oops, that with,
It's not plugged exactly at the HDMI cord.
gotcha. Can I approach?
Yes.
Does this appear to be to you one of the, or the text string that the parties admitted between Devier and defendant?
That is correct. Yes.
And this shows a relationship text
8523.
8/5 at 1 a.m. already adjusted from UTC.
Yes.
This next one is from voicemail to Devier.
So voicemail being the owner of the phone.
And it says, where the WTF are you? You obviously ain't home, but you ain't cheating, exclamation points.
That's correct. I see that. And
August 5th.
2023 at 4:02 a.m.
Okay. And then the next text says, from Devier to the defendant's voicemail, see you when you get back. I'm going to sleep. Girls are in the living room, correct?
That is correct.
Okay. No other text saying I'm on my way, or I'm sorry, headed there.
No.
The CDRs are completely separate from the device. That's the phone company keeping record. And you would agree with me that there is absolutely no record of a text message after the one where he says, I'm going to sleep, going to the defendant's home between whenever that was, 10:36:24 p.m. and 8 a.m.
Can you repeat the initial question?
The CDRs.
Okay,
we're-
CDRs.
Yeah,
that is
we're
correct.
away from the phone.
Yep, that is correct.
In the CDRs maintained by an outside source, the company,
Yes.
there is no incoming text to Devyn from Devier, no outgoing text from Devier to Devyn after that one at 10:36.
Based on my review, no.
So this headed there now text doesn't have anything to do with our time frame based on the CDRs.
Based on CDRs, I believe that is correct.
Just make sure I got through all of them. Yep, that's it. Thank you very much, sir.
Sure.
Just to touch base on the picture being accessed and the gaming data of, I think it was, what's it, a core or a Discord? There was activity the morning of, or the early hours of August 7th.
That is correct.
And do you know if Devier had his phone on him?
I have no, I wasn't there. I don't know.
Yeah, we don't know either. Now, the state brings up the Funny's car wash. Let me pull this back on this slide. Now, he brought up the state, and I'm not trying to misstate, I'm just kind of summarizing, is about pulling in a potential hand wash of a car or something like that. You remember that question?
Yes.
Now, the car turns off at 8:17 and turns back on at 8:21. Does that sound about right?
It does. Yes.
Nissan Armada is not a small car. It's not a Honda Civic. It's not a hatchback. It's a pretty big car. Correct? Just from your, I mean, you've seen them on the road.
Yeah.
It's a bigger SUV. It's not a small
Correct.
car.
That's correct.
So to hand wash a big SUV that they've made is super clean. That 4 minutes is pretty quick.
Correct.
To hand wash a car, not drive through a car wash, but to hand wash it at a gas station, unless there's, yeah, doesn't seem to add up.
Correct.
When he asked you about the Ring cameras at Porcupine. Mr. Giordani asked you about the cameras in and out of the development. Remember that line of questioning?
I do.
But we don't know if any person was walking around, say, hopping a back wall on a side of the house. We don't have any of that, right?
I did not see any of that, no.
There's other ways to get into a neighborhood besides just a car coming through the main gate or the main entrance.
Correct.
Or leave a neighborhood.
That's correct.
Now, there was a call.
Just to clear, you said car or person?
I'm sorry, there's other ways for a person to get out of a neighborhood besides a car.
That's what I thought you were saying.
Yeah.
Okay.
And thank you for clarifying.
Sure.
And we do see that there was a call at 10:58, right?
That's correct.
And that was Devyn to Devier.
Yes. Well, to the devices.
Correct. Now we went into the UFD, UFDR. Like I said, I always confuse these, so I'm glad you're here. We were not provided, you were not provided with the full downloads or extractions.
That's correct.
And from Detective Campbell, yesterday he testified that he got his extraction and gave it to Detective Ozawa. It's kind of what you remember because you've looked at the reports. You're familiar with the case.
Yes.
Do you remember seeing, or do you remember being handed any kind of information from phones that there was a follow-up from Detective Ozawa to get more information on the phones?
I did not see any more.
You were just given the initial or UFDR of the phone.
I have no idea when those, I can look up the time that it was created, but I don't know what order, if there were other extractions done. I have no further information other than I received these reader reports.
So from what you received, it is just, I have this one download, and that seems to be the only thing that was done. From
Correct.
what you've been
From
given.
what I've seen, yes, that is correct.
Now the headed now text, it was deleted, wasn't it?
It was.
And we don't have a time.
We do not.
We don't know what that's in reference to.
No.
And going back to the Ring cameras at Porcupine, or from the address, there's so many. The Taylor Creek address.
Okay.
You don't, not suggesting that the cops didn't, not that they made their own, but there was no follow-up onto subpoena or get any more information on this. You didn't see any of that.
I have no knowledge of that now.
And I'll state it this way. You weren't provided any more than that. This is what we got and we gave it to you.
Correct.
Okay. And just going back to this picture of one of the last pings on Devier's phone, the state suggested that there was this, he had this work schedule, which been throughout the course of the trial, there's been testimony that he had to work, that morning and he went. But were you able to confirm that by any text message you looked at through the phone? Nothing popped out to you.
No, nothing stood out to me.
It's kind of why this popped out to you by this area at this time.
That's correct.
No further questions.
Yeah, I have to apologize. So there actually is text messages where Devier is talking to his boss and saying, I'm headed to a job out. You saw those, right?
Yes.
Okay, so those do exist.
Yes.
Okay, that's not just testimony, that's in the device.
It's in the device.
And it's
There's
consistent.
multiple occasions that they talk about work. Hey, I'm headed to this site, headed to that site. I'm going to run late.
That morning, August 7th.
I don't recall specifically. No.
Well, I can show you.
Okay.
Can we agree overall that you went through these devices like with a fine tooth comb?
No, I did the best I could in the amount of time that I was provided with the data that I was provided.
Okay, fair enough. When you go through this, I mean, you're presenting everything that stands out to you as like, this is fishy, or this is something I would bring up or whatever, right?
Correct.
There's nothing you left out that was that was something you were like really interested in and didn't present to the jury?
No.
Okay. So. So I'm showing you already admitted Exhibit 4. And I want to kind of show you this just in context of the timeline you just provided to the jury. So we agree that there is an incoming call to Devier's phone at 10:58 from defendant's phone.
Correct.
10:58 p.m. on the 6th.
10:58 p.m. on the 6th, 44 seconds.
And this is already admitted earlier by us. Well, let me back out so you can verify. You would agree that this appears to be stuff from the defendant's phone, correct? The Z Fold?
Based on the naming,
Yeah.
yes.
And then I'm going to go into the call log timeline. And you can see that 10:58 p.m. outgoing call from the defendant's device to Devier, correct? Do you see that?
Yes.
And then as it goes on, there appears to be a bunch of missed calls from Michael's home.
That is correct. What's labeled as Michael's home?
Right, but it's a different device from Devier. It's a
Correct.
separate number. Yeah.
Correct.
And some of those went to voicemail.
Yes, that is correct. I believe 3, maybe 4.
And you're aware we can recover those voicemails, and we in fact did.
Absolutely.
Opening the folder entitled Audio. Do these appear to be the 3 recovered voicemails?
Yes, it does.
And these are after that 10:58 p.m. call from the defendant to Devier, correct?
Correct. It appears to be about 11:13, 11:18, 11:21.
And if I click on this, is that going to play the audio?
I hope so. It doesn't have the supporting file.
Yeah, I did this before, and I think I have to open it.
Mom, you answered this room and walked to me. I woke up in the middle of the night. There is a sleeping kid. Please, I can't fall asleep now. I wake up. Please give me a call back.
Did you hear that?
I did.
You familiar with that?
I am.
That's sounds to be a little girl's voice.
It does.
And she's saying, Mom, Devier's asleep. I woke up in the middle of the night.
Correct.
Victoria, can we somehow move that up? Because I have the 3% on. I don't know why the audio is not playing. Because you may, because my laptop's plugged in. No, I unplugged it. May I inquire if the jury heard that?
Yeah, did you guys hear that?
Okay.
Yes. And Mr. Devyn, if you want to put the laptop next to the microphone, it may make it louder.
That would make sense, wouldn't it?
Yeah. You know,
please give me a call. I'm very worried about you. I'm very scared. I don't know if you got a car accident or any circumstance. And I'm getting very worried. Please call me, please. Everyone knows if I woke up in the middle of the night at 10:40, I've been trying to get everything prepped for school tomorrow. So, the beer's not down, today's not down. I know. He's been telling me what kids like here to everything. You said you were going to get some medicine. And then you never got any. So please give me a call back. I'm very worried.
That was voicemail number 2. Sir?
Yes, that is correct.
And you heard the little girl's voice say, everyone's asleep. I woke up in the middle of the night.
Yes, I did.
Devier's knocked out.
I don't think she said that, but
Okay, well, I'll play it again.
I've been waiting for you to come home, and I haven't seen you anywhere. So, if you could, please give me a call. I'm very worried about you. I'm very scared. I don't know if you got a car accident or any circumstance. And I'm getting very worried. Please call me, please. I promise if I woke up in the middle of the night at 10:40, I've been trying to get everything prepped for school tomorrow. So, the beer's not down, today's not down. I know. He's been telling me what kids like here to everything. You said you were
Did you hear it that time?
I did. Thank you.
I've been waiting for you to come home. You never came home. I maybe a couple of minutes and I should be heard them. But I'm getting very worried. Please call me. I'm very worried. You know how you're worried about me sometimes? I'm kind of worried about you scared and everything. I'm really getting worried. I'm like, so, like, are you in a car accident or something? That's not worried. So please, can you call back? I see a car in the neighborhood and it's stopped in front of our house. I'm not sure if it's you. If it is, could you call me back?
And that was voicemail number 3.
That is correct.
And then if we back out of that, we go to the report. That would have been, for the record, 11:13 p.m., 11:18 p.m., and 11:21 p.m. in that order, right?
That is correct.
I'll pass the witness.
Those messages were around 11 p.m. is what you recall.
That's correct.
There's activity on Devyn's phone around 2 a.m.
That's
Correct. On 8/7.
That's correct.
And on one of the voicemails, it talks about a car out front. Is that what you heard?
Yes.
Now, going back to the wash, the state brought up about his work schedule. Do you remember reviewing any messages between him and his boss regarding that morning?
I really wasn't focused on anything that late. It was just over my review of like going through like, oh, that's kind of weird. I didn't really do a lot of investigation around that because there was a whole lot of stuff, other places that I was focused on.
Anything about him running late?
Not that I recall.
And we saw those artifacts on the phone around 2 a.m. with the Discord and the photo.
Correct.
And we can't.
The photo, yes. I'd have to see the Discord one, get one again to verify that time.
Pull it up. Looks like Discord was 231. Is that? Am I
I
sorry,
have
it's
no
not plugged
reason
in.
to dispute
I'm
that.
sorry. I don't know what just happened now. There it is.
2:31 a.m. Discord. That's correct. On 8/7.
Court's indulgence. There are no further questions.
Any follow-up statements? Okay, ladies and gentlemen, the jury have three questions for this witness. Okay, first question on full sheet of paper with your name and your jury number. Counsel could approach. Any follow-up statements? Okay, ladies and gentlemen, the jury have three questions for this witness. Okay, first question on full sheet of paper with your name and your jury number. Counsel could approach.
Do you guys think she's going to testify? I don't know if it's going to help her. I wasn't sure if testifying was worth it initially, but now I need her to explain this to me. Oh, okay. I wonder if she's coming. Okay, let's see. Well, we don't know yet. Looks like there's a break. And someone's coming. He looks like Mark Garagos, but it's not.
What are the exhibit numbers?
Okay.
C4 and D4? Okay, C4 and D4 will be admitted for some stipulation. Defense, you may call your next witness.
Thank you. The defense calls Dr. Larry Sims.
Okay, Dr. Larry is coming up.
Do you solemnly swear or affirm the testimony you're about to give in this action to be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Thank you. Be seated.
Yes, I do. Okay, if we get Dr. Larry's testimony, we will be probably at the lunch break. I don't know. Do you guys want Dr. Larry? Let's go ahead and Dr. Larry is probably going to go about not long. Oh, maybe like 45 minutes, 50 minutes. And then we'll be at a lunch. We'll probably be at the lunch break, but by the time that's over, they might be back, but it might be time to pack it in at that moment and save some for tomorrow. But let's see. Okay. I mean, it's Friday, right? Now let me just tell you guys this real quick. There have been a lot of shenanigans happening over at Afeni Muhammad. As soon as this is over, I'm going to run a live. I'm going to actually put the live up now. So as soon as this is over, I just want to take a little break, get a little bite to eat, and then we'll talk Afeni Muhammad, okay? There have been a lot of shenanigans that happened today, including a relative bringing a weapon into the courthouse, a mess. If you're in members, I put it up in members, and if you are on Facebook, I posted it on Facebook. Just a quick update. So you can catch that over there, and then we'll do it live when we're finished with this. Okay? All right. Okay. Girl,
My first name is Larry, spelled L-A-R-Y. My last name is Sims, spelled S-I-M-M-S.
Thank you. Dr. Sims, if you could tell us a bit about yourself, beginning with your education.
Well, I graduated from high school in 1970. I graduated from college in 1974. I went to medical school at Oklahoma State University and graduated from there in 1978. I did a rotating internship as a physician in Dallas from 78 to 79. And I was a general practitioner for 10 years, 3 years in rural America and 7 years in Detroit. I had about 55,000 patient contacts, delivered about 100 babies. Then I went back into training at Michigan State University in pathology for 4 years. Then I did a 1 year forensic fellowship at Cook County Medical Examiner's Office in Chicago. Stayed on there for some years, and then I came out here and was at the Clark County Coroner's Office for 19 and a half years. I maintain a licensed medical license in Nevada, and I'm board certified in anatomic pathology, clinical pathology, and forensic pathology.
Doctor, so you were a coroner here in Clark County?
Yes.
19 and a half years?
Yes.
Would often be called by the state of Nevada in prosecutions of murder cases?
Oh yeah, I would. I probably testified over 500 times during that period of time.
You were contacted and were ultimately retained by the defense in this case, the state of Nevada versus Devyn Michaels, correct?
Correct. Yeah, I was contacted by the Special Public Defender's Office. It's been over a year ago.
Okay, and just for the record's clean, I mean, I'm not part of the Special Defender's Office, nor is Mr. Horvath, but that was who was initially on this case.
That's who initially contacted me.
After being contacted, were you provided with certain materials, specifically an autopsy report and other things of evidentiary concern, photos and the like?
Yes.
To your knowledge, was it the entire file?
Well, what I was provided, which is all the forensic important stuff, yes.
Have you had an opportunity to review the autopsy report prepared by Dr. Stephanie Yagi?
Yes.
And that autopsy report is dated August 8th of 2023.
Correct.
Did you review the pathologic findings in the autopsy report?
Yes.
And what are they?
Well, okay, have you got a copy of the autopsy report? I can go.
Absolutely. May I approach with a copy? State any objection?
Not at all.
So the main two findings is she classified the death as homicidal violence, and then she noted that he had a fatty liver.
And those were the two findings?
Correct.
Now, are there certain standards of practice that are employed by pathologists, specifically coroners?
Yes.
And what are those? And if you could please describe those to the jury.
Well, there's a number of practice standards, but there's a specific published practice standard in relation to using homicidal violence without any specific cause. It was published in 2010, and it has 5 separate criteria that all 5 have to be present before you use a non-specific cause of death, such as homicide by unspecified means or homicidal violence.
And doctor, what are those 5 criteria? And if we could just have you break them down, please.
Well, one of the important ones is that there can't be any other cause of death present. In other words, there can't be any natural disease present. There can't be any toxicologic explanation of death. There can't be any environmental explanation of death, such as drowning or cold. And there has to be an indication that the body was altered in some way. And there's one other criteria. I can look at the paper. I can't remember what it is.
Okay, if I may approach the witness.
And then a specific cause of death can't be brought out of the whole entire data set, which means all the findings that are available.
So from the get-go, we have this pathological examination done, and we have these pathological findings. The first being homicidal violence. And you had discussed these 5 criteria. Let's focus on 2 of them, specifically no atomic cause of death. How is that a concern, and how did this examination and this opinion not follow the standard practice?
Oh, well, in this particular case, that he actually has 2 natural diseases that could cause his death. His heart was enlarged, and he had a fatty liver.
And those are obviously borne out through Dr. Yagi's analysis and review of the body, correct?
Correct.
There's another criteria I'd like to draw your attention to, and that's no toxicologic cause of death. If you could please explain that and the significance in this exam.
Well, there has to be drugs can be present, but they have to be at low enough levels not to cause a death. Is kind of the main thing to take away from that. Or there can be drugs present that are not known to cause death, like a medicinal type of drug.
So in this case and on this examination, there was a toxicology report, correct?
Correct.
And what were the findings of this toxicology report?
Well, the main findings, he had a low level of alcohol below the legal limit for driving. His marijuana level was substantially above the legal limit for driving. And he had quite a bit of alcohol in his stomach, but not really very much in his blood, which indicates just that he had drank a significant amount of alcohol just prior to his death before he died.
Let's break that down just a little bit, and let's start with the alcohol where you just left off, Doctor. Are there different places where these draws are taken in order to arrive at the alcohol content of the body?
Correct. It's very important to, without going into a lot of explanations, to take the blood from a certain region, because that region is more characteristic of the level of whatever drug prior to death. If you take it some other regions, it could actually be higher or lower.
So in this case, was there both a blood draw from perhaps a leg or an ankle and from the stomach?
Yes, they did both of those.
If you could please explain those processes and the findings to the jury.
Well, the blood was taken appropriately, and so I have good confidence in the alcohol level of blood and the. Have you got a toxicology report, just so?
Yes.
I'll make sure I don't say anything wrong.
I believe, oh, absolutely, Doctor, I believe it's attached
Part
to
of this?
the back of the report.
So the alcohol and marijuana was done on peripheral blood, which is the appropriate thing. They also took urine and gastric fluid, and they did take heart blood, and they did measure the GHB level in the heart blood rather than the peripheral blood, which is not a good thing to do. It should have been done on the peripheral blood. Those are the main things.
And focusing in on the alcohol content, you had testified that in the blood, it was not particularly high, correct?
Correct.
But then you made reference to the alcohol in the stomach. If you could please explain the significance of that. Did that denote recent drinking, heavy drinking? What would that indicate?
Yes, he had, it was about 30 times higher in the stomach fluid than in the blood. So he had drank, a couple of, some significant alcohol that had not been absorbed yet into his blood.
Now, if the THC content, it was significantly above the legal limit, correct?
Correct. The legal limit is 2 and his was 26.
So over 10 times the legal limit.
Correct.
THC. So if an individual were to have ingested alcohol, as we have evidence of, and smoked marijuana, could you opine, was that person intoxicated?
Oh, definitely, yes.
If we had heard testimony that this person had gone to sleep or shouldn't be driving, a family member was concerned about him driving, would that be consistent with the findings of this pathological report?
Yes.
In reference to the GHB and the drawing from the heart, you had said that was of concern. If you could please explain why.
Well, because heart blood is notorious for being inaccurate as far as true level of the antemortem prior to death level. I'm not saying it's completely inaccurate, but it would be better to do that on the peripheral blood, which is what the other toxicology was done on, than the heart blood. But even given that, the DHB level wasn't into any significant toxic range.
Turning your attention back to the findings concerning cause of death, manner of death, and specifically the standards of a practice, these 5 criteria. Is it fair to say that homicidal violence is an incorrect designation?
Yes.
What should it have been?
The practice standards are clear about this. If those 5 criteria aren't met, then you classify the death as undetermined.
As we've covered cause of death, manner of death, it states homicide. Is that incorrect?
Correct. Yes, it's not correct, no.
What should it have been?
It should also be undetermined.
So based upon the science, the examination of the body, fair to say that this was an inaccurate pathological conclusion, homicidal violence.
Yes.
Finally, I'd like to address, there's an issue concerning obviously a missing head. Fair to say that that complicates matters.
Oh, definitely.
And how so?
Well, if you have incomplete remains, it's very risky to make conclusions about something that you haven't examined. You don't really know. Worst case scenario is the head turns up and there's no cause of death with that either. So in this particular situation, that would preclude you from scientifically, objectively assigning a cause or manner of death.
Now, obviously, one of the criteria concerns death under suspicious circumstances.
Correct.
And I don't know if you have had an opportunity to review the file because we haven't discussed it all that much, but obviously we have some fairly suspicious circumstances surrounding this death, correct? And is it fair to say that Dr. Yagi perhaps relied upon that outside the practice standards, but relied upon that in finding a cause of death and a manner of death?
Probably so.
Okay. I mean, we're humans, we make mistakes, fair to say.
Oh, definitely, sure.
In a strictly scientific sense, okay, doctor, and based upon the data, the empirical data, is it possible that this gentleman died of natural causes?
It's definitely possible. That's why you would classify it as undetermined. Before you come to a conclusion, especially one of homicide, which is going to have significant effects, you want to base it on provability. You want to be able to prove it. And in this particular situation, he actually had, in the body that was examined, he actually had causes of death that could cause his death. And the fact that the head is gone precludes you from making a scientific determination.
And again, we've discussed somewhat in this jury's heard for a week and a half, perhaps substantial, suspicious circumstances, but from merely the science, he could have died.
Correct.
Natural death.
Correct. Now, forensic pathologist, that's the role that we're talking about. That's the role I played. You have to base your conclusions on objective evidence, not just suspicion.
Finally, in reference to the decapitation, you obviously reviewed the photos, you reviewed the examination of the body. It was clear that this body was decapitated.
Correct.
Any opinion as, was it post-mortem? Does he indicate that this happened after death?
Definitely. It was examined by an anthropologist or an anthropology team, I guess it was. And they concluded that it was a postmortem decapitation, which I don't disagree with.
Based upon the circumstances, the evidence, fair to say it probably happened close in time of death and decapitation.
That's an excellent question. There's it might be very, very difficult to say that. There's no doubt that the blood was still liquid, but that would be liquid for a number of hours. So it's more likely that it was, but as far as being able to objectively prove it, you'd have to do a substantial number of kind of uncommon tests to do that.
And in reviewing Dr. Yagi's report, in fact, she enlisted an anthropologist to do further analysis on C2 and C3, correct? The findings of that anthropologist was that the head was severed using two instruments, correct?
Correct.
A handheld knife and a mechanical powered saw.
Correct.
Do you take issue with those findings?
Well, after reviewing all the pictures and looking at them, there was an area in the skin that had, in my experience, the characteristics of a chainsaw. But it was only in an area of the skin, which that would be enough for me to be concerned that was part of what was used.
A chainsaw.
Correct.
So while we have the anthropological findings on the bone, did you view any follow-up evaluation or analysis on the skin that you're referring to?
No.
In reference to this idea concerning the cause, the undetermined cause of death, and we have a post-mortem decapitation and the time of death, we agreed that it's fairly close in time. You'd made reference to the blood, and there's been several questions last week asked concerning witnesses and this idea of cast off. Would you anticipate there having been cast off given the evidence that you reviewed?
Oh, especially if there was a motorized weapon used. Yeah, you would expect substantial cast off also on the people or the person that did it.
So would you expect, based upon your evaluation of the evidence, for that person to be covered with blood?
Well, there would be a lot of blood splatter. Yes.
Okay. We had heard testimony concerning, bodies are dissected in the morgue. There's not a great deal of cast off. We're obviously talking about different circumstances here, correct?
Yes, that would be different circumstances. Yeah.
Here, we're not talking about a refrigerated body.
Correct.
Here, we're not talking about a specialized instrument that may be used, let's say, in a coroner's office to dissect a body.
Yeah, we don't use chainsaws, but so no, that's a whole different thing. So.
Okay. There had been questions asked concerning the arteries, carotid arteries, and you'll agree with me, the anatomy of the neck is fairly complex in reference to a decapitation.
Yes.
I mean, we have obviously the muscle system, we have the vascular system, we have the spinal cord with all the vertebrae. We've heard are complex and quite strong.
Correct.
We have the thick ligaments, cartilage. Can you give an opinion as to would it be difficult to effectuate a decapitation?
Oh, yes. Especially if you're just using a handheld knife, would be very, very difficult.
And in this case, we've made reference to a handheld knife and a mechanical powered saw. Again, it's an undertaking.
Correct.
We would expect to see cast off and blood, correct?
Correct.
Would you expect to find cast off and blood at the scene where this had occurred?
Wherever it occurred, yes. Unless somebody cleaned it up or something. But yeah, you would during using a motorized type thing, you would expect a large amount of blood splatter.
So we're not talking about a morgue, we're talking about perhaps in a bedroom, correct?
Correct. Yeah, I've never even considered a morgue anything near a scene of a crime like that.
So that would be inappropriate to make comparisons to what happens in the morgue as opposed to what happens at perhaps the scene of a crime.
I've never done that. I've never heard about that because it's a completely different environment. And so I don't even, there's not even an analogy there. No.
You could have the court's indulgence just one moment. Thank you very much for your testimony, doctor. I pass the witness.
Yes. How are you, Dr. Sims?
I'm okay. How about yourself?
Good. Good to see you, sir. I'm not going to disagree with you too much. I just want to clarify a couple things. We're in agreement. It sounds like that it's difficult to determine cause of death when the head is missing, correct?
Yes.
We're in agreement that it's a postmortem decapitation.
Yes.
We're in agreement. You weren't at the scene. Nobody here was at the scene. Well, maybe except one person, right?
That is, yeah, I definitely was not at the scene. No.
Yeah. So you don't know if someone covered it up while they're doing the sawing with the knife or the saw. We can agree there.
That's a good point. And I was not at the scene, nor did I've never visited the scene.
Yeah.
And so, no, I don't know that.
Fair enough. And you mentioned cleanup goes without saying. You can't say whether the person may have gotten blood on them, took a shower, any of that.
That's correct.
Use chemicals to clean up or anything like that.
That's correct.
Okay. Are you familiar with the term hesitation marks?
Yes.
What does that mean?
So those are primarily in relation to sharp force injury, and they can occur in somebody trying to kill themselves or when they're going to kill somebody else. And it's a mark where you're considering making a cut and you become afraid or for some reason that you don't. And so you leave just a superficial injury.
And you mentioned some of the cuts to the back of John's neck.
Correct.
You're not telling this jury that it was in fact a chainsaw used, correct?
No, I just talked about one area that was that I picked out seeing the photographs that was concerning to me.
Sure. But you'd agree there are hesitation marks.
Definitely.
Looks like somebody who went to do it was like, oh my God, I can't believe I'm doing this kind of thing.
Definitely. There were multiple hesitation marks. Yes.
And with regard to the tools, that was sent out to a forensic anthropologist and there's tool mark experts, et cetera, right?
Correct. Yeah. That is a specialized type of analysis. And I thought they did a pretty good job.
Okay. And that was going to be my next question. Are you calling into question Dr. Burns and her associates' work?
No, I read it. They took very good photographs. They made the proper, in my opinion, the proper descriptive statements. So if that report would have came back to me, I would have adopted the report.
Sure. And it's a report. You didn't prepare a report, I've been told, in this case.
No, I didn't. I was never asked to prepare a memorandum or an email or anything about anything. I was just the reason I was originally contacted with this from the Special Public Defenders. They were puzzled about the cause of death. They didn't quite understand it. So.
We are in agreement that the decapitation is not the cause of death.
That is correct.
You would agree with me. We've had cases together before back in the day. You would agree with me that a single blow to the head with a large blunt object can kill a man.
Yes, they can.
And you've probably seen lots of those cases.
Blunt force injury is a common mechanism of death. Yes.
And there is a difference between the terms homicide and murder, correct?
Definitely.
Homicide is a medical legal definition, and you know better than me. I think it's death at the hands of another.
Correct. It basically talks about a mechanism. Murder is a legal conclusion because there can be justified homicides.
Sure.
Or unjust. Murder is an unjustified homicide.
Right. Gotcha. My point is you're talking about whether or not it's a homicide. You're taking issue with Dr. Yagi's terminology.
Based on the published practice standards, it did not follow that. I wouldn't have came to this conclusion at all.
Okay, fair enough. And I'm not arguing with you about that. I'm just trying to say you're not saying to this jury that John was not murdered.
I don't know.
Okay. Murder can be proven by other means, not just your narrow medical legal determination.
Oh, definitely it can. The jury can come to whatever conclusion based on all the data.
Yeah, phones, video, even confessions.
Correct.
Murder and homicide, two different things.
Correct.
Pass the witness. Thank you, sir.
Any follow-up, Mr. Drexler?
Yes. Suffice it to say that based upon the evidence available, you could not say this person died of a blow to the head. Could you?
No.
That would be reckless.
Yes. There would be no evidentiary basis for that, so I wouldn't say that.
Something I'd like to address on my redirect of you is that we've heard from other witnesses involved in the investigation of this case that this was the first time that they'd investigated, been involved with a case involving a beheading.
Okay.
Have you had experience with beheadings?
Yes.
Multiple?
As far as in the general term of dismemberment, it's probably around 24 out of my whole career since doing forensic cases starting in 1991.
Thank you. Finally, I've got a follow-up question that I'd like to address, and if you don't have any specialized knowledge concerning this, we completely understand. But there's been some discussion of chloramine, the mixing of bleach and ammonia. It was referred to in the autopsy report concerning smoking body, things like that. First of all, can you give testimony concerning chloramine?
No, I don't. That's a criminalist. A criminalist gives testimony about that. I mean, I've definitely been in cases involved in that, and they've talked to me about it. I mean, I can tell you what they told me, but I have an independent. That's not something that I include in my reports or in my estimations, because there's somebody that are better experienced and better knowledgeable than I am.
So you have no opinion as to how long this chloramine may exist? Let's say you put bleach and ammonia together, it's on a body. No time frame, how long that'll be? Nothing. Can't give any testimony concerning that.
No, I mean, you can tell that it caused discolorations in the skin from a pathologist's point of view, but I don't have any opinion about that. No.
Thank you, doctor. I have no further questions.
Any follow-up, sir?
No, thank you.
Please, ladies and gentlemen, do you have any questions for this witness? If you write a question on a full sheet of paper with your name and your address. Council Lynch? If the handheld knife were described to you as a meat cleaver, would it be better to understand that the head could be removed easier than using a knife?
Yes.
Okay. I'm sorry, Mr. Ratcliffe, any follow-up based on yours?
But in addition to this knife, and again, the findings were of a handheld knife, correct?
Correct.
Would you expect a cut to be different from a handheld knife versus a meat cleaver?
No.
Similar?
Yes.
However, in addition to a blade, based upon the findings, we're to understand that a mechanically powered saw was used.
That is correct. Yeah, whether it was a reciprocating saw or a rotary saw or whatever, they didn't go any further than that. But it was some kind of powered instrument.
Thank you. I have no further questions.
State any follow-up based on your question?
No, thank you.
Ladies and gentlemen, any further questions for the witness? Yes, if you can write a question on a sheet of paper with your name and your address.
The jury has many questions. Okay.
Okay, Dr. Sims, is it a regular practice for the medical examiner to call in a criminologist until chemicals are used?
It would be, if that is an issue, a recognized issue in the case, it's not some just minor finding, and that is correct.
If alcohol is in the stomach and not absorbed in the bloodstream, does it affect the person's ability to function?
No.
When you talk about natural causes, would you expect to see physical signs of a heart attack or cardiac enzymes?
That's a very excellent question. Because there was no microscopic analysis of the heart. There was no microscopic analysis of the liver to actually fully assess the amount of pathology and whether there was something acute or longer, which should have been done in this particular case.
In terms of the liver, if fatty liver disease progresses, would you expect to see signs of jaundice or bad enzyme levels?
That's also an excellent question. So in his particular case, it had not progressed to cirrhosis as yet, but without getting into a lot of pathology, the storage of fat in the liver disrupts the liver's ability to function, and the function is the main metabolic organ that takes care of all toxins in your body, whether they're drugs or anything else. And so when you lose that, then you allow a higher level of those toxins to be in your bloodstream, which can cause death. That's how it operates.
Yes, just briefly in reference to the question, the alcohol, based upon your test in the stomach, based upon your evaluation of this person was clearly intoxicated.
Well, the marijuana was really high, and it also worked with whatever little alcohol was present. Both of them are central nervous system depressants. So there's what's called a synergistic effect.
So we would expect then alcohol in conjunction with the THC, this person was pretty loaded.
It was definitely under the influence of marijuana for sure, yes.
Finally, in reference to this cast off post-mortem, you'd expect under the circumstances of this case for there have been significant cast off.
If there was a motorized, there can be cast off even with a handheld knife, depending on how the person is using, but it's going to be very small compared to the cast off from any kind of motorized cutting instrument.
Thank you. I have no further questions.
Any further statements?
No, thank you.
Do the ladies and gentlemen, do you have any further questions for Ms. Williams? Okay, seeing no response, sir, you are excused. Thank you very much for your testimony here today.
Thank you.
Does the defense have any further witnesses they wish to call?
We have no further witnesses that we are going to call. We are going to arrest. However, we do have a housekeeping matter. Did we get those other exhibits? Okay. We'll stipulate the defense rests.
Okay, what are the exhibit numbers? E4 through N4 are going to be agenda pursuant stipulation. The defense will rest at this time. State you have in your witness.
No, thank you, Your Honor.
All right, ladies and gentlemen of the jury, we have now reached the conclusion of evidence in this case. We have now reached the portion of the case where I'm going to read you the instructions on the law that applies to this case. You guys are the fact finders, so it's very important that you understand what I'm reading to you. So we're going to give you your own packet so you can follow along as I read them to you, just in case I read too fast and we don't want you to miss anything.
Ma'am, you see how she's adjusting her chair? Okay, in that, praise God. Okay, look at us. Okay, we're here. The judge, number one, knows that she reads fast. That's for number one. Number two, oops, I didn't know I had the type small that whole time. I'm glad. I kind of would have liked for Devyn to testify, but I'm not surprised she's not. She's crazy. We almost need a little gospel break for a second, but we gonna press on and let Madam Honorable Judge Jones do her thing. I'm surprised that they've already got everything. You know, normally they take a little break. Maybe they did that out of our presence. So now I guess they're on verdict watch. Y'all, my dogs are going crazy. Let me let y'all put y'all on mute and let her read, and then we're going to take a break during verdict watch and stretch our legs and feet and all of those things and reconvene. Okay? All right. You think it was electric knife? I'm giving I could believe that cuz those things are powerful.
All right, ladies and gentlemen, instructions to the jury. Instruction number one, members of the jury. It is now my duty as judge to instruct you on the law that applies to this case. It is your duty as jurors to follow these instructions and to apply the rules of law to the facts as you find them from the evidence. You must not be concerned with the wisdom of any rule of law stated in these instructions. Regardless of any opinion you may have as to what the law ought to be, it would be a violation of your oath to base a verdict on any other view of the law than that given in the instructions of this court. Instruction number two, if in these instructions any rules, direction, or ideas repeated or stated in different ways, no emphasis thereon is intended by me, and none may be inferred by you. For that reason, you are not to single out any certain sentence or any individual point of instruction and ignore the others, but you are to consider all the instructions as a whole and regard each in the light of all the others. The order in which the instructions are given has no significance as to their relative importance. Instruction number three, a third amended indictment is but a formal method of accusing a person of a crime and is not of itself any evidence of her guilt. In this case, it is charged in a third amended indictment that on or about the 7th day of August 2023, the defendant committed the offense of murder with use of a deadly weapon. Count one, murder with use of a deadly weapon. Did willfully, unlawfully, feloniously, and with malice aforethought kill Jonathan Millette, a human being, with the use of a deadly weapon, to wit, a wooden stick and or other unknown object, by striking the said Jonathan Millette with the said wooden stick or other unknown object, and or through other means, the said killing having been one, willful, deliberate, premeditated, and or two, committed during the perpetration or attempted perpetration of a robbery. It is the duty of the jury to apply the rules of law contained in these instructions to the facts of the case to determine whether or not the defendant is guilty of the offense charged. Instruction number four, in this case, the defendant is accused in the third amended indictment alleging an open charge of murder. This charge includes and encompasses murder of the first degree and murder of the second degree. The jury must decide if the defendant is guilty of any offense, and if so, of which offense. Instruction number five, murder is the unlawful killing of a human being with malice aforethought, whether express or implied. The unlawful killing may be effected by any of the various means by which death may be occasioned. Instruction number six, malice aforethought means the intentional doing of a wrongful act without legal cause or excuse or what the law considers adequate provocation. The condition of mind described as malice aforethought may arise not alone from anger, hatred, revenge, or from particular ill will, spite, or grudge toward the person killed, but may result from an unjustifiable or unlawful motive or purpose to injure another, which proceeds from a heart fatal event on mischief or with reckless disregard of consequences and social duty. Malice aforethought does not imply deliberation or the lapse of any considerable time between the malicious intention to injure another and the actual execution of the intent, but denotes rather an unlawful purpose and design in contradistinction to accident and mischance. Instruction number seven, express malice is that deliberate intention unlawfully to take away the life of a fellow creature, which is manifested by external circumstances capable of proof. Malice may be implied when no considerable provocation appears, or when all the circumstances of the killing show an abandoned and malignant heart. Instruction number eight, the prosecution is not required to present direct evidence of a defendant's state of mind as it existed during the commission of a crime, and the jury may infer the existence of a particular state of mind from the circumstances disclosed by the evidence. Instruction number nine, murder of the first degree is murder which is perpetrated by means of any kind of willful, deliberate, and premeditated killing. All three elements, willfulness, deliberation, and premeditation, must be proven beyond a reasonable doubt before an accused can be convicted of first-degree murder. Instruction number 10, willfulness is the intent to kill. There need be no appreciable space of time between formation of the intent to kill and the act of the killing. Instruction number 11, deliberation is the process of determining upon a course of action to kill as a result of thought, including weighing the reasons for and against the action and considering the consequences of those actions. Instruction number 12, a deliberate determination may be arrived at in a short period of time, but in all cases, determination must not be formed in passion, or if formed in passion, it must be carried out after there has been time for the passion to subside and deliberation to occur. A mere unconsidered and rash impulse is not deliberate, even though it includes an intent to kill. Instruction number 13, premeditation is a design, a determination to kill distinctly formed in the mind by the time of the killing. Instruction number 14, premeditation need not be for a day, an hour, or even a minute. It may be as instantaneous as successive thoughts of the mind. For if the jury believes from the evidence that the act constituting killing has been preceded by and has been the result of premeditation, no matter how rapidly the act follows the premeditation, it is premeditated. Instruction number 15, the law does not undertake to measure in units of time the length of the period during which the thought must be pondered before it can ripen into an intent to kill, which is truly deliberate and premeditated. The time will vary with different individuals and under varying circumstances. Instruction number 16, the true test is not the duration of time, but rather the extent of the deflection. A cold, calculated judgment and decision may be arrived at in a short period of time, but a mere unconsidered and rash impulse, even though it includes an intent to kill, is not deliberation and premeditation, as will fix an unlawful killing as murder of the first degree. Instruction number 17, there are certain kinds of murder which carry with them conclusive evidence of malice aforethought. One of these classes of murder is murder committed in the perpetration or attempted perpetration of a robbery. Therefore, a killing which is committed in the perpetration or attempted perpetration of a robbery is deemed to be murder of the first degree, whether the killing was intentional or unintentional or accidental. This is called felony murder. The intent to perpetrate or attempt to perpetrate a robbery must be proven beyond a reasonable doubt. In order for the felony murder rule to apply under the robbery theory, the intent to take the property must be formed prior to the act constituting the guilt. Instruction number 18, robbery is the unlawful taking of personal property from the person of another in his presence against his will by means of force or violence, severe injury, immediate or future to his person or property, or the personal property of a member of his family, or of anyone in his company at the time of the robbery. Such force or fear must be used to 1, obtain or retain possession of the property, 2, to prevent or overcome resistance to the taking of the property, or 3, to facilitate escape with the property. In any case, the degree of force is immaterial if used to compel acquiescence to the taking of or escaping with the property. Such taking constitutes robbery whenever it appears that although the taking was fully completed without the knowledge of the person from whom taken, such knowledge was prevented by the use of force or fear. The value of property or money taken is not an element in the crime of robbery, and it is only necessary that the state proves the taking of some property or money. Instruction number 19, robbery may spread over considerable and varying periods of time. All matters immediately prior to and having direct causal connection with the robbery are deemed so closely connected with it as to be part of the occurrence. Thus, although acts of violence and intimidation preceded the actual taking of the property and may have been primarily intended for another purpose, it is enough to support the charge of robbery when a person takes the property by taking advantage of the terrifying situation she created. Instruction number 20. It is unnecessary to prove both violence and intimidation. If the fact be attended with circumstances of threatening word or gesture, as in common experience, and is likely to create an apprehension of danger and induce a man to part with his property for the safety of his person, it is a robbery. It is not necessary to prove actual fear, as the law will presume it in such a case. Instruction number 21. While a verdict must be unanimous, you need not be unanimous on the means or the theory of first-degree murder in arriving at your verdict. Instruction number 22, murder of the second degree is murder with malice aforethought, but without the admixture of premeditation and deliberation. All murder which is not murder of the first degree is murder of the second degree. Instruction number 23, when it is impossible to commit a particular crime without committing at the same time and by the same conduct another offense of lesser greater degree, the latter is, with respect to the former, a lesser included offense. If you are not satisfied beyond a reasonable doubt that the defendant is guilty of the offense charged, she may, however, be found guilty of any lesser included offense. If the evidence is sufficient to establish her guilt of such lesser offense beyond a reasonable doubt. The offense of murder, which actually charges the defendant with first-degree murder, necessarily includes the lesser offense of second-degree murder. If you are convinced beyond a reasonable doubt that the crime of murder has been committed by the defendant, but you have a reasonable doubt whether such murder was of the first or second degree, you must give the defendant the benefit of that doubt and return a verdict of murder of the second degree. Voluntary manslaughter is a lesser included offense of both first and second degree murder. Thus, you may only return a verdict of voluntary manslaughter if you first rule out both first and second degree murder. Instruction number 24. Voluntary manslaughter is an unlawful killing of a human being without malice aforethought and without deliberation or premeditation. is the killing upon a sudden quarrel or heat of passion caused by a provocation sufficient to make the passion irresistible. The provocation required for voluntary manslaughter must either consist of a serious and highly provoking injury inflicted upon the person killing, sufficient to excite an irresistible passion in a reasonable person, or an attempt by the person killed to commit a serious personal injury on the person killed. For the sudden violent impulse of passion to be irresistible, resulting in a killing, which is voluntary manslaughter, there must have been an interval between the assault or provocation and the killing sufficient for the voice of reason and humanity to be heard. For if there should appear to have been sufficient time for a cool head to prevail and the voice of reason to be heard, the killing shall be attributed to deliberate revenge and determined by you to be murder. The law assigns no fixed period of time for such an interval, or leaves its determination to the jury under the facts and circumstances of the case. Instruction number 25. The heat of passion which will reduce a homicide to voluntary manslaughter must be such an irresistible passion as naturally would be aroused in the mind of an ordinarily reasonable person in the same circumstances. A defendant is not permitted to set up his own standard of conduct and to justify or excuse himself because his passions were aroused unless the circumstances in which he was placed and the facts that confronted him were such as also would have aroused the irresistible passion of the ordinarily reasonable man in likewise situation. The basic inquiry.
Can I just say something about that heat of passion as far as this is concerned? I would think heat of passion can be considered if the person says they did it, right? She's still not admitting to anything. She's like, I don't know what happened. She's not admitting to anything, right? Or she recanted her confession. How is anybody supposed to factor in heat of passion if she claims she don't know what happened? It's either she's guilty or she's not, in my opinion. Am I wrong? Yes, the judge talks super duper, duperty duperter, exponentially. Just she talks fast. I don't get how she thought she's gonna accomplish it. I don't understand. So if you're saying I don't understand how she thought that she was gonna kill him and take the kids and nobody was gonna notice that he was dead without a head in the bed. I didn't mean to make that rhyme, but dead to the head in the bed and nobody was going to notice, and I've got custody of my kids and we're going back. I'm getting back with Devyn, my boo, and everything is all good. I don't see it. Does anybody else? Okay, let's get back to the instructions.
Is whether or not at the time of the killing the reason of the accused was obscured or disturbed by passion to such an extent as to cause the ordinarily reasonable person of average disposition to act rashly or without deliberation or reflection, and from such passion rather than from judgment. Instruction number 26. You are instructed that if you find the defendant guilty of murder or voluntary manslaughter, you must also determine whether or not a deadly weapon was used in the commission of this crime. If you find beyond a reasonable doubt that a deadly weapon was used in the commission of such an offense, then you shall return the appropriate guilty verdict reflecting the use of a deadly weapon. If, however, you find that a deadly weapon was not used in the commission of such an offense, but you find that it was committed, then you shall return the appropriate guilty verdict reflecting that a deadly weapon was not used. Instruction number 27. A deadly weapon is any instrument which, if used in the ordinary manner contemplated by its design and construction, will or is likely to cause substantial bodily harm or death, or any weapon or device, instrument, material, or substance which, under the circumstances in which it is used, attempted to be used, or threatened to be used, is readily capable of causing substantial bodily harm or death. Instruction number 28. The state is not required to have recovered the deadly weapon used in an alleged crime or to produce the deadly weapon in court at trial to establish that a deadly weapon was used in the commission of the crime. Instruction number 29. To constitute the crime charge, there must exist a union or joint operation of an act forbidden by law and an intent to do the act. The intent with which an act is done is shown by the facts and circumstances surrounding the case. Do not confuse intent with motive. Motive is what prompts a person to act. Intent refers only to the state of mind with which the act is done. Motive is not an element of the crime charge, and the state is not required to prove a motive on the part of the defendant in order to convict. However, you may consider evidence of motive or lack of motive as a circumstance in the case. Instruction number 30. The defendant is presumed innocent until the contrary is proved. This presumption places upon the state the burden of proving beyond a reasonable doubt every element of the crime charge and that the defendant is the person who committed the offense. A reasonable doubt is one based on reason. It is not mere possible doubt, but is such a doubt as would govern or control a person in the more weighty affairs of life. If the minds of the jurors, after the entire comparison and consideration of all the evidence, are in such a condition that they can say they feel in the binding conviction of the truth of the charge, there is not a reasonable doubt. Doubt to be reasonable must be actual, not mere possibility or speculation.
Only thing that I heard come out, which not necessarily about her mental health, but I guess however you want to take it, is that she takes some sort of medication for memory loss. And I mean, she's only in her 40s. She's like 47 ish. And I don't know, but that could be due to a lot of different things. Um, I don't know if I don't know what her issues are, but she has some sort of medical issue that she has some sort of loss of memory. And I don't, we don't know what's going on with that. So, we haven't been privy to much, but I'm sure there's something there. We just don't have all of the diagnoses.
You have a reasonable doubt as to the guilt of the defendant, she is entitled to a verdict if not guilty. Instruction number 31. The evidence which you are to consider in this case consists of the testimony of the witnesses, the exhibits, and any facts admitted or agreed to by counsel. There are two types of evidence, direct and circumstantial. Direct evidence is the testimony of a person who claims to have personal knowledge of the commission of the crime which has been charged, such as an eyewitness. Circumstantial evidence is the proof of a chain of facts and circumstances which tend to show whether the defendant is guilty or not guilty. The law makes no distinction between the weight to be given either direct or circumstantial evidence. Therefore, all the evidence in the case, including the circumstantial evidence, should be considered by you in arriving at your verdict. Statements, arguments, and opinions of counsel are not evidence in this case. However, if the attorney stipulates to the existence of a fact, you must accept the stipulation as evidence and regard that fact as proof. You must not speculate to be true any insinuation suggested by a question asked the witness. A question is not evidence and may be considered only as it supplies meaning to the answer. You must disregard any evidence to which an objection was sustained by the court and any evidence ordered stricken by the court. Anything you may have seen or heard outside the courtroom is not evidence and must also be disregarded. Instruction number 32. The credibility or believability of a witness should be determined by his manner upon the stand, his relationship to the parties, his fears, motives, interests, or feelings, his opportunity to have observed the matter in which he testified, the reasonableness of his statements, and the strength or weakness of his recollections. If you believe that a witness has lied about any material fact in the case, you may disregard the entire testimony of that witness or any portion of his testimony which is not proved by other evidence. Instruction number 33. A witness who has special knowledge, skill, experience, training, or education in a particular science, profession, or occupation is an expert witness. An expert witness may give his opinion as to any matter in which he is skilled. You should consider such expert opinion and weigh the reasons, if any, given for it. You are not bound, however, by such an opinion. Give it the weight to which you deem it entitled, whether that be great or slight, and you may reject it if in your judgment the reasons given for it are unsound. Instruction number 34. Although you are to consider only the evidence in the case in reaching a verdict, you must bring to the consideration of the evidence your everyday common sense and judgment as reasonable men and women. Thus, you are not limited solely to what you see and hear as the witnesses testify. You may draw reasonable inferences from the evidence which you feel are justified in the light of common experience. Keep it in mind that such inferences should not be based on speculation or guess. A verdict may never be influenced by sympathy, prejudice, or public opinion. Your decision should be the product of sincere judgment and sound discretion in accordance with these rules of law. Instruction number 35. In arriving at a verdict in this case as to whether or not the defendant is guilty or not guilty, the subject of penalty or punishment is not to be discussed or considered by you and should in no way influence your verdict. Instruction number 36. You are here to determine whether the state has proven beyond a reasonable doubt the guilt of the defendant from the evidence in the case. You are not called upon to return a verdict as to the guilt or innocence of any other person. So if the evidence in the case convinces you beyond the reasonable doubt of the guilt of the defendant, you should so find, even though you may believe one or more persons are also guilty. Instruction number 37. You have seen trial exhibits that have been redacted. Those redactions have occurred either by agreement of the parties or by court order pursuant to Nevada law. You are not to consider the fact that an exhibit has been redacted for any purpose whatsoever. Instruction number 38. It is a constitutional right of the defendant in a criminal trial that she may not be compelled to testify. Thus, the decision as to whether she should testify is left to Ms. Michaels on the advice and counsel of her attorneys. You must not draw any inference of guilt from the fact that she does not testify, nor should this fact be discussed by you or enter into your deliberations in any way. Instruction number 39. When you retire to consider your verdict, you must select one of your member to act as a foreperson who will preside over your deliberation and be your spokesman here in court. During your deliberation, you will have all the exhibits which were admitted evidence, these written instructions, the forms of verdict which have been prepared for your convenience. Your verdict must be unanimous. As soon as you agree upon the verdict, have it signed and dated by your foreperson and return with it to this room. Instruction number 4. During the course of this trial and your deliberations, you are not to, 1, communicate with anyone in any way regarding this case or its merits, either by phone, text, internet, or other means. Read, watch, listen to news or media accounts or commentary about the case. 3, do any research such as consulting dictionaries, using the internet, or using reference materials. 4, making investigation, test the theory of the case, recreating an aspect of the case, or in any other way investigate or learn about the case on your own. Instruction number 41. If during your deliberation you should desire to be further informed on any point of law, or hear again portions of the testimony, you must reduce your request to a writing signed by the foreperson. The officer will then return you to court where that information sought will be given to you in the presence of and after notice to the district attorney and the defendant and her counsel. Playbacks of testimony are time consuming and are not encouraged unless you deem it a necessity. Should you require a playback, you must carefully describe the testimony to be played back so that the court reporter can arrange her notes. Remember, the court is not at liberty to substantive evidence. Now you will listen to the arguments of counsel who will endeavor to aid you to reach a proper verdict by refreshing in your minds the evidence and by showing the application thereof to the law. But whatever counsel may say, you will bear in mind that it is your duty to be governed in your deliberation by the evidence as you understand it, remember it to be, and by the law given to you in these instructions, with the sole fixed and steadfast purpose of doing equal and exact justice between the defendant and the state of Nevada. All right, ladies and gentlemen, we do not want to break up the closing arguments for you, so we're going to take our lunch recess now, and then when you guys come back, we will have the closing arguments by the parties when you return from the lunch recess. During this recess, you must not discuss or communicate with anyone, including fellow jurors, in any way regarding this case or its merits, either by voice, phone, email, text, internet, or other means of communication or social media. You must not read, watch, or listen to news or media accounts or commentary about the case. You must not do any research, such as consulting dictionaries, using the internet.
Y'all, we just it's not in the cards for us to not for us to break off right now, because guess what? They're back. Let's go ahead, finish up the closing arguments. When they let the jury go, what time is it? It's 1:20 something in Vegas. We might get a verdict before 5, their time, 8 o'clock our time. You know what I mean? We might get one tonight. Let's go on ahead and let's soldier through, guys. All right, let's just go on ahead and handle this business. Okay. Can you believe it? How did we catch up? We were 3 days behind and we hadn't done anything special. How did we do it, guys? How did we get caught up? And we've lost some people. But they're going to come back and find out, guess what? We made it through the rest of 6 and into 7, and we're on verdict watch. Okay. All right. Let's just go ahead. We're like maybe 20 minutes behind real time. A little Friday evening LWAP. Okay. All right. All righty, guys. Let's just handle this business. Denise says, yay. Okay, Denise. Girl. Okay, let's go.
We have now reached the portion of trial where closing arguments will be given. Since the state has the burden of proof, the state will get to begin and close the closing argument. State, are you prepared to give your closing argument?
Yes, the smart girl chat. Okay. All right. LWAP loading. Yeah. I'm going to go back. I hate to shame somebody. I'm not going to really shame, but I am going to say you never should have married your stepson, boo. And you never should have married your baby father's son. That's tacky. Marrying your baby father's son is going to take you down doom and gloom alley and bad luck, and it's almost like a curse, just to be honest. You're inflicting a curse of God proportions on you. You know what I'm saying? That's just foul. So, I mean, she already knows she fucked up there. I don't have to say any more about it. You know what I mean? I'm sure when she has a moment in quiet contemplation and she's trying to figure out how did I get here, all she needs to do is think back on some of her life choices. And it didn't start there. But I'm not going to drag her on this Friday. I think she knows. Okay? It's just nasty, right? Okay, guys, I'm going on mute. My bad. Okay. Let's see.
Behalf of the state, we have now reached the portion of trial where closing arguments moves to closing argument. State, are you prepared to give your closing argument?
Yes, Your Honor.
All right, whenever you're ready.
The truth is the truth. It shouldn't change. And the truth is, the walls were closing in on Devyn Michaels and the fantasy that she had put together. And what was her response when her children were taken away? Jonathan had custody, and this was in danger. She did the unfathomable. She murdered Jonathan Millett. The crime charged in this case is murder with use of a deadly weapon. We heard from the judge. She did read that to you folks prior to our break. So what it is willful, unlawful, felonious, and with malice aforethought, the defendant killed Jonathan Millett, a human being, with use of a deadly weapon, be it a wooden stick and/or an unknown object, by striking the said Jonathan Millett with the said wooden stick and/or other unknown object, and/or through other unknown means. The said killing having been 1, willful, deliberate, and premeditated, and/or 2nd, committed during the perpetration or attempted perpetration of a robbery. Let's start with the easy one, the deadly weapon. You heard from the defendant that she hit Jonathan Millett with a stick, and he died. So this is clearly showing that that stick that she described to you is a deadly weapon because it resulted in the death of Jonathan Millett. Now I want to point out something very important that's in your instructions, and it's not something to gloss over. The state is not required to have recovered the deadly weapon used in the crime in this case. So keep that in the back of your mind that we are not required to do that. However, we have the confession from the defendant that that is what she used. So that being said, you'll have your verdict form when you go back to deliberate. So I think it's helpful to sort of walk through that. So based on knowing that there was a deadly weapon used beyond a reasonable doubt, we're able then to eliminate guilty of first degree without, use of a deadly weapon, and also guilty of second-degree murder, and guilty of voluntary manslaughter. So all that we are left are those charges with use of a deadly weapon. Let's talk about murder. Your instructions tell you that murder is the unlawful killing of a human being with malice aforethought. Whether express or implied, the unlawful killing may be effected by any of the various means by which death may be occasioned. So let's talk about malice aforethought. What does that mean? That is the intentional doing of a wrongful act. So I don't think anyone is going to get up here and say that this was not a brutal first-degree murder. Knowing that, defendant's actions were not voluntary manslaughter. Voluntary manslaughter is the unlawful killing of a human being without malice aforethought, without deliberation or premeditation. It is a killing upon a sudden quarrel or heat of passion caused by a provocation sufficient to make the passion irresistible. That is not what we have in this case. The defendant said in her statement to the police, told the police, that she was giving Jonathan a back massage while he was laying face down on his bed. She was next to him. She got up off the bed, made the conscious decision to then walk over to that fireplace that we all saw, grab what she described as a candlestick, an object, right, walks over, makes a conscious decision to then walk over, goes to her bed, and while Jonathan is still face down, with his head facing away from her, as she told us, she took that stick and bashed the victim in the head. He had no clue that this was coming. Conscious decisions every step of the way. His body goes limp. This is not voluntary manslaughter. The instruction also tells you if there should appear to have been sufficient time for a cool head to prevail and the voice of reason to be heard, the killing shall be attributed to deliberate revenge and determined by you to be murder. The defendant did mention that the victim, Jonathan Willett, had rubbed on her leg. And then she kind of just shooed it off. It was like, okay. And then after that, he seemed happy, right? His face was turned away, thought he was getting more of a massage. But instead, the defendant made those conscious decisions that I just went over and bashed him in the head. This is not voluntary manslaughter. So that being said, when you go back to deliberate, you'll have this form again. We've already crossed off the ones that don't apply, so let's cross off the other one. Voluntary manslaughter with use of deadly weapon, because no one's gonna get up here with reasonableness and say that this was voluntary manslaughter. So then what are we left with? First degree murder. You were instructed that murder of the first degree is murder which is perpetrated by means of any kind of willful, deliberate, and premeditated killing. What are those three elements? Willfulness, deliberation, and premeditation. And I do have a graphic photo here, so I just want to warn everyone, including in the gallery, that there will be a graphic photo. This is first degree murder. What is willfulness? Willfulness is the intent to kill. There needs to be no appreciable space of time between formation of the intent to kill and the act of killing. What is deliberation? Deliberation is the process of determining upon a course of action to kill as a result of thought, including weighing the reasons for and against the action and considering the consequences of those actions. This is very important, and I am going to spend some time on this. A deliberate determination may be arrived at in a short period of time. The best way to illustrate this is the stoplight example. So all of us drive to work, we're on our way to work, and there's a stoplight. Sometimes that stoplight turns yellow. And when it's yellow, you're making some conscious decisions at that point, right? Either you're taking the decision to press on the brakes, but during that you're deciding, well, is someone gonna rear end me, right? If I just stop on my brakes, right? Is my coffee that I just bought from Starbucks gonna fly all over the car and I'm not gonna have coffee at work if I slam on my brakes? Is my purse gonna fly off the seat and I'm already running late for work? So how am I gonna have time to put all the items back in my purse so I can walk into work? If I press on the brakes, I'm going to then potentially be late for work. And I've already been written up a couple of times, so this may be the time of fire. All of this is going on in your head when you're faced with that yellow light. You're also thinking, well, I obviously can't press on my brakes, right? So I'm gonna have to blow through this light. But what are you thinking about when you're going, making the decision to run that yellow light that's about to turn red? You're hoping there's no cop, right? You're hoping that a motorcycle doesn't come out from nowhere and you hurt someone. You hope there's no bicyclist that's just somehow hoping that you're gonna stop at the red light because they see that it's yellow. All of these are conscious decisions that you're weighing, and that is all deliberation in a short period of time. We do it every day. Again, it need not be for a day, an hour, or even a minute, this premeditation, this decision-making. It may be as instantaneous as successive thoughts of the mind. The stoplight example. No matter how rapidly the act follows the premeditation, it is premeditated. That is what happened in this case. When the defendant made each conscious decision ending Jonathan Willette's life. We also have another theory of first-degree murder. That's called felony murder. There are certain kinds of murder which carry with them conclusive evidence of malice aforethought. Therefore, a killing which is committed in the perpetration or attempted perpetration of a robbery is deemed to be murder of the first degree. So what is a robbery? You are instructed that robbery is the unlawful taking of personal property from the person of another, or in his presence against his will, by means of force or violence or fear of injury, immediate or future to his person or property, or the person or person or property of a member of his family. Such force or fear must be used to 1, obtain or retain possession of the property, 2, to prevent or overcome resistance to the taking of the property, or 3, to facilitate escape with the property. We heard a lot of evidence over the past 2 weeks, which is why I'm slowly going through this today. We have evidence that the defendant took multiple items of Jonathan's belongings. Social security card, a wallet, his only set of car keys. Why did she want those things? How was she going to enroll the girls at school without having Jonathan's documentation? This all goes into her motive. The defendant obtained Jonathan's property by means of force or violence, i.e., she killed him, and took his wallet, his only set of keys, and his social security card. This is another easy one. That being said, you'll have your verdict form. And between both theories of murder, we are confident that you'll be able to check that first box and at this point eliminate the second-degree murder. But that being said, any way you look at this case, this is first-degree murder. And this is important to note, because when you go back there, you're doing an important thing. But what is also important is that while a guilty verdict must be unanimous, you need not be unanimous on the means or the theory of first-degree murder in arriving at your verdict. What do all those words mean? That means when you go back there and you're carefully weighing the evidence in this case, if 6 of you decide that the state has proven beyond a reasonable doubt the felony murder theory, and 6 of you decide that it's the premeditated deliberate, that doesn't matter. The verdict would be guilty of first-degree murder. You need not be unanimous on the theory of first-degree murder. So there's been a lot of talk over the past 2 weeks about Devyn, and we're not shying away from this. You saw him testify on the witness stand. There is overwhelming evidence beyond what he told you that Devyn did not murder his father. Let's go through that. We'll start with Devyn's testimony under oath. He tells you that he saw his father, Jonathan Willette, at that Porcupine Lane address, the house that he and Devyn shared, briefly on August 6th. You'll recall that he saw his dad in the garage and just went right back inside. They never had a discussion. And he was home at the Porcupine Rim address on August 6th. He told you that he was helping the girls, his sisters, Devyn's daughters, with homework. The defendant, Devyn, tells him that she's going to help John move some things. He goes on about his night. He stays at the house, he watches a movie with the girls, he puts them to sleep. This is what he's telling us. He goes to sleep around 10 p.m. He woke up, he recalls around 2 a.m. to see Devyn getting in bed, which they shared at that time, and he just went back to sleep. He woke up at 6 a.m. the next morning on August 7th. He gets dressed, he goes to work. Even if you don't want to take his word for it, which we believe you should, we also have other evidence to corroborate what Devyn told you. This is a text message that Devyn sent to the defendant, Devyn Michaels, where he texted her, "See you when you get back. I'm going to sleep. Girls are in the living room." Corroborating that he put the girls to sleep and he was going to sleep as well. This was on August 6th, 2023 at 10:36 p.m. We also have video surveillance to corroborate this. No video surveillance shows Devyn's vehicles in Paladura's neighborhood. Paladura being the murder house neighborhood. No vehicles belonging to Devyn are seen. And we spent a lot of time going through that video surveillance on that lengthier data trial, showing you that there is no indication that Devyn's vehicles are in that neighborhood on the night of the murder. There's no video surveillance showing Devyn's vehicles entering or exiting Porcupine Rim neighborhood, the neighborhood he lives in with Devyn. Remember that fixed camera? There was no indication that his vehicles left that evening. Or entered, for that matter. Devyn's vehicle was in the same position overnight. You recall there was sort of that catty corner home that had that footage showing the daytime and the nighttime, and the van, Devyn's van, remaining in the same position, to a T. There's also no video surveillance showing Devyn jumping a back wall to get in another vehicle. There is no evidence of that. What we do have is Devyn leaving in his work van at 7:31 a.m. on August 7th, because that's what happened. We also have the CDR mapping, which also rules Devyn out. Beyond his word. If you recall, there was that Detective Good testified pretty all Devyn was green. We see green popping up at that Porcupine Rim Street, which is his home, throughout the night, and more importantly, during the time period of the murder, which we'll talk about later, because we are able to narrow that down. At no point do we see Devyn at the murder house the night of the murder, and even more importantly, during the murder. Again, I explained this, I just want to show it. This is that footage of the nighttime. We see, if you recall, up in that top right hand corner, we see the victim's truck, Jonathan Willette's truck. We also see right next to it, Devyn's work van. This is the night of August 6th. This is the next morning of August 7th. There's that same work van, Devyn's work van, in the same position. Nighttime, daytime, nighttime, daytime. Never changing. Physics also ruled Devyn out. A lot of discussion about how he jumped the back wall, he took the road that's one house over that, not the road, but the little dirt path, right, to get all the way across town. 7.5 hours? No. That's not common sense. I also think it's important to highlight Devyn and the defendant's relationship, Devyn's relationship. Devyn is a master manipulator, and that is shown through the evidence. This is a woman in her late 30s that decided to begin a sexual relationship with her 19-year-old stepson, who had just lost his virginity. I'm not going to get up here and say that the 19-year-old teenage boy, this wasn't his dream to be with Devyn Michaels, who was an older, more sexually experienced woman. But what I am going to say is that the defendant is the one running the show here. This was her fantasy, and he went along with it. For a while though, because remember, he tried to move away to California on multiple occasions, and somehow she was able to spin her web and bring him back. The most glaring portion being when she uses a supposed pregnancy against Devyn to bring him back to Las Vegas. When she threatened him, I will have this baby and tell everyone whose baby it is if you don't move back to Las Vegas. So what does young Devyn do? He moves back to Las Vegas. He doesn't want a kid at his young age, and even complicate his relationship with his family that doesn't know about their relationship or their sexual engagements. There's also messages that show that Devyn was in charge of this relationship. He tried to get out multiple times. So now that we've talked about this could not be Devyn, let's talk about who's on trial today. Devyn Michaels, the defendant, and how there is overwhelming evidence that she committed first-degree murder. I'm going to go over a roadmap of all the different evidence that you heard in the past 2 weeks and sum it up as much as I can. We'll start with Yoko and Yoshida's testimony, Devyn's inconsistent statements, so her own words, the scene, the DNA, the burlap, which we heard about today again, CDR mapping, video surveillance, the phone contents, and we'll also talk about the custody case and those witnesses we heard yesterday. I think it's very important to start with the timeline because, as Mr. Giordani said, this one's a wild ride and we have to buckle up. So let me start with the timeline here. The timeline starts August 6th of 2023. Devyn, John, the girls, they're all shopping for the girls' first day of school. At 8 p.m., Devyn arrives at the murder house in her vehicle, and Yoko confirms this. At 8:42 p.m., Devyn, the defendant, and John drive to Devyn's home. At 9:40 p.m., Devyn and John drive back toward the murder home. 10:04 p.m., Devyn and John they get to Chevron. They're there for a few minutes, as we saw, and then return back to the Palo Duro neighborhood at 10:12 p.m. And that's even confirmed by Yoko saying that she saw Devyn and John, and that's when John began to prepare a meal for himself. At 11 p.m., a person places something in the Nissan Armada, Devyn's Nissan Armada, moves the Armada in front of the murder house. And what's notable about that, and I think it's important to highlight, is it went from being in front of the camera to being out of the camera, but more importantly, closer to the house, right in front of the driveway, and nose to nose with Jonathan's truck, which we see was in the same position the next day based on the surveillance, as well as the testimony from the officers in this case. We then turn to August 7th, 2023. At 1 a.m., Yoko runs into Devyn for about 15 minutes or so. At 2:04 a.m., Devyn leaves the murder home in her Nissan Armada. At 2:39, she's at that CVS drive-thru that we saw the surveillance video for. And then at 8:40 a.m., there is that 911 call from Jonathan's mother when she discovers her son dead. We can then safely say on this timeline that the murder that Devyn committed occurred between 10:12 p.m. and 2:04 a.m. So knowing this time frame, we're able to look at the corroborating evidence. Let's start with Yoshida's testimony. The day before the murder on August 6th, he sees Devyn at the murder house. And more importantly, he also saw her vehicle at Palo Duro. We heard from Yoko. Again, around 8 p.m., Devyn arrives at Palo Duro. in her Nissan Armada. Devyn and John then leave in John's truck. Around 10 p.m., Devyn and John return to Taladura. Yoko sees them. After seeing them, she goes upstairs. At 1 a.m., she goes back downstairs. She runs into Devyn, and what did she describe to you? Devyn looks surprised. Why? Importantly, Yoko also says that the light was on in John's room. Of course, you also heard that the way the bed was situated, you would have to walk into the room, down, and go around to actually see the bed. But regardless, she sees that the light is on in the room. Devyn tells her that John started drinking and he went to bed. Yoko told you that she didn't hear anything from John's room. The light was on. Didn't really think anything of it. And that she and Devyn talked and washed dishes for about 15 minutes. Because that's when Devyn told her that Jonathan, the next morning, was going to meet her with the girls, and they were going to go ahead and go enroll the girls at school and take them to school. She confirmed to you that there were only 4 people at the home. Yoko, Yoshida, Devyn, and the victim, Jonathan. At 1:15, she goes upstairs. She goes to sleep after having that conversation with Devyn. Around 2 a.m., she wakes to the dogs barking in the backyard, and if you'll remember, that was abnormal. The dogs, when John was asleep, or at night in general, were not in the backyard. So why were they in the backyard barking? She also heard a thud. She then goes back to sleep. At 8 a.m., she goes downstairs, sees John's truck is outside, which is a little weird because Devyn had told her that the plan was for him to already be gone by that time in the morning to go enroll the girls. So her antennas were up a little bit. She calls him, calls John, he doesn't pick up, prepares her coffee, goes back upstairs. She called him again, no answer. So now her senses are heightened even more. So she goes back downstairs. She looks around John's room, couldn't see him, because again, the bed is sort of around that corner, as you saw in the photos. She then goes upstairs again. After going upstairs, again, feeling even more heightened concern, she goes back downstairs. And it's at this point she goes deeper into John's lower room, a makeshift bedroom. She sees the doggy door is down and the dogs are still outside. Abnormal. She saw inside the garage door was half open, the one leading into the garage. Abnormal. The big garage door was open as well, as you all saw in the photos. It had an opening there. Abnormal. So then she investigates more. She goes to his bed, and she sees John wrapped in a blanket. She opens the blanket, and she saw feet. She then goes around to the other side of the bed and sees the amount of blood that's on the other side. Goes upstairs, tells Yoshida, they call 911. Devyn also made several inconsistent statements. The truth is the truth, it should be changed. What were those inconsistent statements? The first one, Jonathan's engagement ring. If you recall in interview 1, Devyn tells the officers, we threw his engagement ring in the trash last night. Okay. Interview 2, threw away John's engagement ring. We kind of made a joke of it, 2 points, threw it in the trash type thing. So it should be in the trash, right? We saw pictures of the trash, of multiple trashes in the Paladura address. Not just one, but multiple. 1, 2, 3, 4, 5. None of them containing a ring that were searched by officers. Ladies and gentlemen, there was no ring that was thrown in the trash. Inconsistency 2. Her marriage to Devyn. We learned from interview number 2 that this was a marriage of convenience, not intimacy, which we know is not true based on other evidence in the case. Interview number 3. Her marriage to Devyn is just on paper. Rings aren't significant. Me and Deb haven't been intimate in years. That's not true. Inconsistency 3. The gun safe. In interview number 1, Devyn tells officers, "We took the guns last night, but we didn't bring ammunition because there's no safe at my home for them." Ladies and gentlemen, we saw pictures of a safe. There was a gun safe in the home. There's a close-up of it there. And there's guns and ammunition. Gun safe in the home. No safe. Inconsistency 4, Jonathan's wallet. In interview number 2, she tells officers, John lost his wallet yesterday. He leaves stuff around a lot. Minimizing. Then we have interview number 3, which is after the search warrant of Porcupine Rim, where they start to confront her with the fact that there's Jonathan's items in there, more specifically his wallet. She tells them, at first, nothing of John's is in my house. John's wallet wasn't at his house, so do you know where it is? No, sir. I have all of his old driver's licenses. The license you found is an old one. We know that's not true. I tucked the wallet away in bags. I knew, but how would she know that the wallet was wrapped in bags in her underwear drawer? She wasn't confronted with that. Nothing of John's in my house. There was. His only set of car keys. His current driver's license. His wallet. And what was found inside her purse? Jonathan Willette's social security card. Why would she have those things? But nothing of John's at her house. Again, the license you found is an old one. And if we look here close up, it expired November 7th of 2025. The murder happened August 7th of 2023. This was his active driver's license. His old one. I tucked his wallet away in bags. Remember, ladies and gentlemen, this wasn't one bag. This was 8 bags, and you heard in the interview with Detective Weinoff that were tied over and over and over and over again. Not just one bag. What was she trying to hide? Also, how would she know? Inconsistency 5. Where was John? In interview 1, she tells officers that John was in the garage, awake, smoking when she left. He was smoking when Yoko came down. But remember, Yoko said Devyn told her John was sleeping off his alcohol. So which one is true? She says she said goodbye to him, pushed out a box under the garage, went out the front door. Then the next interview, last thing she did with John was pop his back. He went to smoke. She talked to Yoko. She finished loading. He told her what to take, and that was it. All inconsistent. And not the same story. Inconsistency 6. John's bloody phone found at Devyn's home. There's a lot of discussion about this during the trial because it's important. And it shows that Devyn committed the murder. And why? First of all, she told us in interview number 3, he told me he cut his hand. Okay? He said he was moving a table and one of the parts fell and took a chunk of his hand. She offers this to police. I didn't see it, but I do know he mentioned bleeding on his hand. Very descriptive. Then interview number 3. He must have been smoking and set his phone down. Again, no notifications are found on John's phone, as if someone manipulated it. Because as we know, John was called and texted multiple times, especially when people were trying to find him. Why would he have no notifications on his home screen? That's because the phone wasn't left by John. You know that his blood was on the phone. And we know that it arrived after the murder based on those CVRs. Based on that raw data, we know when John's phone made it to Devyn's residence. And that's when she took it there because, as you know, it traveled with her after she committed the murder back to her home. This is also an important one. She tells detectives that it was dark in the room and she couldn't see when she committed the murder. In interview 4, we finally get her confession. She hit him. And that's when we get the details. But she tells us that she couldn't really see what she grabbed off the fireplace because it was dark, but she could see him breathing. She tells the detectives, because they're a little confused by that statement, because she can't describe the object in her very hand, but she's able to see Jonathan breathing. She tells him, well, your eyes can adjust. And remember, Yoko said the light was on in John's room when she came downstairs. It wasn't off. It's also important to note that he was wearing boxers. He had his boxer briefs on, she tells the police. And we know that's not true. The boxers were found at the foot, next to the side of the bed, as shown right here. She also can't really account for the time after seeing Yoko at 1 a.m. And this one's really important. In interview number 4, she initially tells detectives, well, I wasn't there for an hour after Yoko came down. That's not true. But then she's confronted that no, there is evidence that you were in fact there until 2:04 in the morning. So detectives trying to solve this case for the family is asking, what were you doing? What were you doing in that time frame? She remembers every detail before. She remembers every detail after. You heard the interview. But she doesn't remember this time frame. Why? Because she did it. She was decapitating Jonathan. I can't remember. I remember talking to Yoko, getting my stuff, leaving, going to the pharmacy, and going home. But she doesn't remember the time frame that she was decapitating Jonathan. Why? She's told this has got to be eating you up. And this is why videos are so important. This is her response.
This has got to be eating you up. gotta be eating you up.
She's nodding.
This has gotta be eating you up.
This is eating her up.
This has gotta be
What?
eating you up.
Ladies and gentlemen, she admitted to the murder. She said in her interview, when she confessed, that she took that object, the stick, the wooden stick, and bashed Jonathan in the head. That is the murder. But there was a head missing, and that was important to the detectives to give closure to the family. So what about the decapitation?
Well, you have to have something for the outer 4 minutes where you were in the house. That's it. That's the only time that you don't remember.
I didn't know I was there that long.
It doesn't matter if you don't.
That's what I'm saying, I don't remember being there that long, I didn't know I left.
Okay, so is it possible you did it, you don't remember?
Yes, sir, it is very possible.
Okay.
Yes, sir, it's very possible. The scene does not lie. Defendant can lie, but the scene can't. So what's the hard evidence as well, in addition to her statements that are inconsistent, other than the confession? As we know, John was found on this bed, and there was blanketing. And we also noticed that there were 2 blood spots specifically on that sheet that he was wrapped in. One on one side and one on the other, as you can see in that right-hand photo. She rolled him to the edge of the bed to complete the decapitation after she had realized she murdered him by hitting him, as evidenced by the 2 blood spots that we see there. In that last interview as well, there was a drawing, there was a diagram, there was a sort of a back and forth a little bit with the defense talking about that the detective was the one drawing, but I will leave it up to you to sort of see how that was going down. Devyn drew that line there, and the detective told her multiple times, correct me if I'm wrong, is this where you were, where the X is? Yes, that's where I was. She drew him in the exact position she left him in. There's some truth. The DNA can't lie. We heard that Jonathan's cell phone was found at Devyn's house during that search warrant of the Porcupine Run residence. And we heard from CSA Nicole Merriam, who testified twice, that she swabbed that blood spot right there on the phone, and the testing revealed presumptive positive for blood. It also revealed Jonathan's blood. It's also important to note that Jonathan's blood was found in the driveway of the residence. We have that marker A, which you can see there, the blood spots with the cone. And we also have marker B, which was that Jonathan's bed frame, where they saw those droplets of blood. All Jonathan's blood. It also is interesting where these blood spots are, because they're in the driveway in the same exact place Devyn would have walked to go back to her vehicle to drive home, as we know occurred at 2:04 in the morning. Devyn's DNA is on that knot of the plastic bag containing the wallet and John's only car keys. They also tested inside and outside of the wallet, including all the pocket openings. So the inside of the wallet also contained Devyn's DNA. This wasn't Jonathan dropping it in a bag. Why would Devyn's DNA be inside the wallet? Devyn and John's DNA are on his social security card swab. Not shocking that Jonathan's DNA is on his social security swab. or social security card, I should say. But remember, this is Devyn's bag. You see her wearing it in the surveillance video with the chevron. She also described it to police during one of her interviews. And what's found inside is that social security card belonging to Jonathan Millett. And not only is it found, but it's found with the defendant's DNA on it. She handled it. She wanted to enroll the girls at school and knew that she needed documentation because the father of the children was dead. We also heard from the coroner, Dr. Yagi. The cause of death, homicidal violence. The manner of death, homicide. The internal exam, and this is important, decapitation occurred post-mortem. Jonathan was decapitated by the defendant after she bashed him with the stick and killed him. Based on the science. No one's disputing that, not even Dr. Sims today. This is also important. No bleeding injuries on John's hands were found. None. She did discuss slippage, which she explained what that was, where, after death, the skin tends to shed a bit in different areas. But again, no bleeding injuries on John's hands. Then we had testimony from Dr. Burns, who passed around those cool exhibits. Cass, I should say. And she explained that there were 2 implements used to decapitate the victim. As you can see in the picture there, this is her annotated version showing that there were 2 implements that were in fact used. A hand-powered serrated or non-serrated knife was the first. Then a mechanically powered saw, because it's very difficult to cut through human bone. Not only did Dr. Yagi and Dr. Sims agree today, but also Dr. Burns told you that the impacts that she saw on the neck were consistent with post-mortem dismemberment. Jonathan's head was decapitated after he was murdered. There's a lot of discussion during trial about whether it's possible for a woman to do this. I think it's important to note, as Dr. Burns highlighted, a mechanical saw is made for anyone. Women can do anything, especially ones that have a clear motive. Moving on to the burlap. Where was Devyn's vehicle during all of this? Her Nissan Armada shows she's at Palo Duro during the time of the murder. We have at 11:05 p.m., there's that short activation that we saw on the burlap, which I'll go ahead and play for you. And it is not very long. It's at 11:05 p.m. on that August 6th, 2023. Which is corroborated by the video surveillance where we see her vehicle moving up right in front of the driveway of Palo Duro, nose to nose with Jonathan. Then we have 2:04 a.m. This is when Devyn's Nissan Armada leaves. And we saw that in the burlap. She goes from the Palo Duro address, she goes to CVS, then she returns home to the Porcupine Rim address. I won't play this all for you, you'll have this back at evidence. You've seen it during the trial. We also have that call detail record mapping. Where was everyone's phones during all of this? More importantly, where was Devyn's phone during this? And we had Detective Good testify that the defendant's phone was at the murder scene when the murder was occurring. And what's also interesting to note, which you kind of have to get close to see, but there's sort of this blue dot that is now traveling with Devyn's red device all the way back. And this was at that 2:04 in the morning. So that's how we know that the victim's phone was taken by Devyn back to her home, because we have that Google geofence highlighted by that blue dot there of Jonathan's phone, showing when it actually got to Porcupine Rim, and that's when Devyn got it. We also heard phone content evidence, which demonstrates Devyn's intent in this case. I worry as much as you probably won't believe. I miss us. I'm glad you appreciate what we once had. We will have it all again, Jonathan says. I want our family back. We gotta do as great as we can for the girls to have a good life. The walls were closing in. We have the video surveillance that was played for you in depth during trial. And there's some important notes from that. We saw how much video surveillance was canvassed in that Caladura neighborhood. There was a point where the detective even said he couldn't pinpoint the address that I needed him to because of all these contacts. Then we have that next door residence to the murder house, that 2696 Caladura Drive. Again, next door. And this is that video I talked about earlier where we do see the Nissan activated and we see it move in front of the driveway of the murder home, 2698 Caladura. We also see in this vantage point of the video when Devyn and the victim returned home from that trip from Chevron. When they were coming from Porcupine Rim, stopped at the Chevron, got some items, then came back, and we actually saw those shadows of two figures, which would be Devyn and Jonathan, getting out of his truck to go inside of the Caladura residence. This camera gives us that as well. And again, 11:05 p.m., we get that activation, and we see that the Nissan Armada is moved up closer to the residence. Why would she want to move it closer to the residence? She's concealing her crime. Then at 2:04 a.m., we also get from this residence that the Nissan Armada leaves, putting sort of a bookend on the timing of the murder. We then have the video surveillance from the Chevron. We've also called it the Terrible Herbs. And in there, I talked a little bit about this. We have that they're there at 10:10. That's Jonathan's truck pulled by a trailer. They then leave at 10:11 p.m. And we know that Yoko, as well as the video surveillance from the Caladura neighborhood, they're arriving into that neighborhood around 10:12 p.m. All corroborating, giving us our time frame. We have the video from the CVS pharmacy, the drive-through, 2:28 a.m. on August 7th of 2023. This is after the murder, where she's at CVS. Again, giving us a time frame. There's no one in that vehicle but Devyn. You can see with your eyes. We then have the 6621 Gray Juniper surveillance video camera from Devyn's neighborhood. This is that one that was fixed where you could see the only entrance and exit of the Porcupine Rim neighborhood, and it was constantly running. we were able to see different things from that. Remember, it was 3 minutes slow to real time, but accurate. At 8:57 p.m., we have John's truck entering the neighborhood. And this is on August 6th. Then at 9:29 p.m., John's truck leaving the neighborhood, further corroborating the timeline. Then importantly, at 2:39 a.m. on August 7th, after the murder, we see Devyn's Armada and Devyn returning back to her residence. At no point was Devyn or Devier's work truck or that sedan seen entering or exiting. Very important. We don't see his work truck or any of his vehicles leaving until 7:31 a.m. on August 7th. So now let's talk about Devyn's motive and intent, which is very important to consider. We heard from individuals that knew about the child custody case during this trial. And they told you that Jonathan had been given full primary physical custody of the two girls, Tamea and Jamea. And this happened on October 27th of 2022. So at the time of the murder, Jonathan technically still had full physical custody of the girls. He had something he could hold over Devyn's head. The walls were closing in on her. We also heard from Elizabeth Lemons Woods, who also had worked on the child custody case and sort of the placement of the girls after Devyn was arrested. She meets with Devyn on August 17th of 2023. She wants to tell the defendant, hey, heads up, I just want to notify you, the girls are being placed somewhere else because you're not there and their father is no longer around. And what Elizabeth Lemons Woods testified to is that defendant then started giving her more information, more than the scope of what the original conversation was supposed to be about. And what I think is notable is that Elizabeth says that throughout the conversation, Devyn appeared that she was trying to cry. Why would you try to cry? Devyn said during this same conversation, she had to do it. She had to do it. Now, ladies and gentlemen, it's very important, and you're in fact instructed on this, to use your everyday common sense and judgment as reasonable men and women. Do not check your life experience and what you know to be true at the door. Bring that with you when you deliberate. The evidence in this case is overwhelming. It's hard, and Mr. Giovanni hit the nail on the head when he said, buckle up, this is a wild ride. This is unfathomable. But this is what happened. We are confident as the state that having all of this evidence in front of you, that you are going to go back to that jury room and you are going to check guilty of first-degree murder with the use of a deadly weapon, because the defendant committed first-degree murder under both theories: premeditation, deliberation, and also felony murder. Thank you.
All right, ladies and gentlemen, we need a moment to set up the technology for the defense's closing argument. We're going to take a brief recess. During this recess, you must not discuss or communicate with anyone, including fellow jurors, in any way regarding this case or its merits, either by voice, phone, email, text, internet, or other means of communication or social media. You must not read, watch, listen to news, or media accounts or commentary about the case. You must not do any research, such as consulting dictionaries, using the internet, or using birth materials. You must not make any investigation, tests, and theories, case, recreating aspect of the case, investigate the rest of the case on your own, unless there's more pressing anything in regard to the case of time. Thank you. Ladies and gentlemen, 2 o'clock will be recess till 2:15. All rise for the jury.
Okay, I'm just going to say really quick, I liked that visual. So basically, she kind of, like when you go vote and they show you how to fill out your voter card. It's like she did. I mean, nothing else makes, based on her admission and the evidence provided, there really is no choice other than first degree premeditated. What was loud? There's no other choice. So, anywho, I'm going back on mute, and I think they're back, aren't they? Yeah, okay. Yeah, he reminds me of Josh Hamlin from Hamlin McGill, which is a fictitious law firm from the classic TV show Better Call Saul. Well, and Breaking Bad.
7239 State Nevada versus Devyn Michael. Waive the right to inspect Ms. Michaels is present with her attorneys. Deputy District Attorneys on behalf of the state. We both parties speaking in the presence of our jury.
Yes, sir. Yes, Your Honor.
Okay, Mr. Justice, are you prepared for your closing argument?
Yes, Your Honor. Thank you.
Whenever you're ready.
Thank you. This case is entitled the State of Nevada versus Devyn. Proof beyond a reasonable doubt is the highest standard in the American justice system. It shows an adoption of a belief that we took from the old common law from England, that it's better to let 10 guilty men go free than to wrongfully convict an innocent person. I would also submit to you that it shows a belief and an understanding from the founding fathers that very few people have the resources, the opportunity, or the ability to prove their innocence. You've seen that through the course of this trial. You have officers come in, collect evidence, and officers are people. I'm not going to stand before you and say this officer's a bad person. We talked about it through jury selection. But officers make mistakes. People are subject to biases, to confirmation bias, where they reach a conclusion first and then kind of work backwards. And I would submit to you that that is what happened in this case. And our founding fathers understood that. And that's why they placed the burden upon the state and the state alone to prove its case, each and every element of its case beyond a reasonable doubt. I'd like to talk a few minutes about the jury instructions. We had a few technical difficulties, but you all have the same packet. I'd like to discuss just a few of these instructions. I'm not going to tell you which boxes to check. You're smart. You paid attention, very close attention throughout the entirety of this trial. You are the sole judges of the facts. You alone will decide what will happen to Devyn Michaels. Instruction number 3 talks about murder with use of a deadly weapon, and that's what the state wants you to convict her of, first degree with use. But the pleading document is telling. Instruction 3, it states murder with use of a deadly weapon. Did willfully and lawfully, feloniously, malice aforethought, kill Jonathan Black, a human being, with use of a deadly weapon, to wit, a wooden stick and or other unknown object. By striking the said Jonathan Willett with said wooden stick and or other unknown object, and or through other unknown means. And then it lays out the mental state. It has to be deliberate, premeditated, or of all things committed during the perpetration or attempted perpetration of a robbery. The following instructions in this packet lay out, after you've assumed that Devyn has killed somebody, her mental states. Instructions 6 through 16 talk about all the different mental states required. That's after you've determined that this person did the killing. There's even a number of instructions concerning robbery. It's instructions 17 through 20. You see, in the state of Nevada, we have what's called this felony murder rule. It's a shortcut. It's maybe basically getting to the shortest distance between 2 points to convict her of first-degree murder. There are, however, other instructions that I would like to spend a little more time on. And again, you are the sole judges of facts. You will review these instructions. But unlike us who had this case for some time, this case is new. You were introduced to this case when we all met and began talking at the beginning of last week. There is an instruction concerning expert testimony, instruction 33. Please look at that. There's a common sense instruction. And I'm going to flip to that. It's kind of telling. Both parties generally point to this idea of common sense. Again, shows the wisdom. Instruction number 34. Although you are to consider only the evidence in the case in reaching a verdict, you must bring to the consideration of the evidence your everyday common sense and judgment as reasonable men and women. Thus, you are not limited solely to what you see and hear as the witnesses testify. You may draw reasonable inferences from the evidence which you feel are justified in light of common experience, keeping in mind that such inferences should not be based on speculation or guess. A verdict may never be influenced by sympathy, prejudice, or public opinion. Your decision should be the product of sincere judgment and sound discretion in accordance with these rules of law. As I go through my comments, and trust me, I'm going to leave things out. It's inherent in the process. Please use your common sense. You've taken good notes and you've paid attention. Please review the exhibits and don't take my word or that of the state of Nevada. Reach your own conclusions. Review the evidence. There is an instruction that I think is of paramount importance in this case, and it's instruction 32. It concerns the credibility or the believability of a witness should be determined by his manner upon the stand, his relationships to parties, his fears, motives, interests, or feelings, his opportunity to observe the matter to which he testified, the reasonableness of his statements, and the strength or weaknesses of his recollections. If you believe that a witness has lied about any material fact in the case, you may disregard the entire testimony of that witness or any portion of his testimony which is not proved by other evidence. I read this instruction to you with Devyn in mind. You know, we started this case talking about motivations. Motivations dictate actions. Devyn is not on trial. You know, this case is not going to be, well, did we prove our case against Devyn better than they proved their case against Devyn? Devyn is the only person that's on trial. We have gone through the evidence in good faith, and I'm going to discuss that a little bit with you today in my summation, that there is evidence to believe that Devyn committed this crime. But you don't have to believe that to acquit my client. But I would submit to you that you should take that into consideration. The ultimate determination that you will make is the sole judgment of the facts, whether the state has proven this case beyond a reasonable doubt. Through the course of this case, and as you know, when we talked about it, we wouldn't have to ask a single question, present a single line of testimony. State fails to prove their case, she's entitled to a verdict of not guilty. But as this evidence has unfolded, I would urge you to see that perhaps the detectives in this case, the Henderson Police Department, were basically trying to choose the shortest distance between 2 points. I mean, hey, we knew, and we all know, and we're not making issue that she was with him on the night in question. It's easy to reach a judgment like they did. She's guilty. But you, as jurors, must consider all of the evidence. Because unlike when you read in the paper, so-and-so's caught, oh, and you think, yeah, he's guilty, she's guilty, you determine whether a person is guilty, not the police and not the state of Nevada. I would urge you to read the reasonable doubt instruction. A defendant is presumed innocent until the contrary is proved. This presumption places upon the state the burden of proving beyond a reasonable doubt every element of the crime charged and that the defendant is the person who committed the offense. And again, this is why we have addressed what the evidence reasonably shows concerning Devyn. A reasonable doubt is one based on reason. It is not mere possible doubt, but is such a doubt as would govern or control a person in the more weighty affairs of life. And what more weighty affair of life do you have than to sit on this jury on this type of charge? If the minds of the jurors, after the entire comparison and consideration of all the evidence, are in such a condition that they say they feel an abiding conviction of the truth of the charge, there is not a reasonable doubt. Doubt to be reasonable must be actual, not mere possibility or speculation. If you have a reasonable doubt as to the guilt of the defendant, she is entitled to a verdict, not guilty. Since this is a charge of murder, I'd like to begin my comments, and I won't be long. I mean, we've been here a long time, but this is important. Let's begin at the autopsy. We had Dr. Sims. He was the lead coroner here in Clark County for 19 and a half years. You heard his testimony. It wasn't much of a cross because he didn't say much to be disagreed with. We did, however, hear from Dr. Yagi. Do you recall the question that was posed to her? Would you agree with me that a decapitation is difficult to effectuate? Remember her answer? I don't know, I've never done one. We heard from Dr. Sims that yes, it would be difficult. It takes a lot. It's involved. Dr. Yagi missed the tattoos. It was in the report. We had Oriental John. That kind of goes to the weight that you should give her testimony and the thoroughness of her examination of the body. The state's relying upon Dr. Yagi's statement, her testimony that there was no injury on the hand. You got to consider the source. Dr. Sims testified that the cause of death cannot be determined without evidence of injury, and he was talking about standard practices. Obviously, these are very suspicious circumstances. In fact, if John was murdered, it's very reasonable to assume, common sense would dictate, that the person that killed him decapitated him. And through the course of this evidence, they have not shown a scintilla of evidence that she was involved with a decapitation. She didn't do it. Determination of homicidal violence cannot be used when in large part that fatty liver or drugs and alcohol are present. He was talking basically about industry standards, what experts in this field collectively agreed upon. And we saw a variation in this case from Dr. Yagi. In this case, we did have a combination of all three. You heard the testimony about 20 times the level of THC, alcohol in the body. 0.02 was the alcohol in the blood, but Dr. Sims testified that that in conjunction with this high level of THC would cause a person to be intoxicated. That's important in this case because you will hear testimony concerning her concern, Devyn's concern about not letting him drive. As you recall, we went through all those texts beginning back in 2018 concerning Yoko's concern. And again, I don't want to speak ill of the dead, and it was no showing of disrespect towards her, but it was an ongoing concern that she had. She didn't want her son driving drunk, and that concern was shared by Devyn. She had his key. She took the key to the house. That's not evidence that she committed a murder. This is extremely important, and there's been a great deal of issue made concerning this video evidence. As you recall, through the course of Devyn's testimony, I read it to you at the beginning of the trial and read it to him, where basically we had a detective, it was the 12th of September, telling him, you're under the radar. We're here to clear you. I mean, when you look at the radar, when you look at this net that was cast, it has so many holes in it. The state would have you believe that both homes were under 24-hour surveillance. It's just not true. The evidence of Detective Lippisch and the other detectives showed that. The state expects you to accept representations made by Detective Lippisch regarding the true time of the videos from this residence. And I want to start there. This concerns the state's timeline, which I would tell you flies in the face of common sense. But it's important to take into account how this evidence was gathered. You recall the list of times or the videos that were shown? He supposedly didn't, it was on a neighbor's cell phone. We saw no logs. We saw no indication of the veracity or the accuracy of those times. The state's basing this idea that she's pulling up in front of the Talavera residence and is somehow moving her car at 11:04 to avoid detection. You have to take this detective at his word. And again, I'm not necessarily saying he's lying, but he did a sloppy job of collecting that evidence. And this is the video evidence that I'm referring to. Remember, there was no embedded data here. We don't have time. He would have you believe that the vehicle is moved at 11:04. We don't know what time this is occurring. We do know that the vehicle perhaps was moved from the Burla, but we don't know the sequence of events. As you recall, and you will have the evidence, there was various blue lines showing triangles, and we heard that through the positioning of the GPS, you have movement, even if a vehicle is in one place. We don't have specific times, and we really don't know the order of how things occurred. We would urge you to believe and to consider that common sense would dictate that this was when Devyn left the residence at 2:04. There's going to be a close-up here. You'll have a computer screen. Zoom in on it. Here you see the interior of the vehicle. You see Devyn getting in. You see a bag on the passenger seat. And she leaves. Please pay close attention. And again, not that I'm trying to tell you to do, but we've had this case for a much longer time than you have. Look at the video evidence from 6505 Taylor Creek. Detective Lippisch testified several times that he could only speak to items that he can't restore, but he was happy to testify concerning other detectives who went unnamed that collected this evidence. It's clear from the testimony of a forensic examiner, O'Brien, whose credentials and whose testimony went unchallenged that we presented to you today. He testified that one of the three videos was compiled from a series of screenshots, which the Ring camera is set to capture by default in the absence of video activity. Where are the other screenshots? They only gave us 3. I'm not gonna stand here and point the finger and say that this was done in bad faith. It was done out of sloppiness. Why weren't subpoenas issued? Why don't we get the complete record? This woman is on trial for murder. We heard nothing concerning them going to the third-party providers, Ring, Google, other parties. No, they're relying upon the cooperation of neighbors who are living their own lives and who very well may be indifferent to the gravity of this situation. Didn't give us the full picture. And that was the video that had constant, I mean, you got a good scene into or a good view of the residence. It's incomplete. We just have these three. And again, this is at the new residence where it's been referred to. Porcupine here, we've got the truck. You know, there's been an argument made that Devyn had to have been in the home the whole time. Based on what? Because the entrance to the neighborhood with the continuous camera doesn't show a vehicle. There's other ways to leave that residence. There's a walkway next to one house away. There's over the fence. This is something that's been discarded by the state, but again, I would submit to you that it goes to what Devyn is thinking. It goes to her innocence. She starts trying to contact Jonathan on the morning of the 7th, starting about 4 a.m. She'd left him. She'd left him at the residence. The plan was that they were going to take the girls to school that morning, and we have evidence, and you've heard uncontradicted evidence that that's what she did. The message she leaves him is concerning the girls' school supplies. She's letting him know that their daughter was sick, because we know that she's at that pharmacy, and it's a 24-hour pharmacy at 2:28 a.m. That's what went on. She hadn't killed him and decapitated him. She was worried about getting her daughters to school that morning. She sends messages of concern when he doesn't respond. The state claims, and again, this is where common sense comes into question. The state claims that Devyn was answering Jonathan's phone from the house the morning of 8/7/2023. You heard the argument concerning the notifications. We did hear from Detective Skinner that they didn't put it on airplane mode. Those notifications wouldn't have shown up. That evidence, like so many other pieces of evidence, were mishandled. But the state's going to have you believe that she purposely took the phone from Paladera to Porcupine Rim and leave it out on the driveway, and at the same time be calling it and answering it and leaving it on the driveway. That flies in the face of common sense. She took it and left it there, and then is answering it and calling it to provide some sort of an alibi. She's lucky that in this very slipshod investigation that she has as much evidence that she does to present to you that she didn't commit this crime. Crime scene, the footprints. There are footprints in the backyard. And we have, and I'll show you the photos, we marked them and had them admitted. We have this, the Henderson Police Department documenting these footprints, but then trying to basically throw shade on that, saying, well, they could have been there for some time. They weren't important. When you look at the photo, you can see that they're fresh. They wanted to argue that they're male or female. They didn't do any follow-up. There was no footprint comparisons to anybody's shoes in this case, much less Devyn's. You recall Yoko's testimony, there were 4 dogs in the backyard. If that footprint had been there for very long, common sense would dictate that the dogs would have walked through it. They would have been sullied. They weren't. They were fresh. Again, they were not analyzed or tested. And there it is. And Detective Ozawa just kind of discounted that and said, well, we don't know how long they were there, but apparently no one really looked at Yoko's testimony and Yoko's statements. 4 dogs were out there. for most of the night. This was a big point of contention. And again, these aren't red herrings. These go right to the very heart of the case. There was no blood cast off in the bedroom. In spite of evidence, uncontroverted evidence, the mechanical powered saw was being used to decapitate Jonathan. You recall, Coroner Yagi went so far as to try and compare a beheading by a mechanical tool there at a crime scene, and Dr. Sims took issue with this. She tried to compare that. These crime scene analysts tried to compare that to the dismemberment of a body under controlled conditions by specialized tools in the morgue, bodies that have been refrigerated. But nonetheless, she testified that they still wear protective goggles and aprons to protect themselves from this cast-off. Luminol, we heard no testimony whatsoever that luminol was used by the crime scene analysts. That would show indications of blood or attempts to wipe it up. Nothing. What's clear, and it was kind of laborious at the beginning of this trial, was Yoko's testimony, because her testimony was so crucial to the timing of this case. There were some difficulties with the interpreter. However, I'd submit to you, she speaks pretty good English. It was important to memorialize what she told officers the morning of in the 40-minute conversation, as well as what she testified to the grand jury. She testified that she saw Devyn at 1 a.m. and Devyn didn't have any blood on her. If you follow the state's timeline, it's sometime around then, and it's unclear, she's involved in this murder and decapitation. She stated that no gloves were worn by Devyn when she met her at 1 a.m. And you recall the testimony concerning the dishes and the alcohol bottles. And there were some issues concerning Jonathan's level of drinking. 15 minutes. She testified that the light was on. That brings to question the veracity and the reliability of the statements through her multiple interviews that Devyn made to the detectives. There was no blood visible on Devyn's shirt at the CVS drive-thru pharmacy. And thank God that she stopped there. Because again, we have real time. We have real evidence that shows that she didn't commit this crime and not some detective's opinion. There's another issue concerning this, the mixture of ammonia, bleach, the stench. Remember that? We heard that the first responders, that they said that the smell got worse the longer they were there. If we're to believe the state's timeline, this is smoking for 9 hours. That flies in the face of common sense. Ammonia evaporates quickly. And again, your common experiences. The state never, and one of you posed a question to Dr. Sims. Again, it's the state and the state alone that bears this burden. Where was the expert to talk about that? That was important. This case was out of the ordinary. It's clearly gruesome, but because it's gruesome doesn't make that woman guilty. It isn't evidence that she committed this crime. Here we are, 2:27 in the 24-hour pharmacy, and you'll have this. Look at her. She's sipping her water. Apparently this is after she's murdered a man and decapitated him. She's reaching out of the vehicle. No marks, no blood, nothing. And Sims testified that this would have been messy. she's just decapitated, she's murdered and decapitated Jonathan, and she's making sure that she picks up her daughter's medications on her way home. There was a very good question that was asked concerning, was there any stops? There wasn't. There were no, her vehicle didn't go to any isolated areas, to any trash bins. There's been times when I've gone through moves and I've gone behind the Vons and dumped trash out in their dumpsters. There's no evidence of that because it didn't happen. You know, the state will have you believe that there's this bucket of blood that's the reciprocal of all this blood that's squirting out when she's sawing his head off. What did she do with that? Yes, she did. The car didn't go anywhere. She went home. There's no rags. There's nothing in that vehicle. We do know that they recovered, and this is based in part of the video that we saw from the terrible herbs. You know, again, I don't want to point fingers, but her life is on the line. They didn't do their job. There was no direction of what to get and when to get it. We heard from Detective Lippisch that he got that video evidencing her clothes around the 11th of August. That warrant was served on the 7th. We didn't hear much about what they picked up on the 15th. They made a big deal about the shoes, the swoosh, but we showed you evidence in the photographs, and it's in evidence of the black shoes with the white soles. I mean, she gets arrested on the 15th. Game over. It's done. According to Yoko, and this is important, and I read the statement to her because it was so dispositive. She said Jonathan's room was a mess. And there's this kind of a feigning of not understanding. And I said, man, these are your own words. And I read her own words to her. During her initial interview, she stated that there were 2 chairs flipped upside down. That's evidence of a struggle. But then we don't see that on the body cam. What happened? We don't have that many diagrams of the crime scene. But when she spoke to police and thank goodness it was recorded, she talked about 2 chairs being flipped upside down. And obviously her memory would have been far better at that time than it would be now. But again, you know, there were some questions by the state. You were traumatized, things were terrible. I'm sure it was. But the veracity of the statements and the accuracy of the statements shine through. She was trying to help law enforcement and give them clues concerning who committed this murder. There's no reference made in Devyn's statements about chairs, about a struggle. Jonathan was killed after she left. It's kind of weird is that there were 2 belts tied together on the ground near the bed. There's been no explanation by the state, and we can't give you one, but something's going on in here. Crime scene GPS. Devyn's car is trackable. We know that she didn't stop. You know, she was there that night, and that's why she was charged. Her phone is trackable clearly. No deviation is made to some remote location. She went to the pharmacy and went home. There's no anomalous stops, and this was brought up by you. She gets the medication and gets home because her girls have school early the next morning. The timing, and this is obviously where timing is very, very important. We do know when they leave the terrible herbs. You see 22:11. We know that when they got home, they spoke to Yoko. We don't know how long they spoke, but do you recall Yoko's testimony? Her words were, it was a very good day. She'd known for months that they were getting together. They were trying to unite the family. And you know what? No union is perfect. Hey, we all know that. There are ups and downs, but she and Jonathan had a union. You know, the state in their first closing, they're going to get a second one, try and paint her as this devious, manipulative, conniving temptress. But think about that, the flip side, a 19-year-old. You know, when we talk about motive, what drives a person to murder, is it not passion of a young man? His first love that's coming to an end when dad's coming in and moving him, the dad that he said was never there for him. You know, it's kind of an archetype, you know, the father that's killed by his son. I mean, it's in, I believe it's Isaiah 38:18. We've got these Greek stories of it, Oedipus. I mean, there's various variations of that, but it's an archetype. Saturn. It's known, and it's as old as the human condition. Fathers are sometimes killed by their sons, and that's why we wanted to underscore, and we spent a great deal of time in our opening statement because we didn't know where it was going to go with Devyn, but we knew that they'd had a relationship that had been kept clandestine. Devyn covered for Devyn, and Devyn covered for Devyn. This is important. I would submit to you that this is a more accurate and a more reasonable timeline. Yoko was awake. 10:58. There's a 44-second call to Devyn from her phone. You recall, we get the text, and you want to talk about an alibi type text, putting the girls to sleep. It's 10:36. I'm going to bed. That has been refuted by facts. He testified here that, well, maybe he woke up at 2. That was the first time. Previously, he had testified before a grand jury that he got home, put the girls to bed, went to sleep, woke up, Devyn was there. That is a lie. Why would he lie? What motivation would he have to lie? He's a fairly smart young man. I mean, he was kind of catatonic here, and understandably so in the witness chair. But again, we need to look at motivations, because motivations, they author actions. At any rate, we knew the night before that Devyn had been there late with Jonathan. But after we were to believe that he's asleep at 10:36, we've got a 44-second call from Devyn's phone to Devyn. 8 minutes pass. 11:05, we get that 10-second burla in the Nissan Armada. It may have been moved. You're to determine that, because I'll tell you, we really don't know. The evidence is not reliable. Whether it pulled up and stopped, or what we saw there was Devyn leading, we don't know. States to provide that to you, the timeline. They haven't done that due to this slipping through the cracks in the slipshod investigative work. Now, an hour and 55 minutes pass. Yoko is awake. There's no suspicious noises or activities. And we have a 15-minute timeline. Because you recall, Yoko's into time. She corrected me. She looks at the clock. They talked for 15 minutes. And it was kind of like pulling teeth. She admitted about the dishes and the alcohol. They talked for 15 minutes. We're to believe that, and again, this goes to Devyn's statement and reliability after she's subjected to interview after interview. Yoko says the lights are on. The state would have you believe, apparently, that Jonathan's dead. She struck him in the head and he's dead. Meanwhile, she has this 15-minute communication. Again, no blood, gloves, chemical smell, any of that on Devyn. At 1:15, Yoko goes back upstairs. And you recall yesterday, that was kind of rebutted Lena's testimony. They kept hitting her with that hour and 4 minutes. That's why you don't talk to the police. That's why you have a right to remain silent. One thing that we have learned is don't talk to the cops, especially if you're the target, because they're going to take what you say and they're going to twist it. Yoko was equivocal in her testimony when she testified before us. This time, and she's just testified once before a grand jury, she's equivocal. She was awake the whole time. She looked at YouTube. She went to sleep. It's equivocal. But at 2 a.m., for the first time here, she says she hears the bang. I think we had the prosecutor bang his hand. She's never talked about that before. But still, may have happened. 2:04, Devyn's leaving. Maybe it was the door closing. We don't know. That's her testimony. But you have to evaluate her testimony. But again, this is really kind of shedding light on this timeline. She previously testified that she heard dogs at 3 a.m. She brought it up 3 times during her police interview. Apparently she felt it was noteworthy, and she testified to that September 14th before the grand jury. Yeah, the dogs are barking. It's 3 a.m. Someone's put the dogs outside. The facts, taken as a whole, and not this little piece here and this little piece there, show that this murder, and it's silly to say a murder didn't occur. Obviously it did. It happened after Devyn left. The facts, taken as a whole, bear that out. Again, you've heard, and it's uncontroverted, Devyn leaves at 2:04. What's of note is that presumably Yoko went to sleep after she went upstairs. Part of her testimony previously is that she was awake during this whole time. Where's the testimony of a mechanically powered saw? It happened. It's more reasonable to believe that that happened after 3 a.m. We don't know when it happened. She didn't do it. The dogs were outside barking. Somebody's in that house. Somebody has killed Jonathan, and somebody is cutting his head off. Again, what kind of passion does that take? Not an on-again, off-again relationship that Devyn had with him. It's a person that's enraged. Well, watch the TV, the police stories. They talk about stabbings are personal versus a shooting. What's it going to take to cut a head off? And what kind of anger and what kind of resentment is that going to cause for someone to do that? There's been a great deal of argument made and points attempted to be scored that Devyn did that because she'd do anything to get her kids. It was uncontroverted that regardless of what was going on with family workers, she had those girls from May 27th on. She had them all summer. And when we talk about motivations, we know that Jonathan was moving in. There was talk of marriage. And, they want you to believe that the rings weren't there. Look at this investigation. Look at the photographs of the trash cans. I believe one was Exhibit 68. We have no evidence and nothing to show that they emptied that. And why would they take a picture or preserve a ring? They didn't preserve anything else in those trash cans. It's easy for them to come in years later and say, I didn't see a ring. There was no notations, and they go through hundreds of crime scenes. When they were there, when Miss Wilson was there, they were looking for weapons. They were looking for evidence of a murder. They weren't looking for rings, and they're asking you to convict her on this shoddy police work and have you believe that Devyn's lying about these rings when there is no indication that they were looking for rings. This is the state's only evidence that she committed this murder and this decapitation, because you got to put them together. Common sense would dictate whoever did one did the other. The interviews of Devyn Michaels. I'm going to focus on the third interview.
And then, have you guys ever had a sexual relationship? Yeah, we had. Okay. But it's not there now? No, I can't even have sex now.
This is important. This isn't something that Devyn is making up. You have her medical records. The time, 12/5/22, vaginal hysterectomy. She's had surgery. She's not having sex. She's telling the detectives the truth.
We've got that. Is there any reason why Jocelyn or anything DNA related would be in your vehicle? Because that goes back to our station, our CSAs are gonna thoroughly look for everything in that vehicle.
I couldn't tell you if he was bleeding from when he was doing the thing. He helped load up the truck, so if he was bleeding, it might be
Before your
my Armada. Like he was putting the things in the car, like anything else
Sure,
he had.
there's gonna be obvious areas where blood doesn't belong even if you're loading. So I'm just asking you directly, because if we do find any DNA evidence in that vehicle, obviously we wanna make sure we asked you if there would be a reason.
No, the only thing I knew he said was his hand that he hit on the table. That's the only time he ever said he was bleeding, and he said it got a pretty good gash.
But you didn't see that.
No, I did not, so I can't really speak on it. But he was still loading everything up, so I don't think it was really bothering him that much.
This is the inside of the Armada. With the testimony from Ozawa, it appeared the vehicle had just been washed. That's been disproven. The burla shows that that didn't happen. The location coordinates show that that didn't happen. Look at the inside of this vehicle. I know my partner, Mr. Horvath, had asked Detective Spangler, well, was it very clean inside? I think he made a reference to teenage kids, something along those lines. This isn't well kept. I've seen much worse, but it's not well kept. The important point is we're to believe that there's buckets of blood in here. There's bloody rags. There's a head, a murder weapon, a saw. There's nothing in there. They sealed this vehicle and they took it off. If you're to believe that she murdered and decapitated Jonathan, you're to believe, common sense would dictate that there's going to be some indicia of a crime in here. You're taking buckets of blood because they weren't at that residence. This made reference, and again, nobody understood the significance at the time. Miss Miriam didn't, but there's the table that she talked about. It was a moving day. Injuries do happen. We're to believe, again, Dr. Yagi's, the reliability of her testimony. She said there was no bleeding injuries. Well, we've got an injury right there. Whether it's bleeding or not, we don't know. But that's sign of an injury. And remember, this is the same doctor, the same coroner that said John didn't have tattoos on his arms. Big point was made about the telephone. And we're to believe that Devyn is so sophisticated and so cool and so cunning and so informed that she can murder this guy, decapitate him, not leave any evidence, and then drop his phone in the driveway. A more reasonable explanation, it's tired. She's got girls that are going to school in the morning. She's been carrying things, it's late. She obviously brought the phone, whether it was knowing or not, we don't know. It appeared that it had fallen on the side. She tries to give an explanation. You recall about the cigarette butts? She didn't know the phone was there. That's why she was calling the phone, following up with Jonathan. She knew he wasn't dead because she didn't kill him. Another thing that was a big point of contention, sometimes little things can have very large implications. Remember the issue about the blood on the screen? Papakostas, the DNA expert, testified that she couldn't confirm that it was blood. There was a presumptive test, but the confirmatory test, and some of you are far more knowledgeable than I am, it was not. She couldn't confirm that it was blood. So then the state recalls crime scene analyst Miriam to apparently discredit their DNA expert in reference to the blood. And this is the entity that's charged with proving this case beyond a reasonable doubt. They're calling a crime scene analyst on a presumptive test. to discredit the DNA expert who gave testimony, uncontroverted testimony, concerning the lack of a confirmation for this blood. We know that John's DNA is on the phone. I would submit that it is somewhat significant in determining whether the state's proven his case. Devyn's isn't. It was handled. Maybe there weren't epithelial cells left from Devyn. Clearly, Devyn took the phone, knowing or not, and I would submit to you that given the circumstances and the chaos of a move, she didn't know she had the phone. It's not evidence that she killed him. Just like the key, it's not evidence that she killed him or the wallet. She's going to go through all this work to leave this, this crime scene spotless or clean and not leave anything behind, no blood, nothing in her car. That she's going to drop the phone and then make calls to it. This is what the state is relying upon, this interview. And you recall the tenor of this interview? Please don't just look at one part or another. Listen to the whole thing. The power dynamic. You've got two large men. You've got a woman who they had said, we Mirandized you earlier today. You have to ask yourself what went on. What happened before this interview?
John? That's the John said when last saw him? Yeah, but he had his boxers on. No, he had his boxers on. I don't know, he had his boxers on. His boxers were black boxer briefs. He had boxer briefs on. That's what I'm talking about. The shoes getting ripped. Keep looking at that. Take another look at this.
This was into the interview, and it was a fairly lengthy interview. She'd had multiple interviews before. We heard in this interview that they had told her previously that day about the decapitation. So there's more going on. She knew. It's at 16:01, and it's interesting that the state showed you the exhibit, the one that she supposedly wrote. When you look at the original exhibit, it says handwritten by Devyn Michaels. It wasn't. She drew a line, and that's significant. It was Detective Christopher that wrote that. And again, this is in the crises, in the crucible of a very confrontational interview. She didn't author that. And I'm assuming that Mr. Giordani is going to stand up when I sit down because he gets the last word. He's going to say that somehow, how could she have known that? She hadn't been shown the photos. This gentleman had seen the photos and he filled in those details. And she's sitting there having been arrested previous to this interview and facing the horror of being accused of a crime, a murder that she didn't commit. Here's the boxers. Why lie? Why lie? When she left, he was wearing those boxer shorts. She was consistent in that. Why choose that hill to die on? She was telling the truth.
Have you had moments in the past where you have been stuff where
Yes.
That
Yes, there's things in my past where I cannot remember. And yes, I have talked to my doctor about it. Yes, they're trying to figure out what's going on with me. Yes.
Okay, you don't have to tell me if you don't want to, but what is wrong with you that you say that?
I don't know. They're testing me now. I think yesterday, for whatever reason, my brain tingles and I black out. And I literally have it on documentation from the doctor, and they're trying to figure out what's going on with me.
This interview was on August 15th of 2023. This condition that she's talking about, it's documented 6/7/2023. New patient established our patient she feels like tingling, vibrating in the back of head, comes and goes, denies headache, has dizziness. This isn't some ploy. I mean, she's in this high pressure, confrontational interview, and she's trying to give as truthful information as possible. She's had some problems. This is some defense where, oh, she blacked out and didn't know what she did. She didn't commit this crime. She didn't commit this decapitation. She's had some issues that she's been trying to address. And again, she's being truthful to these detectives. It's confirmed.
Absolutely. And your brother definitely did you because you can't even have the audacity to give it over. Shame on you. That's terrible. Get out of here! Kill me up there! Oh, so there's there's some anger now, huh? I told you from the beginning I didn't. Is that how you feel against him? No! It's not against him.
She's pushing back. She's been interviewed over and over again. She's telling him, I've told you I haven't done this. What we're dealing with now is a woman that's denying that she committed this murder. You know, it'll be up for you to determine whether she hit him in the head when he was grabbing her leg. She was consistent that he was alive. He was breathing. There's no evidence that she hit him in the head. And again, given this, we know that when people are confronted, they'll try and give something to appease the other party, this power dynamic. She was trying to give. In this interview, you'll read, they threaten. I mean, what you do here is going to determine what happens with you and your daughters. She gives a little, but then snaps back and says, I didn't do this. And she's expecting, through all these interviews, for them to pick this up and do their job. But they'd already made their minds up. You heard from Lanai yesterday. In their minds, she was guilty. That's it. And we're dealing with this investigation that you heard from Sean O'Brien, 3%. We're dealing with 3% of the information that was available on those devices. But still, in that 3%, we've been piecing together what really happened. We do know, and it's clear, incomplete Celebrite reader files. Critical database files are missing from the phones. Now, years later, we're trying to piece together a defense to defend a woman that didn't commit this murder. There's artifacts which would indicate a need for further investigation. And Sean O'Brien testified that generally, as he's been a forensic analyst, he's been involved in law enforcement. There's supposed to be this back and forth. Hey, get us this. You know, as this investigation develops, we need more information. There was no indication that that occurred in this case. She's at the house. She's the low-hanging fruit. She's guilty. The end. All investigation stopped. Image of Devyn and Devyn. And again, we would like to have more, but we can show you this image. Now, all the images that are available on a cell phone, I think I probably have 4,000. You know, it's going to be the state's position. Well, this is just randomly popping up. Devyn had said that he was asleep, or Devyn had said that he was asleep at this time. He testified under oath. He lied under oath. Look, there's a Discord chat application, 231. This is telling. You know, the state can play 3 phone calls from the girls who are adorable. Those were all after 11 o'clock. We have no proof where Devyn is. But we have 2 indications of 2 artifacts at 2:12 a.m. and 2:31 a.m. that he's up and he is engaged. There's a deliberately deleted file. This is the image, 2:12:38 a.m. This is after there's been 3 calls from the home phone that night to Devyn. 3 of them were the girls. What about the other 8? But of all images, at 2:12:38 a.m., this is being looked at. on Devyn's phone. Game box. Again, and this is important, this was not preserved, this was overlooked. There's photos, he was a gamer, they had issues. Gamers are on their game platforms and they talk to other people. We have a Discord file, there's a remnant of that. He's using that at 2:31 a.m. in the morning. He's up. He didn't drive his car over there, and again, I can't tell you for certain if he committed this murder. But he could have easily gotten out of the house, and he's not going to walk. He's going to talk to a fellow gamer. We now know that he's up, and he's lied. He's lied under oath. What does he have to lose? I mean, he was able to avoid the motives through the course of this investigation concerning getting kicked out of his house and losing his wife, who he, based upon all the photos, and we didn't have to go through those, you saw them, he was in love with her. But we do, in this 3% that's available to us, we can show you that he was up. Not one indication, but two. And given the nature of that photograph, the multiple phone calls that were made earlier, and now we have this Discord, we have a remnant that he's on an app. It's not too hard to imagine that he went there. Those are the facts. And the timelines, you recall the detectives that for the Henderson Police Department that testified, they set out timelines, but they didn't do a more in-depth analysis. And this is what our analysis was only 3%. We were able to show he was awake. This was deleted, it's there. I'm not saying that was that night, but that's something that should be taken into account, headed there now. He's there in this area, and you'll have the exhibit. He's next to a remote area. Don't know if he had a job there or not. This is the morning after 8/7/10/25. You know, when detectives interviewed him, he'd said, hey, I've been drinking. We don't know if he'd been drinking all night. We don't. He's a drinker. He's in a remote area where, and obviously there's been no testimony, there's been no investigation in those wash areas. We know he was over there. We know he was up. We know that he was looking at a picture of him and Devyn. You know, it's, you see on the crime TV shows about motive, means, and opportunity. He had all three. He had the motive. He had the means. He didn't walk there, but he was talking to somebody. Clearly, he had the opportunity given the timeline. But again, I'm not going to stand before you and say he did it. We don't know. She didn't. These were texts that were between him and his father. You have nothing to tell me, WTH or TF. I thought you were my seed. If what I can know, I can't fuck with you. Boy, that's true. Devil shit. It was clear, and he tried to smooth things over through the course of his testimony, but Devyn did not like his dad. He had an affair with his dad's girlfriend. You know, these things don't reflect too good on her, okay? They reflect poorly on Devyn. But Devyn's not here for good moral character. You can despise the choices that she made, but you can't convict her for murder, for a murder that she didn't commit. This is their home. The home that he's being kicked out of. Again, there's the walkway down the side. There's a way to get out the back. There's no cameras that were pulled on Rebecca. We don't know. The police did a slipshod investigation. We can't show you him walking away. They didn't collect the evidence, but the motive would point to Devyn. This gun, there was an issue made concerning that. That gun was looked at the afternoon of, I'm sorry, that's another gun. There's guns in his possession. We don't know if that person was shot or not. Jonathan was. The swords, again, we're not trying to throw these things out, aha, but this just shows a conscious indifference on the part of law enforcement in collecting evidence that could exculpate her. Their minds were made up. She was guilty. There's so much evidence here that you can go through and look. Again, thank you for your patience. Thank you for your attentiveness. You know, this is the last chance that we'll have to speak. There's going to be things that I have overlooked, things that I missed. Don't hold them against her. Hold it against me. You remember the movie 12 Angry Men? The jury went through and exonerated that young man. I'm going to ask you to do that, to look at the facts. You may not be comfortable with a verdict of not guilty. She's done some bad things. She didn't commit this murder. She didn't kill him and cut his head off, because those two things are combined. Common sense would dictate they are. She's not guilty of this charge. Thank you.
Are you prepared to give your rebuttal argument? Ladies and gentlemen, because the state has the burden of proof, they are allowed to open and close the closing argument.
Let's talk about reality now. I want to commend my colleagues over here who represented Ms. Michaels first, because they've done an exceptional job. And Ms. Michaels is entitled to a fair trial, like we talked about in jury selection. They've done a good job of coming through and poking as many holes as they can in the evidence, and I commend them on that. But make absolutely no mistake, that woman is guilty as sin. That family deserves justice. Those girls deserve justice. Do not take this lightly just because a real polished defense attorney gets up here and spins a yarn for you. Do not take this lightly. Those people deserve justice. If I were to tell you that a defendant confessed to a crime, described how she did it, everything she said matches the crime scene, except for the part where she minimizes or potentially blacks out the aftermath, you would say, well, that's pretty damn obvious. And some of you were probably sitting there when we played that confession the other day, yesterday maybe it was, or the day before, and go, why didn't you guys play this 2 weeks ago? We could have kind of sped this process up. Maybe you're thinking that. Because we have to show you that the cops did their job and she is overwhelmingly guilty. We wouldn't be doing justice to that family right there if we just played that confession and walked. And we didn't. We put 2 weeks worth of evidence up here to show you Devyn sure didn't do it and she did. There is no reasonable doubt in this case whatsoever. And I want to address kind of an elephant in the room. You know, Mr. Draskovich just got up here at the very end and he told you those two things, common sense dictates those two things go together. And I kind of agree with that, right? The person who killed him probably decapitated. But make no mistake, she's not on trial for decapitation. She's on trial for murder. She told you she did the murder. Now, she minimized it. She told the detectives that she hit him over the head and he was still breathing. Of course she did. But she admitted to the act that caused his death. Are we really, as reasonable men and women, going to believe this was a fatty liver or a marijuana overdose? Are you kidding me? That guy was murdered and then his head was chopped off. And here's the elephant in the room. I don't care if you for some reason believe Devyn somehow snuck out of his home like a ninja, crossed town, and cleaned up the job. I don't care. She's not charged with decapitation. Look at the pleading document. She's charged with killing John. That is it. That is your job. Did she kill him or not? And the answer is absolutely yes. I need to show you a couple instructions because they're important. Bear with me. I know you're probably tired because we all are. But this is too important to just gloss over. This is the beyond reasonable doubt instruction. Mr. Draskovich addressed it. I want to tie this into another instruction. Doubt to be reasonable must be actual, not mere possibility or speculation. Instruction 31, direct versus circumstantial evidence. The top part is really important. I'm going to address that in a minute, but this one down here that's underlined is also important. You must not speculate to be true any insinuations suggested by a question asked the witness. So a question is not evidence and may be considered only as it supplies meaning to the answer. So everything Mr. Draskovic said through the course of this trial was a question, right? It was a question. That ain't evidence. So you tell me what piece of evidence, what single piece of evidence suggests Devyn did this? Not one. Not a one. And when you start accusing an innocent guy of murder, Devyn, you got to think about this for a second. That young man was taken advantage of. And like Miss Griffith said, it's not like he wasn't enjoying it and liking it and into it. No doubt. Mr. Draskovic in his opening statements suggested that Miss Michaels has a history in the adult film industry. Did you ever hear me ask that? No. Did you ever hear me or her mention that? No. Because Mr. Draskovic is right. She's not on trial for having a past. Doesn't matter. The only reason that does matter is because it dictates that relationship with Devyn a little bit, colors it. She is an experienced woman, much older than Devyn. He's a young knucklehead, and I would submit to you that when you heard from him, no disrespect, but that guy's not a criminal mastermind. He's not somebody who snuck out the back of the house, evaded all cameras, he left his phone behind because he was thinking ahead to what he was going to do, somehow made it all the way across town, even though he didn't have his phone to contact anyone. There's no Uber notifications or pickups or anything suggested. There's no calls, no text, nothing after 11 o'clock. So who did he contact and when? There's no evidence that Devyn was involved in this. None. There's actually evidence to clearly refute it. You heard those voicemails, and we can agree those little girls they're precious, they're adorable. Those voicemails eliminate this alternative suspect, which I will refer to as a scapegoat, because that's what's happening to him. He's being scapegoated, and it's not right. Those little girls said on those voicemails what Devyn was doing. He was knocked out, probably passed out, if we're being honest. And you didn't hear any other voicemails afterwards. You saw more calls from the landline. If Devyn had got up and snuck out, because we know the one little girl is awake and panicking and like scared and where's mommy? She should have been home a long time ago. Where's mommy? Wouldn't there be another voicemail where they're calling going, Devyn left us? Like, really, mom, where are you? Of course there would. Of course there would be. And there isn't. That's because Devyn was home. And you know that because he texted and he said, I'm going to sleep. He's no criminal mastermind. His phone is at home. There's no evidence his vehicle's left. There is zero evidence that Devyn is involved in any way. Zero. And so Mr. Draskovic brought up a good point with the instruction that Miss Michaels is the only one on trial. That's instruction number 36. I want you to think about this for a second before you let a guilty person walk. Okay, think about this. Imagine if I were to stand in front of a bunch of jurors and try to prove Devyn's guilt. Imagine that. That's not what we're doing here. That's not what this is about, but imagine that for a second. Can you think of a single piece of evidence I could, with a straight face, present to a jury and say Devyn did this? A single piece, other than speculation and really good questions by a really polished defense attorney? There is not a piece of evidence. I would be laughed out of the courtroom if I tried to prosecute Devyn for this homicide, because he didn't do it. He had no reason to do it. Go look at the text messages between him and his dad. We included a bunch of them. Did he Worship the guy? No. Did he hate him? Who cares? He didn't kill him. There's no evidence to suggest it. He says throughout the text messages to his dad, hey, what's up? You'll see it. There's like years of it. There's 2 years of it. And then those texts that Mr. Draskovich just showed you with the devil shit, I would submit that's a reasonable thing when you learn that your son is having sex with your ex or is married to her. That's reasonable. But then, you know, they left out a text that's right after that where dad is reaching out to Devyn like months later saying, hey, this wasn't some big, you know, homicidal relationship between dad and son. Now, when you're thinking about motive like that, you've got to think about this defendant. She told you in that interview with Detective Lina and Christopher why she did it. She said it clear as day. I didn't think he was really going to move in. The walls were closing in on her, and she made a real horrible decision. A real bad decision. She said that she very specifically got up. He was down on the bed getting a massage. Got up because she was a little pissed off, I think were her words. Maybe don't quote me on that. Something like that. Walked across the room, grabbed this heavy blunt object, bashed him over the head, and he went limp. That's a confession to homicide. Okay. On top of that, she told a DFS worker, when you're thinking about motive, in the context of losing her children and homicide specifically, which she brought up, she said she had to do it. She had to do it because that's how she felt. And I'm going to answer or try to answer a couple of unanswered questions for you. We all get this evidence before trial. You know, we're all obviously somewhat prepared. I'm not like tooting our horns, but we're prepared. We know the evidence when we come into this case. There were clearly going to be unanswered questions in this case, right? There's a missing head. There's a missing murder weapon. There's missing implements, no doubt. But think big picture, forest from the trees. Think about reality, right? Criminals ditch murder weapons all the time. Criminals try to cover up what they've done all the time. Just because she ditched the head and therefore the doctors can't confidently say what injury did it, does that mean she gets a reward? Like, does she get to benefit from the actions she took to cover up? Of course not. Does that mean we can't convict her of murder? Of course not. And that is why I asked Dr. Sims those questions earlier. I didn't challenge his credentials. Like I've dealt with him on cases before, as you probably noticed, and he's a smart enough guy. He's very educated, but he's not disputing that a blunt blow could kill a man, right? He is saying exactly what Dr. Yagi said, the decapitation is post-mortem. And you know what he didn't say, which should be very notable for you? That there were other bleeding injuries on the body, including the hand, right? Because there weren't. He didn't say that because there weren't any bleeding injuries to the body except for up here. And that's how we know she did it. That droplet of blood, you can go back and forth about the DNA analyst not confirming it's blood. Well, DNA analysts actually look at DNA profiles. And DNA is in every single cell of your body, including your blood. And so, no, a DNA analyst is not going to come in here and say, John's blood was on the phone. She's going to say, John's DNA was on the phone because she's a DNA analyst. That's what that is. John's droplet of blood being on that phone convicts the defendant even without her confession. Set those, two confessions actually, because she told the DFS worker she had to do it. But set those aside for a minute. There are no bleeding injuries on his body, except for up here. The phone left at 2:04 with a droplet of blood on it. That means the murder happened before 2:04. It had to. Nothing else would make sense. Nothing else would make sense. She, the defendant, traveled with that phone. Okay. So then you got this other big glaring unanswered question. How could someone be capable of doing that? That question, I can't answer. Okay. This is reality. It happened. I would submit to you that there is a chance that what she said about that hour and 4 minutes is true. Maybe our psychology major could talk about this. But I would submit to you that she may have been genuinely telling those detectives the truth, that she didn't remember chopping John's head off. Because this is beyond anyone's wildest dreams. Violent beyond all imagination. And there is a good chance she blocked it out. That doesn't mean that she walks out the door because she says she can't remember. It convicts her. There is no way she didn't do this. The evidence is absolutely overwhelming. And I need to address a few points because I just can't leave them unsaid, so please bear with me. Mr. Draskevich called into question Devier's testimony, and I want to bring this back for a minute. I think Devier is pretty well excluded. He walked into this courtroom, and I want you to remember that I asked him the question, did we bring you back? We didn't have to arrest you or anything. He came back willingly. He flew here, right? He brought his girlfriend, a little more age appropriate now. I guess he's learned his lesson, but walked in the courtroom willingly with that big old camera and all you strange faces to him. And he sat on this witness stand. He swore an oath to tell the truth. He got up here. He testified. He looked at his wife. He looked at all of you. He looked at me. He looked at the marshal with the gun and the badge. And he testified to the best of his ability. Now, I am not and will not endorse his character. I don't know the guy. I've met him a couple times because he's a witness. But you got to see him tell you the most intimate details of his life. And I asked him straight up for a reason, and I did this early in the trial because we just learned he's the defense. Put him up early, and I asked him, did you kill your dad? And he said no. Now, I know he's a stranger to you, and you can't just accept his word, but you've got to consider the circumstances and what it took for him to do that, to put himself in front of the world, and testify about all this. Willingly. He came back. We flew him back from California, and he came in here and he answered questions from a very skilled defense attorney for however long he was on the stand. Think back to that. Did that kid strike you as someone who snuck out of his home, plotted this big old thing, and killed his dad and then somehow covered it up? Or did he strike you as someone who got himself in a bad spot, his words, tried to fill some shoes he had no business filling, and made a series of mistakes in relationships? That his testimony from the stand has to be considered in context. And it's all corroborated. Now, I would submit to you that if he came up here and he said every word consistent, precise with everything he said over the last 2 years, then you might rightfully be a little suspicious. Like, oh, what is he studying for this? He had some inconsistencies. We don't shy away from that. He's not perfect. I asked him a question. I think the word I used was tumultuous, and he's like, what does that mean, sir? I don't know what that means. He's not a criminal mastermind. No disrespect to Devier, but he's not a criminal mastermind. He's a scapegoat. Don't let that happen. Need to address our pleading document. Mr. Draskevich brought this up, so I just have to address it. So you heard in the beyond a reasonable doubt instruction, it says the state must prove every element of the offense beyond a reasonable doubt. This is a legal pleading in Nevada. We are permitted to use unknown means and manner of death and unknown deadly weapon. This goes back to what I was saying earlier and what Ms. Griffith said about the deadly weapon instruction, where it says the state is not required to recover the deadly weapon used and present it in trial. There's a reason for that, because like I said earlier, this happens all the time. We don't reward criminals who are smart enough to get rid of the weapon. In addition, we don't reward criminals who are smart enough to get rid of the head after they crush it. That's why we are legally permitted to do this. Unknown object, unknown cause. Only question is it murder? Is it not? Did she do it? That's it. And it's absolutely first-degree murder. Mr. Draskevich brought up the robbery instruction, or the robbery pleading felony murder stuff. So I need to address that as well. Instruction 18. So when you first heard the charge read by the clerk, I'm sure you're like, what do you mean by robbery? This doesn't really, it doesn't really make sense. This doesn't really seem like a robbery, but bear with me a second. Taking property by means of force is a crime. The motive and reason behind it is separate. So yes, she took his wallet, his keys, and his social. We're not saying she took that for its value, right? It's not like the traditional robbery. The evidence says she took that for a reason, and it all comes down to one thing, and that's the girls. She took the Social Security card because she knew she had John out of the way, and she was going to make some changes and live the life that she wanted to live. So it is by law a robbery what she did. She killed someone, took their property, but we're not saying that she took the property to take the property. She took it because she wanted the girls and she wanted John out of her life. Instruction 29 is the motive instruction, or we call it the motive instruction. Motive is not an element of the offense or the crime charge. We're not ever required to prove motive, but you're permitted to use it to color kind of the facts of the case and determine whether there was a motive that could lead you to convicting on the crime. I've addressed motive a little bit. I just want to kind of wrap up that idea with this. John and Yoko and his side, they had a very different understanding of the moving situation than the defendant. Okay. She didn't want it to happen. Go look at the text, especially the ones that Miss Griffith showed in her closing. John is continually saying, I miss my girls. I miss my girls. I want you girls back. We need to put this family back together for the sake of the girls. And go look at the defendant's responses. Those ones that Miss Griffith showed. One was, I'm glad you appreciate what we had or how it was back then. And then that last text she put up where John is saying, we need to do this. We need to have them under the same roof. She doesn't respond. So go look at those when you're thinking about motive and tie it in with the last statement, the confession. There is no doubt that both sides have been aware of this potential for a move. What I would suggest to you, the evidence says, is that she didn't want John moving in, and John did. John wanted that. And it didn't become real until that night. And you know that because of the conversations with Devyn. He's still there. He's literally still living there. So if he was going to be moving out for John to move in, why isn't he moved out already? That's because no one expected John to try to make the move that night. And that's when the walls started closing in on her. She's thinking in her head, I want my girls back. I want my girls. That's it. This guy can't move into my house. That's not what I want. She wanted him out of the way. And she did what most reasonable people wouldn't do. She made the decision to take a blunt object and bash him in the head and kill him. I want to address a few things with the defense expert. Mr. Draskovich showed a couple of cameras and a couple of texts or activity, 212 and 230. One's a Discord, one's a photograph. Remember what their own expert said. That wasn't active activity. That could have been background activity. It could have been active. He can't say that. So whether Devyn woke up and activated his phone at 212 or 230, well, that just tells you he's still at home. And if it's just background activity, then who cares? Either way, it's not good for the defendant because it rules out Devyn. It's either with his phone or it's a nothing burger. Mr. Draskovich talked about the boxer shorts being off, and I already mentioned this. The defendant may very well have blocked out what she did after she killed him. And whether she took the boxers off or not doesn't really matter. It's probably very likely that he was naked when they were having this massage situation, but the boxers being on scene have no real import in this case. Mr. Draskovich talked about the CVS pickup, and I got to address that. So he said, and he showed you the video, there's no blood on the defendant in that drive-through. Now, we all watched it together. I don't see any blood from here up from what you can see. But do not forget, that shirt was never recovered. Neither were the shoes. Now, I'm not arguing to you or suggesting that I know what the defendant was wearing when she decapitated him. She could have been naked. She could have put John's shirt on. She could have changed her clothes, a number of things. But what I am telling you is that white shirt, from here up, maybe no blood on it, but it's never recovered. So we don't know if there's actual blood on it. Mr. Draskovich asked you a question, and I need to provide an answer. He said, is that a woman picking up this medication for her girls that's just done this, has the wherewithal to have just done this and go pick up medication? Yes. Yeah, that's reality. You heard the voicemails. The little girl was saying, you were going to get my medication. I'm not saying that the defendant is a bad mother. I will not say that. That ain't right. She took her children's father away. That's a bad thing she did. But did she care about her girls? Obviously. She stopped to get medication? Obviously. That doesn't exonerate her in any possible way. And neither does the post-homicide messages she sent to the victim's phone in the early morning hours. There is two very real explanations for those messages. Number one, you already know the extremes she went to cover up what she did to his head. She took it. That's extreme. She poured chemicals. She took a bunch of stuff from the scene, probably a towel too that was on top of him when she did the chopping. It's not outside the realm of possibility that she sent a text and made it look like she thought he was alive. That's certainly not unreasonable. The other explanation, as I've intimated to and pretty much said directly, is that she doesn't remember the real bad stuff. And legitimately, in her mind, he was still alive after she hit him. Because from then on, she blocked it out. So take those text messages for what they are. They're either she's alibying herself or covering up, or she genuinely doesn't remember the wet work. That's what that is. I have to mention the timing of the big confession, not the one to the DFS person, but the big confession. If this is all, there's no evidence to say this, but according to Mr. Draskovich, this is the defendant covering up for Devyn. If that is true, why does she confess after she's arrested? Right? She's already been arrested. Devyn's gotten away with it. Why does she confess after? Unless it's what happened. Mr. Draskovich showed a couple of videos, the small movement off screen. Remember the 2696 video? He showed the small movement off screen, and I believe he said, I'm sure it was just misspeaking, but I want to make sure it's clear, that was the 204 movement. That was not. That, according to the detective, that was the 11 p.m. movement when it goes off screen. And we know that for a fact because the Burla shows that exact movement at 11, or it's 11 or 11:04, I can't remember. The 204 footage on that video is when you can't see the car, it's already out of frame, but you can see the lights turn on and it leaves. And then that is also consistent with the Burla, so just needed to clarify that. I want to briefly address the girls. So you didn't hear from them in this trial. You can probably imagine why we wouldn't want to put them through anything more than what they've been through. I would just ask you to, that's my decision. I live with that decision to not call them. But I would submit to you that you heard everything you needed to hear from the girls in those voicemails. Devyn was home. Devyn was asleep. That's it. I need to briefly address this DNA stuff. So Mr. Draskovich made a point about the swords, the shower earlier in the trial, not an argument, but no blood being in the Nissan Armada and the footprints. And I just want to take this to its logical conclusion. So say we swab the swords and any one of the three's DNA is on it. What question does that answer for you that hasn't already been answered? If Devyn's DNA is on it, it's, well, he's handled the swords before. If the defendant's DNA is on the sword, it's, well, she lives in the home, of course her DNA is on the sword. If John's DNA is on the sword, it's, well, yeah, those are his swords and they were just moved from his house in the move, right? That doesn't answer an actual question in the case. DNA being in the shower. The defendant's been to the home many times. Have we found her DNA in the shower? What is that going to change for you? Absolutely not. No blood in the Nissan Armada. There is so much evidence of her covering up her acts at the crime scene. It should not be shocking to you that she could have wiped up some blood if there was any in the Nissan Armada. We know from the patterning at the scene, and you look at it for yourself, the blood on the ground, there is something she used to collect that head. There is a very straight, clear line on the border of that blood that suggests that something caught that head. And whatever that was, she took it with her. And when the defense says there's no stops along the way, we agree. But what they can't say, no one can say, is what she did when she got home. And you may remember that many times, different witnesses talked about it being trash day. It is not very hard to walk over 2 homes or 3 homes and dump a bag or basket or whatever it is in a trash can. And, you know, I got to address the investigation. Now, the detectives are all learning this stuff as the investigation goes along. They didn't have the burla and all that stuff when they go to Porcupine Rim on August 7th. Should they, because of they did know there was a head missing, should they have checked every trash can in the neighborhood? Yeah, probably. But they didn't. Okay. That doesn't mean that she didn't dump the head in the trash can. And that doesn't mean that this investigation gets the case thrown out or the defendant acquitted. These detectives actually did a pretty darn good job of follow-up investigation. When they suggested that she was the convenient, shortest distance between 2 lines, I disagree with that. Because remember, they found all that stuff in her home on August 7th. All that stuff, highly suspicious, blood on the phone. Did they arrest her then? No. Could they have? Yep. They didn't. They went and did mountains of follow-up investigation. All of that confirmed the suspicions. And then she confesses after she's arrested. It's too important to miss anything, so bear with me. I know it's getting late. Almost. Instruction number 35 is important. In arriving at a verdict in this case as to whether the defendant is guilty or not, the subject of penalty or punishment is not to be discussed or considered by you and should in no way influence your verdict. I want you to take that to heart. There's a phrase that's commonly thrown around in this courthouse that goes, admit what you can't deny, deny what you can't admit. I'll say it again. Admit what you can't deny, deny what you can't admit. I want you to think big picture, forest from the trees, just one more time. When there is a confession and DNA and mountains of phone evidence and video surveillance, what could the defense possibly do? She's covering up. The only thing that these very skilled defense attorneys could say in this case. We, luckily, have a mountain of evidence to disprove that. Admit what you can't deny, deny what you can't admit. They were painted into a corner. I commend them on their job, but what they did is they blamed an innocent person for a homicide he didn't commit. And I don't want you to blame the defendant, Ms. Michaels. I don't want you to judge her based on whatever her past. No one's asking you to do that. I also don't want you to take into account whether she's a good person or a bad person. She seems like she has some good qualities about her. Seems like she's trying, to be a good mom. You must not make this decision based on sympathy or a popularity contest. Mr. Draskovich, very likable. We're not here to do a popularity contest. This is real stuff. Okay? Real stuff. Do not think about whether you think she deserves a little leniency or redemption or this is a one-off. She lost it. None of that matters for you. That matters for the judge Judge Jones, who in her wisdom will sentence the defendant, not you. That is not your calculus. Your job is simple. Did the defendant do it or not? That's it. Please remember your oath to follow the law. It's my understanding the judge is going to let you stay a little bit after to deliberate tonight. I'm sure you might get instruction on that, but please don't take this lightly. This is important to more people than just the defendant. She is guilty beyond a reasonable doubt. Guilty of homicide. Thank you for your time and attention these 2 weeks. We really appreciate it.
I'm now going to ask the clerk to swear in the officers to take charge of the jury and the alternate jurors.
You do solemnly swear that you will keep this jury together in some private and convenient place, that you will not permit any person to speak to them, nor speak to them yourself, unless it be by order of the court, except to ask them whether they have agreed upon a verdict, and that you will return them into court when they have so agreed, so help you God.
All right, ladies and gentlemen of the jury, as you know, a criminal jury is composed of 12 members, and there are 14 of you who are here. That is because 2 of you will serve as our alternate jurors. This means you are not discharged from your service as a juror. Your service may still be needed if one of the other jurors is no longer able to participate in deliberations. In this case, our alternate jurors are juror number 13, Ms. Fitzpatrick. Jurors 1, may the record reflect we are outside the presence of our jury. Do you guys have any
Okay, guys, I'm going to go ahead and shut this down. We'll probably talk about the verdict tomorrow. I don't know if they're going to do a verdict tonight. You never know. If they do, I'll drop you guys a short or something, but we'll talk about it tomorrow live on Kathy's. And I'll film you guys an update just depending, but we've been live all day. So I'll give you an update as soon as it comes through. You guys have a good night. Bye, guys.